I don't want to disappoint anybody. I'm in fact not the Lord Hanson of Flint. It would not be a very convincing impersonation, not least because he's sitting next to me, but you will have the pleasure of hearing from him later on. My Lords, I beg to move that the bill be now read a second time. My Lords, this bill reflects not only our manifesto commitments, but it demonstrates the careful stocktake that we have made of important parts of our criminal justice system and our determination to improve the law where needed. It aims to keep citizens safer and more confident in the daily lives of all of us. And I am proud of our proposals. They are fair, proportionate, and they add to the law where needed. My Lords, as part of the bill's driving force, which is to make people and communities safer, it will build on what we have done already in the past year to rebuild neighbourhood policing. We are restoring public trust in the criminal justice system by the delivery of our Safer Streets mission, and we aim to halve, yes, halve, knife crime and violence against women and girls in a decade. For too long, neighbourhood policing has been neglected and downgraded. That has ended. We are already delivering on our commitments with 13,000 additional neighbourhood policing personnel by the end of the Parliament, backed by £200 million in new funding this year. Alongside this investment, the bill brings in new respect orders. These are to tackle persistent offenders who engage in the antisocial behaviour which blights our town centres. There are enhanced powers to tackle the antisocial use of cars and off-road bikes, and the police will now be able to seize these without first having to give a warning. My Lords, everyone should feel safe when they're at work, and this bill delivers stronger action to protect shop workers. Assaulting a shop worker will be a bespoke criminal offence with a presumption that the courts will, on conviction, impose a criminal behaviour order on offenders. We are also repealing the provision that treats low-value shop theft as a minor offence. Shoplifting is not minor, my Lords, and we are sending a clear message that all shop theft should be taken seriously. I know both these measures will be particularly welcomed by the Justice and Home Affairs Committee. Part 2 of the bill brings in Ronan's Law. We are clamping down on dangerous knives and weapons in our streets by introducing a duty on retailers to report bulk sales of knives and offensive weapons, increasing the maximum penalty for offences relating to the sale of knives to children, and strengthening the age verification requirements for the online sale and delivery of bladed products and crossbows. We are also delivering on our manifesto commitment to hold senior managers of online platforms personally liable for failure to take action to remove illegal content relating to knives and offensive weapons. I turn now, my Lords, to violence against women and children. The prevalence of violence and abuse against women and children defiles our society. We need more effective enforcement action against perpetrators and better protection for victims. To this end, the bill strengthens stalking protection orders and the management of registered sex offenders, including preventing them from changing their names on official identity documents where they pose a risk of sexual harm. The bill also creates a new offence of administering a harmful substance, including by spiking, to make it absolutely clear that such behaviour is illegal and to encourage victims to report such incidents. Recognising how dangerous online material is in perpetuating the growing epidemic of violence against women and girls, we will bring forward amendments in your Lordship's House to criminalise pornography that depicts acts of strangulation and suffocation. And may I take this opportunity to pay tribute to the noble lady Baroness Burton for her tireless work culminating in the Pornography Review, which recommended that action be taken in this area. Child sexual abuse and exploitation are amongst the most despicable crimes imaginable. It is estimated that 500,000 children every year experience some form of child sexual abuse. Alongside the new national inquiry recommended by the Noble Lady Baroness Casey, we are pleased to be pressing ahead with the implementation of some of the key recommendations of the independent inquiry into child sexual abuse. As a result, the bill creates a new duty to report child sexual abuse, backed up by strong criminal sanctions for those who seek to cover up such abuse by preventing or deterring a person from carrying out the duty. It makes grooming a statutory aggravating factor when sentencing, and it removes the 3-year time limit for civil personal injury claims brought by victims and survivors of child sexual abuse. Part 5 of the bill also helps to tackle the rising levels of online child sexual abuse. In particular, the bill provides for new criminal offences to stop, and we mean stop, AI-facilitated child sexual abuse, and to hold accountable those who commit or enable these vile crimes. I commend the Noble Lady Baroness Kidron for her earlier advocacy of the new child sexual abuse image generator offence. My Lord, the bill also provides enhanced protections for children and vulnerable adults against their exploitation for criminal purposes. First, it provides for a new offence of child criminal exploitation, so where an adult intentionally uses a child to commit criminal activity. And to complement this new offence, the bill also provides for child criminal exploitation prevention orders to help prevent the criminal exploitation of children from occurring. Second, the bill introduces a new offence to tackle the practice of cuckooing, where criminals take over the home of a vulnerable person for the purpose of illegal activities such as drug dealing. Thirdly, the bill creates a new offence to combat coerced internal concealment or plugging, where children or vulnerable adults are coerced into concealing drugs or other items in their body for criminal purposes, typically as part of a county lines operation. We also recognise how dangerous online material is in perpetuating the growing epidemic of violence against women and girls. We committed in the other place to criminalising pornography that depicts acts of strangulation and suffocation in this bill, and we will shortly bring forward an amendment to that effect. I turn now to children who are victims of child sexual abuse. As noble lords will be aware, 10 years ago, the Street Offences Act 1959 was amended so that the offences of persistent loitering or soliciting in a public place for the purposes of prostitution no longer applied to children. Parliament was right to do that, because in doing so, Parliament recognised that children, because they are children involved in such conduct, are not criminals, but they are themselves the victims of sexual exploitation. I'm pleased to say that we will now bring forward amendments in this House to introduce a new disregards and pardons scheme for anyone who, as a child, was convicted or cautioned for these offences. I now turn to policing. We will address the need to rebuild trust in policing. In some serious and worrying cases, public confidence has been undermined by atrocious criminality and misconduct by a very small minority of officers. Deterrence and punishment of such misconduct is a priority for this government, as indeed it is for the police. A key strand of the government's Safer Streets mission is to increase public confidence in policing and the wider criminal justice system. Since 2017, the College of Policing has operated a police barred list and advisory list, which ensures that those officers who are dismissed by a police force in England and Wales are prevented from just joining another force. Such individuals have no place in policing. The bill extends this approach, ensuring that officers dismissed at disciplinary proceedings from the National Crime Agency and other specialist police forces cannot be re-employed by another force. It is vital that the system of police accountability commands the confidence both of the public and the police. As a society, we rely on the professionalism and bravery of firearms officers who put their own lives at risk to keep us all safe. Thankfully, the occasions where the police have to use lethal force in this country are few and far between. But when they do so, it is entirely right that officers are accountable for their actions. But those accountability arrangements must be proportionate, timely, and fair to all concerned. Regrettably, this is currently not the case. So the measures proposed in the bill, we will improve the timeliness and appropriateness of investigations by the Independent Office for Police Conduct and the rights of victims. That said, if firearms officers are charged with offences relating to and committed during their duties, the bill will protect them from violent reprisals by establishing a presumption of anonymity in criminal proceedings up to the point of sentence. My Lords, the public rightly wants to see crimes solved and offenders brought to justice, and to do this, the police must have the necessary tools to do their job. So if someone has their mobile phone stolen and the victim can trace its whereabouts, this bill ensures that the police have the powers to enter premises quickly, if necessary without a warrant, to recover electronically tracked stolen goods. It's also vital that police powers keep in step with the march of technology in other respects. Evidence of criminality is no longer routinely stored on a computer hard drive, it is instead held remotely in the cloud. This bill clarifies the circumstances in which law enforcement agencies can access such information, subject to strong safeguards, as they investigate offences ranging from child sexual abuse to fraud and to terrorism, thereby protecting the public and our borders. The bill also ensures that law enforcement agencies have the necessary powers to combat other forms of technology-enabled crime. So we're banning the possession and supply of SIM farms, save where there are legitimate uses, such as in broadcasting. And we're giving the police and others the power to suspend IP addresses and domain names used to commit fraud or other serious crimes, such as the so-called pimping websites involved in commercial sexual exploitation. Protests. My Lords, the right to peaceful protest is fundamental to our vibrant democracy. But in facilitating peaceful protest, the police also have a duty to uphold the rights of others not to be harassed or intimidated and to go about their daily lives without serious disruption. The bill ensures that the police have the powers they need to protect places of worship from intimidatory protests, and it also protects specified war and other memorials, including the cenotaph and the statue of Winston Churchill in Parliament Square, that have been the target of protest action. A new targeted offence of concealing identity at designated protests will strengthen police powers to require the removal of face coverings at protests where violence or other criminality either has occurred or is likely to occur. The precious right to engage in peaceful protest and the equally precious entitlement to freedom of speech does not extend to threatening or abusing others, all the more so where those being threatened or abused are emergency workers. The law already recognises that racially or religiously motivated threats and abuse should attract tougher penalties, but these currently don't apply where the behaviour takes place in a person's private home. So police, firefighters, ambulance staff, when they're attending someone's home, for example in response to a 999 call, have no choice but to remain and to act. So the bill closes the loophole in the law so that anyone who threatens or abuses an emergency worker because of their race or their religion within a private dwelling will be liable for the higher maximum penalties such hate crimes would attract where the conduct takes place in a public place. I now turn to counter-terrorism. We must also make sure that counter-terrorism powers reflect evolving threats, ensuring that operational partners have the tools they need to keep the public safe. Part 14 of the bill delivers on several recommendations made by the Independent Reviewer of Terrorism Legislation, Jonathan Hall KC. He's identified the need for a new diversion order in response to the increasing number of young people who are the subject of counter-terrorism investigations. The Youth Diversion Order provided for in Part 14 will be a new civil order which will enable the police to intervene earlier to prevent young people engaging in terrorism and divert them from the criminal justice system. Finally, my lords, In addition to the three new measures which the government will be seeking to add to the bill, to which I've already referred, we will also be tabling amendments to apply various further provisions in the bill to Scotland and or Northern Ireland. These amendments are being brought forward at the request of the Scottish Government and the relevant Northern Ireland departments. My Lords, this government was elected to deliver change. Change that will reverse the decline in neighbourhood policing, change that will tackle the epidemic of violence against women and girls and the epidemic of knife crime. This bill will help deliver that change by cracking down on antisocial behaviour, making our town centres safer, building trust in the police, clearing our streets of knives, and protecting our children from sexual abuse, criminal exploitation, online harms, and safeguarding women and girls from stalkers and sexual predators. These are the purposes behind this bill. I beg to move.
Yeah. The question is that this bill be now read a second time.
My Lords, it's a pleasure to open this debate on behalf of His Majesty's official opposition. And it will come as no surprise to noble lords of the government front bench that we on these benches broadly support this bill. It will be no surprise because large parts of it are a copy and paste job from the previous Conservative government's criminal justice bill. From the provisions on antisocial behaviour to the new offences of cuckooing, the duty to report child sexual abuse and the new protest and public order offences, this government are continuing the work we were doing to strengthen the criminal justice system. This is, of course, very welcome. But it does mean that all is it does not mean that all is plain sailing. The feeling amongst the British public is that crime has been increasing, even though overall rates of crime since 2010 have fallen. The Crime Survey for England and Wales for the year ending March 2025 shows that there were 9.4 million incidents of headline crime. Although this represents a 7% rise from the previous year, the ONS state that this is entirely due to a 31% increase in fraud. Undoubtedly, a significant factor in this overall feeling of pessimism is because of the increase in more visible crimes that impact people's daily lives. Shoplifting, phone theft, graffiti, vandalism, fare evasion and drug use are highly visible crimes that leave people feeling unsafe in their daily lives. Shoplifting, for example, has risen by 20% in the year from 2024 to 2025. The National Police Chiefs Council has pointed to an estimated 1.2 billion shortfall in police funding. The chair of the NPCC has said the funding settlement for the spending review will cover little more than police pay rises. Chief Constable Paul Sanford has warned the government will find it incredibly difficult to meet their neighbourhood policing pledge with this funding settlement. The Metropolitan Police have already announced they will have to cut 1,700 staff, scrap their dedicated antisocial behaviour officers and close down half of the front desks in stations across London. And this strikes at the heart of a wider principle. Is this crime and policing bill, which runs to over 200 clauses and over 20 schedules, actually going to reduce crime on the streets of this country? In some ways it might, but in many others, unless coupled with serious improvements in enforcement and police action, it may very well not. So turning to the bill, the government has in fact committed 3 crimes of commission and 2 crimes of omission in this bill, and I'll start with the crimes of commission. The government's 2024 election manifesto promised to introduce new respect orders with the aim to stamp out issues such as public drinking and drug use. So the government comes armed with a noble cause, but all it takes is to scratch just below the surface to see that these respect orders are little more than smoke and mirrors. What this bill does is to insert a new part before Part 1 of the Antisocial Behaviour Crime and Policing Act 2014, creating the respect orders. Then it converts what are currently antisocial behaviour injunctions into youth injunctions. Rather than giving the police, local authorities and the courts tough new powers to tackle antisocial behaviour, as the government claims, they are instead simply renaming the currently existing injunctions and creating new orders which are the same in all but name. The antisocial behaviour injunctions were introduced as part of my noble friend Baroness May of Maidenhead's efforts to streamline the powers available to authorities to deal with criminal and challenging behaviour. As she noted at second reading of that bill, under the previous government, Labour government, over 9 antisocial behaviour laws were passed, creating 19 separate powers. The Antisocial Behaviour Crime and Policing Act 24 consolidated those into 6 powers. That had a purpose. I cannot see what this government's new respect orders will add to this arsenal. Secondly, the repeal of Section 22A of the Magistrates' Court Act 1980. This provision states that shoplifting of goods with a value of less than £200 are to only be tried summarily in a magistrate's court. There has been much misinformation about this provision, which was brought forward by the last Conservative government. The Labour manifesto called this an effective immunity for some shoplifting, a line which has been parroted by Labour ministers ever since. However, the government's policy paper on the bill, published on gov.uk, calls it perceived immunity, and I think that sums up the bizarre nature of the criticism. I want to be absolutely clear. Anyone claiming that trying low value shoplifting in a magistrate's court is granting criminals immunity is wrong and misleading the public. There is absolutely no reason why theft under £200 cannot be tried summarily. I need not remind the House, full of eminent lawyers as it is, that a person can still be sentenced for up to 6 months imprisonment and issued with a fine if found guilty in a summary trial. 6 months imprisonment is clearly not immunity. What it does do is clear the already clogged up Crown Courts and the police to prosecute more serious cases. That does not mean that thefts of under £200 from shops do not impact on shopkeepers, nor that they should not be investigated. But there is nothing wrong with having a bit more summary justice in this country. It permits cases to be tried and discharged more quickly and more efficiently, rather than risking long and drawn-out Crown Court cases that last for months, if not years. If the police are not investigating such offences, then that is an issue with the operation of policing, not the law. I will now turn to clauses 107 and 108. These were inserted into the bill at report stage in the other place, and as such have not had as much scrutiny perhaps as they ought to. The 17th report on the Constitution Committee of Your Lordship's House has drawn attention to these clauses for the uncertain scope of the new offences and the use of highly subjective terminology. Clause 107 creates the new offence of using threatening, abusive or insulting words of behaviour towards an emergency worker that is racially or religiously hostile. Clause 108 creates the offence of using threatening or abusive words of behaviour that are likely to cause an emergency worker harassment, alarm or distress. These offences are very similar to the already existing offences under Section 4A and 5 of the Public Order Act 1986. The key difference is that these new offences can be committed in a private dwelling, whereas those in the Public Order Act cannot. And it is understandable why the government might wish to press ahead with these new offences. We all wish to see our emergency workers protected, but it is far from certain that creating 2 new speech-related offences will offer emergency workers any greater protection in reality. Clause 107 involves the criminalisation of insults, and Clause 108 uses the term distress. Both are highly subjective, thereby leaving people open to prosecution on undefined terms. We already know this is an acute problem in this country. There exists a litany of cases whereby people have been arrested and prosecuted for speech offences. The continual misuse of non-crime hate incidents and the probably irresponsible policing of tweets and online comments has had a chilling effect on free speech. If anything, we should be reviewing and removing barriers to freedom of expression and speech, not expanding those limitations. I therefore echo the comments of the Constitution Committee in relation to clauses 107 and 108 and call on the government to heed their advice that these clauses should be drawn far more narrowly. I'm sure that much of the debate in this bill will comprise of what noble lords deem to be omissions and missed opportunities. And I have time to only mention a few of those, but I do give notice to the noble lord, the Minister, that at committee stage I will be raising many more. Given that this bill in many ways mirrors the previous government's criminal justice bill, it was surprising to see that there has been no inclusion, bar 2 clauses, of the measures surrounding the replacement of the Vagrancy Act. The previous government planned to repeal the Act and replace it with a new framework around nuisance begging and rough sleeping. If the government are to commence the repeal of the Vacancy Act, but not institute further powers to replace that Act, there may be a gap in the law. I would appreciate it if the Minister could perhaps comment on why the Government have not included these measures in the bill. Furthermore, it does not include the previous Government's plans to impose tougher penalties on those convicted of shoplifting offences on more than 3 occasions. Those provisions would require the court to impose a community order, including a curfew, exclusion or electronic whereabouts monitoring condition, or a combination of such conditions. Given the Government's tough talk on bearing down on retail crime, it is more than a little confusing why they have not included such measures in the bill. So I will end where I began. Criminal justice is not simply about laws this Parliament passes. We can continually create new criminal offences, we can pass as many new laws as we like, but until we get to grip on the enforcement of those laws, we will never tackle the scourge of criminality. The Government has been talking tough on crime, but this must now be met with corresponding action.
My Lords, I thank the Minister for her introduction, and I'm grateful to the many organisations who've provided briefings. In too many areas of crime and policing, we're failing the people who most need protection. Children and vulnerable adults exposed to predators, shopkeepers bearing the cost of unchecked theft, farmers shouldering the consequences of criminals stealing expensive farm equipment to order, and traumatised women who hesitate to report assaults, fearing the justice system will only compound their suffering. Much of this comes down to resources. Although the Minister often states that Labour is investing an extra £1.2 billion in policing this year, the reality is that little of this will reach frontline services. The National Police Chiefs Council notes that a quarter of this sum will be returned to the Treasury through increased employer national insurance, with the rest already committed to fund pay awards and service debt, because a decade of underfunding has forced police to borrow just to maintain their dilapidated buildings and antiquated IT. Already gaps in children's services, mental health and social care force police into roles they are ill-equipped to fill. So in scrutinising this bill, we'll have to ensure that we do not set the police up to fail. Take drug testing. The bill expands the range of triggers for police to be able to trust someone for drugs, but makes no provision at all for more drug testing centres or forensic resource. That must change, because drugs are deeply intertwined with serious violence and linked to more than half of all homicides. Drug-related deaths have doubled since 2012, and about 70% of thefts and cases of domestic violence are driven by addiction. Yet more than 27,000 suspected drug suppliers remain on bail or under investigation, largely because we lack enough trained forensic specialists. If these delays and the patchy availability of treatment programmes are not addressed, the measures in the bill will become irrelevant. In a similar vein, there are a number of provisions in the bill that are welcome in principle but need careful scrutiny in practice. Among those are new offences, such as assaulting retail workers, and the proposed respect orders, which, while well-intentioned, risk duplicating existing laws and further straining a justice system already operating way beyond capacity. My Lords, Liberal Democrats have long argued that neighbourhood policing is the most effective way to address these problems before they take root. The role of local beat officers is crucial. They know where the domestic abusers live, they know where the kids are left home alone, and they know where the drug dens operate. And effective neighbourhood policing depends on familiarity, consistency and trust, qualities that can only be built up over time. We cannot keep parachuting in new officers and expect these relationships to flourish. That's why we have proposed legal minimum resourcing to ensure neighbourhood policing teams are maintained at the level necessary to sustain long relationships and a sense of safety among communities. That sense of safety is especially important for young people. At the moment, 1 in 3 young people report that they don't feel safe in their communities. The dangerous and often tragic result is that they carry weapons. We therefore back proposals to tighten the rules around the online sale and delivery of weapons. And we'll bring forward amendments to give legislative life to even more of the Clayman Review's recommendations. I now want to turn to police and criminal justice reform. Very few people realise that 90%, yes, 90% of crime is now digitally enabled. That means chief constables must be given the flexibility to decide the right mix of traditional police officers and specialist staff needed in their forces, because digital skill is very often now more highly valued than physical prowess, and recruitment should reflect that. Meanwhile, training has to move with the times. 1/3 of all police officers now have under 5 years' experience, yet inspection after inspection exposes serious flaws in the training provided, poor professional development, combined with infrequent updates on new laws and procedures, mean many frontline officers have outdated skills, leading to uneven standards and a workforce that lacks the confidence to use their powers. With 94% of reported offences unresolved, new laws mean little if officers aren't equipped to enforce them. So we will push for the first national review of police training since 2018. But reforming policing alone is like fixing the lock on a door that's completely rotten. It simply beggars belief that at the end of March 2025, there were 310,000 cases outstanding in magistrates' courts. That serious offences such as rape are taking more than 2 years to come to trial, with offenders back out on the streets on bail, tormenting their victims. And that perpetrators who are convicted of crime often pass through prisons without any kind of rehabilitation. Now let me highlight some serious concerns on civil liberties. In Clause 138, the move to give police automatic access to driving licence data for any law enforcement purpose, not just driving offences, marks a major expansion from current practice. The Home Secretary need only consult police with no full parliamentary oversight when drafting these regulations. While the bill doesn't mention facial recognition, and ministers say there are no plans to use DVLA data this way, the National Police Chiefs Council, in a written submission to the Home Affairs Committee, stated that police chiefs are seeking access to the DVLA database for facial recognition searches, and proposals by the previous government would have enabled this. To do this would put more than 50 million innocent people in a perpetual digital lineup. This poses profound risks, particularly for people of colour and minority groups. In 1923 in the UK, Big Brother Watch found that 89% of police facial recognition alerts wrongly identified members of the public as people of interest. So we will vigorously press the government to ensure DVLA access is necessary, proportionate, and set out clearly in primary legislation, restricted to tackling serious crime or public safety threats. And it's not just about facial recognition, but a whole range of biometrics, some of which are only now in development. I am particularly concerned about the need to future-proof the bill against tomorrow's technologies. New digital tools, such as remote data extraction, advanced surveillance systems, predictive analytics, and wearable sensor technology, will soon reach the UK market. The bill must be capable of evolving with technology, ensuring that protections for citizens remain robust as new digital tools appear. In conclusion, public confidence in policing is at an all-time low. This may not be fair. I don't think it is. but it is the reality. New duties imposed by Parliament must therefore be matched by new investment. We must deliver policing that keeps people safe without edging towards a surveillance state. This bill gives us a great opportunity to strike that balance. But more power without resources or safeguards risks serious consequences. So let us ensure this bill empowers the police, protects freedom, and prepares the service for a fast-moving technological world, because only then will it truly deliver safer communities.
My Lords, I rise to broadly support the bill. I think there's an awful lot in it that's to be commended. I wouldn't agree with everything that the Liberal Democrats have said about access to more data, and certainly not facial recognition, but I think there's some steps in the right direction. But of course the nature of a second reading is to highlight the things that you would have preferred were in it, rather than probably the things that are in it. My first point is going to be about the missed opportunity, I genuinely feel, to set out a strategic direction, partly for the criminal justice system and certainly for the police. We've not embedded anything about prevention as a strategic direction in the way that the fire brigades have. We've not said anything much about police professionalism and how that might be developed. And finally, the use of technology and how we set a strategic framework in which that will develop. So that, I think, is a genuine missed opportunity. The four areas that I just want to highlight that I will be pushing in committee stage for some recognition. Now, first is around firearms officers. First of all, I acknowledge that the development around the anonymity of officers is welcome, although I confess that on occasions I thought that actually they should be named, because accountability is very important. But I think this development is a good one, and I support it. But this group of brave men and women, 3,500 of them, who protect 69 million of us, and the only ones who can go forward on our behalf and deal with the people they have to deal with, I'm afraid are not receiving a good deal at the moment. This week alone, the officer in the case who shot and killed Jermaine Baker in 2015, this week was told he had no case to answer in a misconduct process. 10 years. Never at risk of a criminal charge, but 10 years later, that can't be right. So it's something about timeliness, but I would also say the law ought to offer more generosity and sympathy to the officer in the first place. We do that for householders who protect themselves and kill someone in their home. They're a unique group. So why has this unique group not got any similar protection, which is a higher bar before prosecution is considered, not immunity? No one argues for that. Accountability is essential. But I really think something has got to happen in this area, and as yet it hasn't. My second area is around cycling. Now, I'm trying to get some amendments into this bill because I think it's time that cyclists had more accountability too, and insurance wouldn't be a bad idea. The opportunity to have points on their licences if they have driving licences should they commit offences, registration marks to identify them, and even licences for the people who ride them. The Public Bills Office told me it's out of scope. I can't understand this, because obviously there are amendments about dangerous cycling which the government's brought forward, which I support. But there'll be no use having those amendments if you can't identify the person who did it. So I suggest that there is a possibility to consider future developments in this bill. My third point is around the suicide of police officers. The Police Federation are concerned that the number of people, police officers and staff, who are committing suicide over the years is increasing. They're having real difficulty getting hold of the data, either about those who have committed suicide or those who have attempted it. They recently had a survey in which only 41 forces replied. Two of the biggest forces in the country, including the biggest, did not reply. So they're struggling to get hold of the data. So they would like to see a legal duty to ensure that this data is first of all collected to see if there's a problem, what is it, how big is it, and where the themes are that might enable more prevention to take place. And my final point is just about the indirect consequences of historical weapons around offensive weapons. Lord Lucas has done some work around this, but I think there's more to do to make sure that people who have historical weapons are not captured in the offensive weapon debate, and also the couriers who carry these things are now withdrawing from the market meaning that there's very few people who are carrying neither weapons or things like scissors, which means that we'll have a real problem soon if we don't consider that indirect impact.
My Lords, I commend this government's mission to achieve safer streets and applaud particularly the aim of halving both knife crime and violence against women and girls within a decade. This bill touches on a wide range of complex and important issues, and I want to just raise a few here. Reporting of child sexual abuse and the decriminalisation of abortion are of particular interest to my colleagues on these benches. Indeed, noble lords may have seen the Church's statement in response to the debate in the other place on the decriminalisation of women seeking abortion. Fundamental reform to this country's abortion laws ought to merit its own parliamentary process, we would say, and we on these benches are keen to continue engaging with government to ensure careful consideration is given to support all those facing such a painful decision. I declare interest as Chair of the Board of Trustees at the Children's Society, and I'm proud of their unwavering commitment to protect children from harm, including child sexual abuse, and to enable them to flourish. I'm pleased that the bill includes a standalone offence of child criminal exploitation, CCE. And I welcome the government's commitment to define CCE for police, but also support calls to bring forward a statutory definition of CCE on the face of the bill that's directed at all organisations supporting children, to be supported by a robust, comprehensive implementation package with adequate funding and training. I note that the bill before us risks criminalising children forced or coerced into criminal activity. I think we need to take care that children are exempted in the work of this bill from any offence of commissioning, cuckooing or coerced internal concealment, recognising here, as elsewhere, children as victims, not perpetrators. The Right Reverend Prelate, the Bishop of Gloucester, is also following this bill and is unable to be here today. With her, I would make the case for recognising so-called honour-based abuse as an aggregating factor in sentencing, introducing a new offence where victims die of suicide following sustained patterns of coercive control and abuse, statutory defences for victims and survivors of domestic abuse who are accused of offending, and removing parental rights of individuals convicted of child sexual offences. We have been reminded today that recent terrible events mean many are fearful when approaching a place of worship, indeed going about their everyday lives. The Right Reverend Prelate, the Bishop of Manchester, who can't be in his place today, wishes to engage with the elements of this bill, offering practical guidance for police both to enable expressions of public protest while also preventing intimidation and harassment. He also looks forward to working with noble lords to ensure that this bill offers stronger safeguards against the discriminatory treatment of Romani, Gypsy, Roma and Irish travellers. Noble lords will be aware that the Right Reverend Prelate, the Bishop of Sheffield, has recently been nominated to chair the Orgreave inquiry into the events of the 18th of June 1984. My colleagues on these benches and I will continue to engage the government on public order policing measures. Finally, I welcome the principle of youth diversion orders for those under 22. This bill will need to strike a delicate balance. Overzealous restrictions on movement and social contacts under such orders may lead to yet more disenfranchisement and distrust. My Lord, this is a challenging time and the obstacles are real, and I therefore commit myself and those on these benches to work with the noble lords to think creatively, compassionately and constructively in our collective scrutiny of this bill.
My Lords, yet again we are being asked to digest a lengthy criminal justice bill which covers far too many diverse areas of conduct. Churchill might have said that this bill has no theme. Before the bill began its progress through the other place, the government proclaimed that it contained 35 headline measures. And Andy Slaughter, the chairman of the Justice Select Committee, said the bill introduces 27 new criminal offences. I think he was congratulating the government. Had I been discussing the criminal justice bill, that's to say the bill that my noble friend Lord Davis referred to, which fell at the last election, I would have said of that what I now say of this bill. It covers too many subjects. It makes criminal activities that are already criminal. It has 430 pages. It has 203 clauses and 21 schedules. Just look at it. It's like a telephone book. It's a catalogue, in my view, of early-day motions rather than a practical answer to the problems it seeks to identify. It reminds me of the Criminal Justice Act 2009, which included provisions, amongst other things, for the appointment of senior police officers, prostitution and lap dancing, the supply of alcohol to children, gang-related violence, aviation security, border controls and extradition, but more besides. Many of the measures in this bill, I'm sure, are on their face worthy, and assuming they're not already criminal offences, no doubt good measures taken from the criminal justice bill. But passing laws is not of itself a solution to an actual or perceived problem. Movement is not productivity. Too often governments of all political persuasions think that sounding vigorous is a substitute for action. Between 1815 and 1914, remarkably few laws, about 15 or 20 statutes, were passed that affected the criminal law. Several of them are still in force, in whole or in part. When Tony Blair was Prime Minister, between 1997 and 2007, over 50 criminal law statutes were enacted. The Criminal Justice Act of 2003, another doorstop of a bill, even repealed earlier sections of earlier Acts of Parliament passed after 1997, which hadn't even been implemented. I would ask written questions in the other place, asking how many criminal law provisions had been implemented, how many had been repealed before implementation, and how many had been brought into force. And the answer I used to get was roughly 1/3 had been implemented, 1/3 had not been implemented, and 1/3 had been repealed before implementation or soon afterwards. Now, I'm not making a politically antagonistic point. I'm simply pointing out that the early 21st century legislative equivalent of dreadnought building is ineffective unless the government, any government, does more than pass laws and pat itself on the back. The court system is under strain, the police are under strain, our prisons are under strain, and yet we blithely pile more and often repetitive legislation on them for political effect without calculating whether the new provisions already exist or can be managed within the present creaking criminal justice system. The Lord Chancellor recently had promised 1,250 new Crown Court sitting days. With the Crown Court trial backlog leading to serious criminal trials now being scheduled for 2028 or 2029, and with literally hundreds of courtrooms unused, 1,250 additional days is insignificant. A senior Crown Court judge recently told me that he could use those days in just his own court centre. The Home Secretary's second reading speech in the other place in March amounted, if I may say so, to empty jargon interrupted by loyal backbenchers reading out interventions drafted by her spads or by government whips, and by the opposition complaining she was ignoring the previous government's achievements or claiming that they were her own. This is not a satisfactory way to amend the law, still less create new law. Of course, my lords, this bill will, either in this version or some other version of it, pass into law, and the government will proclaim its enactment as one of its great achievements at the next election. In the meanwhile, the IPP scandal continues, despite the heroic efforts of the noble Lord Timpson and other noble lords from across the House to release the ghastly grip of its talons around the lives and hopes of those hundreds of prisoners still in prison well beyond their tariff. My lords, governments and ministers say a lot. The voters watch carefully and remember what they actually do.
Lords, as my noble friend the Minister has so clearly set out, there's much to welcome in this bill to improve the law where needed, to make us safer. And I look forward to following it closely. And to the noble Lord Garnier, I would say that I also look forward to following the implementation when it is an act. It will have a profound impact on the lives of many, including the most vulnerable. And I particularly support the clauses relating to counter violence against children, women and girls. Following the report of the Independent Inquiry into Child Sexual Abuse, the IISCA, I welcome the abolition of time limitations in historical cases of child sexual abuse with Clause 82. The importance of this clause was brought home to me by a very courageous survivor who, following years of sexual abuse by his priest, has lived a life with incapacitating mental illness of which the origin was that trauma. The last government refused to act on this specific issue, so I'm proud that this government has conceded the fundamental legal principle. However, as drafted, it has limited benefit to those who have fought for the change and whose sufferings make it necessary to fight. And I would ask the Noble Baroness, the Minister, to discuss this with me further, together with survivors. The IICSE recommendation should be adopted without change or qualification. However, the clause adds a new substantial prejudice, especially for historical cases, which creates uncertainty, delays and an extra hurdle for survivors. As I understand it, the IICSA's final report did not include any changes regarding the introduction of substantial prejudice. Its inclusion in this bill could be interpreted as reintroducing the status quo. The impact of narrowing the court's focus to a fair trial with the burden on defendants should make out-of-time CSA claims easier overall, but ambiguity remains around what counts as claims arising. Subsections 3B and 3C of section 11ZB in clause 82 of the Crime and Policing Bill introduce the novel legal idea of substantial prejudice adopted from Scottish legislation, but the sub-clauses are unjustified as there's no provision for relitigation in these cases in England and Wales. I would suggest that if cases fail in civil courts, the legislation has failed in its aims and these subsections should be removed. The testimony of witnesses to the IICA shows institutional discouragement and the extended, often ineradicable psychological harm of abuse, underscoring the need for these reforms to remove barriers. One witness said to me, and I quote, "Attending the IICA was the second most traumatic thing in my life, and the trauma of it has lasted 7 years so far. If subsections 3B and subsection 3C remain, then preparing for a court case which could be dismissed on these grounds would be as traumatic as that, and with as little personal benefit." End of quote. While survivors are relieved that through this legislation, time limitations in historical cases of child sexual abuse will be abolished, for better access to justice, the substantial prejudice clauses need to be deleted. My Lords, the clauses on the management of sex offenders are hugely important for the victims of violence against women and girls, and with a long-term interest in stalking, I'm delighted that the government is both seeking to implement its manifesto commitments and to respond to the invaluable super complaint made by the Susie Lamplow Trust. Following discussions with those most concerned, I will wish to probe Chapter 6 of the bill. I also know from campaigning on doorsteps that the new offence of cuckooing will be of great benefit, especially to those living in social housing. Finally, I wholeheartedly support Clause 191 on the removal of women from the criminal law related to abortion, and I pay tribute to my colleague Tanya Antiolilezzi.
My Lord, I will focus on disorder in public places and spaces, which is having such a detrimental effect on our lives. And in doing so, I will concentrate on clauses 37 and 38 of the bill, which create a new standalone offence of assault against a retail worker and build on the aggravated offence contained in the Police Crime Sentencing and Courts Act of 2022. Now, I support the new measures, those two new measures in this bill. I want to see violence against someone doing their job dealt with seriously. No one should be subject to random attacks whilst at work. And I should declare, as the Vice Chair of the Customer Service All-Party Group, I don't want people who care deeply about giving great customer service to leave their jobs or to deter anyone from taking up this kind of employment, which is both essential and valuable to us in so many ways. And I will say more about how in a moment. But first, the Institute for Customer Services tracking survey shows violent abuse against all frontline service workers continues to rise. That means public transport workers, those who work in the hospitality trade, people who work in post offices and banks, delivery drivers, and even utility engineers working on the streets. That's why the aggravated offence in the 22 Crime Act covers anyone, not just retail staff, providing a public-facing service or doing a public-facing job. So can I ask the Minister, when he comes to wind up, why this bill's stronger measures only cover retail workers? My Lords, all the people who do these public-facing jobs matter, not just because we need the services they provide. They matter because more often than not, they are the responsible person in charge of public spaces and places. So they don't just need protection, they need our support to uphold our common standards, which are so important to maintaining good order and a civil society, which means we must show respect for the authority of their roles in public settings, whether their authority in such situations is formal or informal. And we need to give the people who do these jobs the recognition they deserve so they discharge their responsibilities well. My Lords, if we are to prevent violent criminal behaviour in public spaces becoming normalised, we must work together to tackle the low levels of disorder and disrespect that we see on our streets, on public transport, in shops and elsewhere, which cause us to feel so despondent. Litter dropping, feet on seats, watching videos or listening to music on our phones without headphones, queue jumping, fare dodging, graffiti. Police presence on our streets is important. Rapid response from the police to actual crimes is vital. But we can't keep creating new criminal offences and expect the police to deal with everything that's gone wrong in society. We as leaders, whether political, religious, business, public service or union, must use our authority to set, promote and honour the standards we know are vital for a healthy society, yet too often now treat as unimportant. My Lords, I would support expanding clauses 37 and 38 to more than just retail workers for the reasons I've given. But I would ask all the businesses, unions and trade bodies who understandably want more legal protection for their workers to think about what I've said. Likewise, we as legislators must do more than the easy bit of making new laws, as my noble friend Lord Garnier said. Tackling crime and disorder through better policing and stronger sentencing is important, but on its own it's not enough. We need to share and promote what the good citizens of this country want and expect from each other in our shared spaces. That's how we will create the right conditions for people to support each other and together make it harder for people to behave badly and do wrong.
My Lords, this bill has the potential to transform how we protect children from the devastating crime of child sexual abuse. So I welcome mandatory reporting. It'll be a historic step made possible thanks to the survivors who bravely shared their testimony to the independent inquiry into child sexual abuse. Too many children have been failed because adults in positions of trust and institutions who employed them protected themselves over children who needed it. But I fear that mandatory reporting will not be enough to create the culture of safeguarding this country so desperately needs. All those who work with children, teachers, healthcare or social workers have responsibility in keeping children safe from harm, but they must feel confident and have the skills to do so. But in 2020, the National Review into Child Sexual Abuse in Family Environment highlighted that many practitioners lacked the knowledge, skill and confidence to talk about sexual abuse with children. That's why Barnardo's, and I declare an interest as Vice President, and many other children's charities are calling for the introduction of clear guidance and training to accompany this essential new duty. Mandated reporters must be confident in their responsibilities and clear on what they should do if they suspect abuse. So training will support professionals to identify and act on the signs and symptoms of abuse, as well as to respond effectively in cases where children do disclose. Or we risk more children falling through the cracks and abuse go unrecognised. My Lords, there must also be accountability for both professional and civil mandated reporters who fail to report, as well as criminal convictions for any individual or institution that deliberately conceals abuse. The Centre of Expertise on Child Sexual Abuse, which was hosted by Barnardo's, has highlighted how such cover-ups have only served to increase a survivor's sense of betrayal. Never again should institutions be allowed to put their reputation ahead of the safety of a child. They must be held accountable for failures to protect children, whether due to concealment or poor safeguarding or a lack of proper recruitment and training. This duty must be backed by a strong inspection regime so that children are never again left unprotected by systemic failure. My Lords, protecting children is now more vital than ever, both offline and online. This means ensuring that the messages and images that shape young people's understanding of relationships and content are not harmful. The BBFC found that 1 in 3 pornographic users had seen violent and abusive content online on numerous occasions. A poll by the Children's Commissioner found that 44% of young people had viewed material online which portrayed sexual violence as normal. Content involving strangulation, incest, and worryingly, adults dressed as children, as well as content involving trafficking and torture, is rightly illegal offline. Yet these images and videos are widely accessible online. This inconsistency is harmful, especially to children, and many find themselves victims. My Lords, in 2023, during the Online Safety Bill, I raised the extremely concerning issue that the laws on pornography are regulated differently offline from what is permitted online. Baroness Burton's independent review, Creating a Safer World, the challenge of regulating online pornography, which I strongly support, is now also calling for online pornography to be regulated in line with offline pornography. If we do not act, we risk legitimizing a culture where children continue to be sexualized and young people grow up with distorted understanding of healthy relationships. My Lords, no child should grow up in a world where abuse is normalized or their safety is undermined for profit. So let us ensure that every child's lifetime is free from abuse, fear, and silence, because childhood lasts a lifetime.
It's almost absurdly challenging to try and speak on a bill of 427 pages, 203 clauses, and 21 schedules in 4 minutes. The bill is extremely wide. It ranges across multiple offences, creating multiple new criminal offences, and we will need to determine inter alia whether they have sufficient clarity, whether they disproportionately limit our fundamental freedoms, whether they may lead to unintended consequences. Clause 1853 is a case in point, and we will need to consider the very real resource implications of what we propose. My Lords, I want to concentrate on Clause 191, though there are many others I would want to talk to. This clause was passed after only 46 minutes of backbench debate in the other place. It wasn't a manifesto commitment. It constitutes a very significant change to our law on abortion. It carries with it enormous risks to women who might consequently think that aborting a baby up to birth will be safe in these circumstances, doing so without medical help. Dr. Caroline Johnson MP explained in the other place that she works as an NHS consultant paediatrician
and has cared for and held babies in her hands from 21 weeks and 6 days gestation right through to term. She said, "I am very aware that babies from, say, 30 weeks upwards have a more than 98% chance of survival." She went on to explain how an abortion is achieved in the later stages of pregnancy, saying that taking abortion pills intended for early pregnancy are not a suitable or safe medical intervention in later pregnancy. She said, "If one has a termination later in pregnancy, it is done by feticide. Essentially, an injection of potassium chloride is administered to kill the baby, and then the baby is born in the usual way but deceased. That is why it is important to know what the gestation is, because the termination offered under the law is done by different routes to make sure that it's done safely. We know that later in pregnancy a termination happens, the more a woman is at risk of medical complications." My Lords, I think that's the essence of the challenge we face here today. We must scrutinise a clause which, under current law, would enable a woman who has secured medication to end a pregnancy under the Pills by Post scheme, which is supposed to be used only up to 10 weeks, to take this medication in a non-clinical setting right up to birth, where she would have no professional medical support, despite the fact, as Johnson says, that she's in greater risk of complications. The clause does not give her any protection other than that against prosecution, but prosecution is the least important issue here. What is profoundly important is the woman's safety. Even at earlier stages of gestation, there may be need for surgical intervention to remove a dead baby. How might a woman achieve abortion in the later stages of pregnancy? Essentially, as I understand it, it will be by taking abortifacient medication, which is neither suitable nor safe, or by acquiring potassium chloride by some means. But how could the potassium chloride be administered? It has to be injected into the baby's heart using ultrasound guidance to cause cardiac arrest and death to the baby. And that's not the end of the process. The baby must be delivered. Now, during childbirth, specific drugs are administered and offered for pain management, prevention of things like hemorrhage and other complications. None of these would be available to this mother. My Lords, most women who have experienced miscarriage or childbirth will probably agree that if proper medical help is not available, it is terrifying. Things can go so terribly wrong. Babies can get stuck in the birth canal, which will eventually lead to the need for an intervention, whether by caesarean section, forceps, or vacuum extraction. There is a serious risk that a mother whose baby gets stuck may die if the baby is not removed. At the very least, she may suffer terrible pain or multiple serious consequences to her own health and her future childbearing capacity. We're left then in a situation in which your lordships are being asked to legislate for abortion to birth without medical help, because any medical practitioner who helped her would be subject to prosecution. My Lords, if this provision is passed, women will think that aborting their own babies will be a safe thing to do simply because it's lawful. This clause is redolent with danger to women. Can the noble Lord the Minister tell us exactly what government thinks women might seek to, how women might seek to end a full-term pregnancy, and how they might be protected against the potentially catastrophic consequences of aborting and delivering a baby without medical help? My Lords, this clause is too dangerous to women to remain in the bill.
My Lords, the Policing Bill stands as an important framework for how we as a society respond to acts that cause harm and undermine our shared values. Among its many provisions, one issue demands our urgent attention: the failure to treat racist comments and abuse as crime when it goes unreported or unchallenged. When racist comments are dismissed as harmless or just words, their impact is underestimated. In truth, silence allows prejudice to grow. Communities subject to racism feels unsafe, unheard, and excluded. This erodes trust not only between neighbours, but also between the public and the institution meant to protect them. If racist acts are not reported and addressed, they normalise intolerance, creating an environment where discrimination can escalate into more serious violence, like the racist murder of my son Stephen. I don't want to see this repeated in years to come, and families are forced to go through what many families have gone through during the past, my family has gone through during the past 30 years plus. There's been an increase in knife crime since Stephen's death. This needs to be addressed with urgency to stop parents like myself continue to suffer the trauma of losing our child. When racist behaviour is recognised and reported and challenged, it sends a powerful message to everyone, regardless of their background. Belongs and deserve protection under the law. Within the school environment, racist name-calling must never be ignored, as it can escalate into more serious form of harm and violence. If such behaviour is not addressed early and documented properly, this risks developing into more dangerous attitudes and action as individuals grow older. The Crime and Policing Bill must therefore ensure robust measures that empowers individuals to report racism, support victims, and hold perpetrators accountable. Only then we can strengthen the community cohesion and safeguard the dignity and the equality that are the foundation of our society. For these reasons, I firmly believe that the abolition of the non-crime hate incidents should not be pursued, as doing so would risk silencing victims, undermining trust in law enforcement, and weaken our collective ability to confront and prevent hate in all its forms. I also want to thank the government for their commitment in addressing crime on our streets.
My Lords, this is a very large bill. As my noble friend Lord Garnier said, it is too large. But for present purposes, I am going to focus exclusively on clause 191, which is the clause which allows a mother to abort an unborn child right up to the moment of birth. My Lords, I believe that this clause is wrong in principle and should be removed from the bill. Your Lordships will note that this particular provision was incorporated into the bill late during the parliamentary process, at report. The debate lasted for some 2 hours. So far as I'm aware, there was no pre-statutory consultation. Now, I've always taken a very libertarian view on abortion. I am a strong supporter of the 1967 Act. I agree that abortion raises serious issues of morals and faith, but I've always taken the view that that is a matter for the mother, and on the whole, not for Parliament. However, clause 191 goes far too far. I find it very difficult to distinguish in principle between a child who has just been born and a child who is about to be born. If the child was killed immediately after birth, its killing would be an act of homicide. So I suggest is the killing of an unborn child immediately before its birth. There is very little distinction in principle. Of course, the law and common sense has always recognized that some acts of homicide are lawful. So, for example, reasonable defense is lawful. So, for example, is an abortion when the health of the mother is at risk long after the 24 or 26 weeks. But such is not the case here. The arguments that are being advanced rely very largely on the distress of vulnerable mothers. Mothers who incidentally could have had an earlier abortion under the provisions of the 1967 Act. Now, I accept, of course, that there may be very distressing cases, and I hope too that the prosecution authorities should consider very carefully in any individual case whether the public interest requires prosecution. Very often, usually not. I also think that if a prosecution occurs and leads to a conviction, then I hope that the sentencing judge will give very serious consideration to the mitigating factors and impose as lenient a sentence as possible. But these considerations are not the same as decriminalising an act of homicide. Society as a whole, Parliament as an institution, has the duty of care to an unborn child capable of being born alive. It is an obligation which reflects the value that we place on human life. This clause, if passed, would flout that obligation, and I don't think we should allow that to happen.
My Lords, I'm very pleased to be taking part in this second reading debate. I'm particularly pleased to welcome my noble friend the Minister to her place and her first bill, the first of many, I hope. And my two noble friends on the front bench know that they have my support for this bill. I'm following the remarks from my noble friend Baroness Lawrence. I am struck by the commitment of the government in the Commons to introduce an amendment to make hate crimes on the basis of sexual orientation, transgender identity and disability to be aggravated offences, and I look forward to their introduction in due course and offer my support to my noble friends the ministers. And of course, as a Labour and Co-op here, and also a former USDOR member, I also welcome to the bill the address to retail crime. But I intend to address in this debate clause 191. I profoundly disagree with two speakers who've spoken before me about this. On the 5th of June, MPs voted to insert clause 191 into the crime of policing bill by 379 to 137 on a free vote. This clause would disapply the existing criminal law on abortion from women acting in relation to their own pregnancies, bringing the law for women in England and Wales into line with the changes Westminster already made to abortion law in Northern Ireland in 2019, which works well, which was debated and agreed in this House at some length. The proposal to repeal this provision was led by my honourable friend Tonia Antoniazzoni, MP, and became, because in recent times, contrary to the words of Lord Hailsham, we have actually seen a substantial increase in investigations and prosecutions of women in England and Wales under abortion law dating back to 1861. And these have included women who were victims of domestic abuse, suspected victims of human trafficking and exploitation, and girls under the age of 18. Clause 191 is a simple, principled stance which reflects the strong position of cross-party MPs, and I strongly support it as it is. And notwithstanding the words of noble Baroness O'Lone and the Lord Hailsham, and indeed it has to be said the hysteria from those outside our gates this morning, in fact, the 1967 Abortion Act is not changed by this clause. There remains, however, a number of technical issues which I and others believe it is our job in this House to consider as this legislation proceeds. And they concern the impacts, the lifelong impacts of investigation and convictions for relevant offences. Because, of course, the change in the law under Clause 191 applies only to offences committed after the bill received royal assent. So there are a number of women whose pre-existing cases remain under investigation and where decisions have not been made. So I think that the House needs to consider an amendment to halt ongoing criminal investigations and prosecutions for repeal offences and pardoning women with criminal records and expunging the records of those investigations. Because, my lords, of course, if a woman is convicted of these offences, it precludes her from certain employment because of the DBS check for life. And it also includes women who have not been committed, who have not had a commitment, because it also stays on their record as part of a DBS check. So I think, in line with the Turing pardon for criminalisation of same-sex activity and similarly outdated laws, an amendment which will pardon women with a criminal record for repealed offence and expunge those records is relevant. And finally, my lords, sometimes if even with clause 191 removed, that there are offences against the Person Act of 1861 and Infant Life Preservation Act of 1929, which have a number of offences have been brought against women under these. So I think it's important that we actually ensure that the law is in step on this matter if we want to decriminalise abortion under these circumstances.
My Lords, this government has pledged to halve serious violence, crime, rebuild public confidence in policing and strengthen our criminal justice system. In my judgment, the Crime and Policing Bill represents a significant step towards these vital goals. Reflecting on the bill, I am reminded of my early years as a young beat constable in Jarrow during the 1960s at the age of 20. Fresh from training, I patrolled a town area where there were no radios, no mobile phones, only public telephone boxes to contact the police station. I still remember all those years ago, a warm summer's night, when at 2 a.m. at the back of the Jarrow shopping centre, I saw a chink of light. It was two men carrying a till from the back of a shop. The shops were surrounded by a large wall with an opening for delivery vehicles. Fortunately, the men, on seeing me, separated. Otherwise, I believe I was sunk. I tackled the one with the till, who dropped it. We both fell to the ground and I lost my helmet and torch after a struggle. He broke away and fortunately ran into a builder's compound, which was a cul-de-sac. He was trapped because they had barbed wire at the top. He turned and threw a 4-foot piece of cast iron guttering at my head. My lords, had I not ducked, I would not be here today. I even remember thinking, they didn't tell me about this at the training school. I tackled him again, and with the liberal use of my truncheon, he was arrested. And I remember being splattered by his blood. That moment illustrates how risky, demanding and dangerous lone night patrol could be, yet it helps to develop resourcefulness and resilience, qualities essential in policing. As the service has evolved, today's officers face even greater complexity and risk. They do so with dedication and courage, and they deserve our respect and support. The bill commits to recruiting 13,000 additional neighbourhood police and support officers, focusing especially on town centres. Their visibility is key to reducing antisocial behaviour and the alarming rise in violent shop thefts. Another issue the bill tackles is the lack of police visibility. People frequently say that they never see a uniformed police officer anymore. This isn't just about appearances. Visibility fosters trust, provides community reassurance, and helps to gather local intelligence, preventing and detecting crime. The devastating decision to cut 20,000 officers during austerity must never be repeated. That mistake drained the service of experience, especially sergeants and inspectors, those officers so vital for mentoring and guiding young officers. These are the supervisors who might have spotted the red flags, such as Sarah Everard killer PC Wayne Cousins and serial rapist PC David Carrick. The bill rightly empowers forces to raise standards, sack miscreants very early and restore trust. I include in this the disgusting behaviour recently of the Charing Cross 11. My lords, we're police by consent in the UK. That principle is foundational to our system and must never be taken for granted. To uphold it, we must recruit the most honest, capable and resilient individuals and support them through strong leadership and accountability. I firmly believe in the broken windows theory. Early action on minor and social behaviour prevents escalation, and this demands visible, engaged officers and intelligence-led, proportionate stop and search, used judiciously with public support. used wisely, we can enhance policing, public safety and community confidence, my lords. And I include in this modern facial recognition cameras. And to those who object, I ask a simple question. What is the difference between a member of the public telling me that man A looks like a rape suspect published on Crime Watch and an image produced from a technical camera telling me the same thing? The reality is, in both cases, it simply points the police in the right direction and can't be used simply to convict. Finally, I wholeheartedly support this bill. Let us stand firmly behind the men and women who risk their lives daily to protect us all and give them all the training, leadership and support that they need. And let us all work together to restore public confidence in the idea that the maintenance of law and order is the bedrock of a just and civilised and democratic society.
My Lords, there is a lot in this bill that I welcome, though I have some sympathy with my noble friend Lord Garnier about how we keep creating law upon law. Well, one of the answers to that is that when governments lose rulings in the courts, often the only way to try and tackle perhaps what governments had thought was in place is to introduce new primary legislation in order to make sure that the will of Parliament can be put in place in terms of how we govern our country. But to that end, there are a number of issues where I am concerned on some elements this bill is now going too far, or indeed may not be going far enough. If I think about spiking, it was Richard Graham, former MP for Gloucester, who first raised this as an issue in the Commons several years ago and has been taken up by Joe Robertson, Member of Parliament for Isle of Wight East. Where he is in difficulty or dispute with the government is his concern that the level for threshold for prosecution is concerningly low. Now, we've discussed already this week, when do you prosecute on spying? When do you prosecute on spiking is what my honourable friend wishes to address. And in particular, he wants to talk about, and I will continue to do this with others in this House, about reckless behaviour that could actually, instead of just being intended to annoy, that it actually is prank spiking can be covered, because that prank spiking can have serious consequences. In terms of one of the ways that we report fraud, it's either recorded crimes or through surveys. The crime that people fear the most and experience the most in this country is fraud. And yes, Part 8 is quite light, although perhaps this is a case of how we need to try and make sure we get more resources in the police focused on the crime that is considered to affect most people in this country, perhaps rather than more statutory duties. But nevertheless, this is something that really needs tackling right across the country and not just on an online reporting to somewhere in the City of London Police, perhaps never to be seen again. At the moment, of course, the banks will pick up the bill by refunding victims of fraud, but that cost goes across all of us who have bank accounts, and that is something to be considered. Quite rightly, there's a lot of debate about reporting. I do wonder at what point does the duty to report, when we start to talk about children under the age of 16 having sex, people getting treatments, people getting after the morning after pills, at what point, it's a long time ago since parents were basically blocked from learning about this activity, even though it's their child who's involved in underage 6. So I'd be interested to explore during this bill how we get into that fine line about what's right for the child, but also where the parent has the primary, of course, responsibility for looking after their child. I think of Luke 17:2. I appreciate the bishops are not present in the debate at this moment, but I am concerned about clauses 72 and 79 when it comes to the confessional. And I'd be interested to discuss this further with the Minister, perhaps outside of the chamber. In terms of reporting, though, the BBC has asked me to raise a particular issue. That's regarding Schedule 8.2d. And they are very keen to get into making sure that undercover journalism is seen as a reasonable excuse rather than their journalists being inadvertently criminalised. In terms of the other aspects of this bill, I think it's been well trailed already that Clause 191 is probably the most controversial of this bill, brought in the other end. Now, a lot of the prosecutions that have been referenced already are due to pills by post, which ultimately was passed in the House of Commons by 27 votes a few years ago. It's very difficult, in fact it's impossible at the moment, to get any statistics. We don't record how many pills by post are issued. We have not yet been able to get the abortion statistics, primarily because ONS is not able to capture them at the moment. The whole use of HSA forms and the similar. However, I think we do need to consider further this in much more detail, including how the government intends to make sure that those who provide abortion services illegally, what further changes they make to the law to allow that to happen. Going on about the 1861 Act, I'm afraid, this is the basis of lots of charges brought in this country, murder, use of chloroform, all these different things. To try and say it's an out-of-date act, I'm afraid, is irrelevant to the reality of actually how we use our laws today. But for this, I'm looking forward to further comments from not only the Minister today, but debate during committee stage.
I appreciated very much the speech of the noble Lord Hogan Howe. Though I see more value in this bill than the noble and learned Lord Garnier was prepared to admit, I agree with what they each said about hard topics that this bill might usefully have tackled, but did not. The Joint Committee on Human Rights has produced another of its helpful and focused reports. I agree with them that the difficult issue of concealing identity at protests may need to be better calibrated. I agree with them also on the issue of universal jurisdiction, which was debated in the Moses Room on the 9th of September. To bring our law into line with our neighbours and allow perpetrators of the gravest international crimes to be prosecuted here would involve nothing more complicated than removing the requirement of citizenship or residency in the International Criminal Court Act 2001. I look forward to supporting proposed amendments along those lines. The Constitution Committee raised two issues in addition to that referred to by the noble Lord Davies of Gower: the widening by Clause 4 of the categories of person who can issue on-the-spot fixed penalty notices, now of up to £500, and the need for parliamentary scrutiny of statutory guidance to police on the Child Sex Offender Disclosure Scheme, Sarah's Law. Like many constitutional issues, they may seem mundane, but I hope they will not escape our attention. Turning to national security, I support the youth diversion orders, which will be used to disrupt at an early stage young people who are believed to be involved in low-level terrorist offending, such as the possession and dissemination of material, often online. The idea is to divert them from the criminal justice system for their benefit and for ours. As noted in my recent report, Lessons for Prevent, their availability might also help to increase the rate of consent to channel interventions, which is currently running at about 75%. Polygraph testing is to be extended. I should like to know more about how rigorously the use of this technology has been assessed and with what result, since it was rolled out for sex offenders in 2014 and terrorist offenders in 2021. Finally, clauses 130 to 137 of the bill extend police powers following the seizure of electronic devices to access information accessible from such devices but stored on the cloud. The logic of that extension is not hard to understand, but its sheer scale requires us to think about safeguards. That is so particularly in relation to clause 135, which concerns the no suspicion powers to search and to question that are exercised by counter-terrorism police in ports and airports under the Terrorism Act 2000 and the National Security Act 2023. The utility of those powers has not been doubted by any of those who have been tasked with the close examination of their use. But the latest of them, Jonathan Hall KC, was moved to ask this week what will prevent excessive data from being extracted and copied, how journalistic and legally privileged material on an online account will be protected, and given the quantity of personal data which members of the public hold on the cloud, whether merely travelling through a port or border should be considered a sufficient reason to surrender so much private data. Senior courts have expressed a degree of disquiet about the existing power, and a further case is underway. Nobody wants a regime of pointless box ticking, but we need to rise to the independent reviewer's challenge and satisfy ourselves that if this strong and intrusive power is to be further extended, it is accompanied by the right safeguards.
My Lords, crime and disorder have reached such levels in this country that we certainly do need more effective and meaningful policing, but it has to be done in a way that retains confidence, does not damage fundamental freedoms, and keeps the criminal law clear and easily understood, or perhaps rather stops the law becoming ever more complex and harder to understand. Now, I won't dwell on that point, as my noble friend Lord Garnier has made that particular point quite eloquently. But I am sorry, nevertheless, that the bill continues down the road that the previous government took of creating specific offences for things that are already crimes. For example, though not only, the offence of assault on a shop worker. And my Lord, speaking as somebody who's been very critical of the way the pandemic and the lockdowns were handled, I can't help seeing some irony in the fact that 4 years ago it was an offence to attend a demonstration without a face mask, and soon it will be an offence to end one with one. My Lords, nevertheless, I'm generally supportive, and in the time available I want to register 2 concerns, just briefly. First of all, I note the government's intention. We've heard about it, and it was expressed by the Minister for Policing and Crime Prevention in the Commons. The intention to expand the scope of so-called hate crime offences by making all existing strands of hate crime aggravated offences. Now, my Lords, given the way so-called hate crimes have recently, in practice, been used to chill freedom of expression and freedom of speech, I do have quite a lot of concern about this, and it seems to be going in quite the wrong direction. Rather, I think, as a society, we ought to be going in a different direction, which is to begin to remove the concept of hate crimes from the statute book, and in particular, to abolish the entirely illegitimate category, in my view, of non-crime hate incidents. Now, an amendment to that effect was put forward in the Commons and did not succeed, but I hope and expect it will be tabled again, and I may indeed propose my own amendment on that subject. My Lord, second, as others have done, I want to register the deepest concerns about Clause 191. If this becomes law, it would be the biggest change to abortion legislation since the Act was introduced in 1967. As has been said, the permanent extension of the Pills by Post scheme with no requirement for an in-person consultation has made it possible to try to end a pregnancy at any point beyond 24 weeks. Now, at the moment, that's still a criminal offence, and this clause would mean it no longer was, provided only the mother was involved. Now, my Lords, it's foreseeable that this in practice will make abortions up to birth more common. It will endanger more women because of the medical risks of termination after 24 weeks. And it will create pressure for a similar decriminalisation for medical practitioners themselves. People will argue, how can it be illegal for a doctor to help with something that is not in itself illegal? Or they will say that doctors need to be able to perform late-term abortions to avoid the risks with terminations at home. It's the beginning of a slippery slope. Now, my Lords, there's no demand for this. Polling shows that more than half the public favour keeping abortion after 24 weeks a criminal offence. Only 1% of women support introducing abortion up to birth. And indeed, in passing, 70% of women support a reduction in the time limit from 24 weeks to 20. Now, my Lords, the clause would remove one of the few remaining legal protections for the unborn. In our country, if children are born prematurely after 24 weeks, the medical system will do everything it can to save them, and is often successful. Yet this clause will make it possible to try to end the life of a baby after 24 weeks without criminal consequences. It's simply inconsistent, not just with current abortion law, but with current law around maternal and child health more broadly. My Lords, this clause had a wholly inadequate couple of hours debate in the Commons. Its proponents really should be embarrassed to legislate on life and death in this fashion. I hope you'll get a lot more debate here, and I hope noble Lords will reject it.
Yeah. My Lords, I welcome Baroness Levitt in introducing a bill described as challengingly broad. It's not easy, however, to identify an overarching theme, so I shall speak rather generally about children who are the subject, or if you like, object of much of the bill.
I declare an interest as a trustee of Safer London. We, not me, I pay tribute to the professionals in the organisation, work with young Londoners and families caught in cycles of violence, exploitation and trauma. We help them escape harm, to heal, rebuild and believe in brighter futures. That may sound naive and flowery. It's hard-headed and hard work. An effective response is often rooted in safeguarding, not the imposition of punishment. Young people caught up, for instance, in child criminal exploitation are frequently significantly affected by trauma, seriously adverse childhood experiences before this happens. Alongside this, Safer London is finding that about a third of its clients are neurodiverse or have special educational needs. Allowing for those undiagnosed, this may actually mean about 50%. So many are so vulnerable. Grooming often involves quite small gifts, so-called, followed by, now you owe me. And if you don't do as I say, you'll see what's coming to your sister, a sort of debt bondage. It takes skill to work alongside, advocate for, and help a young person effect change, to see beyond behaviour to what leads a young person to where they end or are in danger of ending up. Noble lords will not be surprised that I'll mention resources. When money has been lost to support services, antisocial behaviour has increased. The first inquiry of the House's Justice and Home Affairs Committee 3 years ago looked at alternatives to short custodial sentences and heard a lot about the need for more investment in treatment as the response to crime. This applies to children as well as adults. And it's hard for a child with a criminal record to find employment when what's needed is an economic future outside criminality. On top of this, I'm told there's a racial element. Black children do not get diversionary sentencing to the same degree as others. This, of course, skates the surface. I share the frustration of other noble lords this afternoon. I may express through amendments concerns about polygraphs and whether there are gaps in the mandatory reporting provisions. Those are just for instances. A different broad point: how much new law are we loading on the police, who have to prioritise and get their heads around the detail of new offences when, as other noble lords have said, an activity has been covered by an old one? But sometimes we do need to update, I recognise, as with cuckooing, which I want to welcome specifically, and with the late addition of halting the criminalisation of women in England and Wales under abortion law dating back to 1861 to bring us into line with changes that noble lords across the House, and I've been reminded I was among them, voted into Northern Irish law in 2019.
My Lords, Clause 191 proposes an extremely radical change to abortion law. It was added at report stage in the other place without proper due consideration and only 46 minutes of backbench debate. It's unnecessary, badly drafted and will harm women. We already have one of the most permissive abortion laws in the world. Even David Steele said he never intended the Abortion Act 1967 to enable termination to be treated like a form of contraception. The presumption in the Act is that deliberately ending the life of a child in the womb is a criminal offence, unless it is signed off by two doctors who decide in good faith that one or more of the specified grounds are met. The change in the law is not because there are women who can't get abortions. It's not because it's too difficult to get a doctor to sign off. It's because of an ideological commitment to presenting abortion as a form of health care, like the removal of a tumour. The humanity of the baby in the womb is ignored. A wanted child is a baby and should be protected. An unwanted child is a fetus, and the othering word, if ever there was one, and can be removed and disposed of. I simply don't believe the degree to which a mother wants or does not want her baby changes the moral status of the child, and I think we need to have a national conversation about this. And I may be in a minority in this House when I speak on this issue. But I suspect that the removal of abortion from the ambit of the criminal law for the mother is something that makes many people uncomfortable, because abortion is important. I think we all instinctively know we are dealing with the termination of a human life. We can't just allow a free-for-all. There must be limits. Even though prosecution of mothers for unlawful abortions is incredibly rare, the existence of a criminal law framework for abortion sends a vital message. Ending the life of an unborn person is a serious matter. This is reflected in the way the law is framed, and that's what the majority of the public appear to want. My Lords, a poll of over 2,000 adults found that more than 6 in 10 respondents agreed that abortion should continue to remain illegal after 24 weeks. Just 17% disagreed. Clause 191 disapplies the law from a woman acting in relation to her own pregnancy. So no matter how she ends the life of her unborn baby, no matter how late the pregnancy, no matter how painful for the child, no matter how distressing for whoever finds the remains, she would be beyond the reach of the law. Whereas any doctor or nurse who is complicit would be committing a criminal offence. The member for Gower gave an interview to Times Radio. She was asked if she was, quote, comfortable with any woman ending a pregnancy at any time, unquote. She said she was. My Lords, that's what Clause 191 will enable. Janice Turner of the Times, a supporter of abortion, wrote that she was aghast at this, quote, glib, careless and amoral clause. In her words, quote, it cannot be that killing a full-term baby in the birth canal is legal, but smothering it outside the womb is infanticide. And of course, the Times editorial, my Lords, also raised the issue of pills by post, which was passed in the dead of the night in 2022 without proper debate or an impact assessment, and indeed the amendment was a disorderly amendment which had to be amended by the department. My Lords, there can be severe complications with abortion pills, especially when they're taken late in pregnancy. These include hemorrhaging and excruciating pain. My Lords, the traumatic situations in which these women have ended up is as a result of pills by post. It enables women to have dangerous late-term abortions at home alone without any medical supervision, and yet activists are now using the failings of pills by post to push for even more extreme laws. In conclusion, my Lords, Clause 191 will only make the situation worse, increasing the number of late-term abortions and putting more women in danger. If we really care for women, we need to reinstate in-person appointments, proper, sensitive, skilled medical assessments where experts can assess how far along a woman is, or whether there are any complicating factors that put her in danger, or whether she is being coerced. My Lords, we already have unfettered access to abortion. Clause 191 is an embarrassment to supporters of abortion and a stain on our reputation as a country that claims to care for pregnant women and their unborn children.
My Lords, Tony Blair had a pronounced interest in reducing crime, so 2 decades ago, as his strategy advisor and working with gifted teams of officials, I spent 2.5 years looking at patterns of crime and offending and how the many organisations within the criminal justice system were responding. 2 decades on, my Lords, however, the crime picture has changed fundamentally. On the plus side, a combination of forensic science, the extraordinary ubiquity of street cameras, including in doorbells, and the data obtainable from suspects' mobile phones has seen highly professional police clinically solve the worst crimes, and particularly murder. But, my Lords, we are failing miserably to organise effectively to counter other types of offences, which each of us now experiences either directly or through friends and family, all of the time and to an unprecedented extent, and which I am certain mostly go unrecorded. Staff at my local supermarket tell me they witness shoplifting with impunity at least once every hour. Watch thieves stalk the streets of Soho. A visitor to a 5th floor flat in my apartment block had his £5,000 bike stolen, all captured clearly on CCTV and shared with the police. 2 days later, he saw his bike for sale on eBay, but they refused to help him reclaim it. The BBC Scam Interceptors programme scams the scammers, listening in, catching them in the act, chiefly frightening older people, unversed in technology, into parting with some or all of their life savings. The scammers operate with impunity on an industrial scale out of identified buildings in India. The BBC recently tracked down a scammer facility in Nigeria which tricks naive British teenagers into selling sex pics, then blackmails them, in one instance tragically triggering a suicide. My lords, we should be ashamed sitting here in the nation's parliament in the borough of Westminster that we are cited in the street crime capital of the UK with mobile and other theft rampant. Yes, the police have just finally mounted an ambitious operation, but each of us will know people who've had their mobile snatched, have immediately located it using the Find My Phone facility to a specific house in Hackney or elsewhere, only to be told by police that no action will be taken. In our city centres, warrior e-bikers bomb along, some at souped-up speeds, sometimes at night without lights, ignoring red lights and zebra crossings, the wrong way up one-way streets, all with impunity, confident that they never will be stopped. And I thought Baroness Stoll tellingly identified other forms of wholly unwelcome and ever-increasing antisocial behaviour on our streets. Knife crime has doubled in a decade, with now over 50,000 annual offences and 200+ deaths, now the most common method of murder. The current inquiry into the horrific Southport massacre by a 17-year-old has produced chilling evidence of just how easy it was for him to purchase outrageous weaponry online, in his case, a Black Panther kukri machete with a 16.5-inch blade. I do not, my lords, dispute the value of most measures in this bill, but I do suggest that nothing in it addresses the need for the police and other agencies massively to raise their game and to attack every kind of crime that has a material impact on our everyday lives, whether on the internet or on the streets. So I conclude by asking the Minister in his closing remarks if the government will step back and frame a bold and transformative strategy to tackle head-on the plague of everyday crime which we are living with today.
My Lords, I draw attention to my interest declared in the Register as Chair of the College of Policing. For our police service, founded on the principle of consent, to be effective, the trust and confidence of the communities they serve is essential. But the proportion of the public who believe the police are doing a good job has fallen precipitately in the last few years. There are multiple causes, but I believe this bill and the government's focus on rebuilding neighbourhood policing will be a very important step towards improving confidence. We place immense demands on the police service, and in recent years there's been a shift of priorities and resources towards dealing with crimes of harm and important issues such as violence against women and girls, issues which simply weren't on the agenda before. Combined with funding and other pressures, we've seen in some forces a failure to attend to the basic standards of service which the public expect, such as action following shoplifting, burglaries or mobile phone theft. It is, I believe, the failure to attend to these basics which exacerbates criticism of the police for overreach, for getting involved in things we don't want them to be doing, and in particular in relation to police action which it is felt intrudes upon free speech. Non-crime hate incidents have become a kind of lightning rod for criticism of the service, and a number of high-profile cases of ill-judged police intervention have undoubtedly damaged confidence. NCHIs were born out of the landmark Stephen Lawrence inquiry as a means to support police to monitor incidents linked to hate or hostility. with the purpose of preventing future crimes, supporting investigations and protecting the most vulnerable in our communities. Recent events such as the horrific attacks on the Manchester Synagogue and the Peacehaven Mosque should remind us that dealing with hate crime remains as vital in 2025 as it did in over a quarter a century ago. It is essential that policing continues to have the ability to monitor hate and hostility within our communities. What could not have been envisaged at the time of the Lawrence inquiry was the growth of the internet, the advent of smartphones and social media, and how these have transformed how people interact with each other. The rapid expansion of the online space, coupled with increasingly polarized public discourse, has resulted in forces grappling with the challenge of balancing free speech with monitoring community tension in both physical and online spaces to prevent crime and protect people from harm. Not all perceived hate reported to police requires a police response or police incident record. The requirement to record should be shaped by necessity, proportionality and legality. There have been high-profile instances where policing has struggled with all three. That is why I called in this chamber for a rebalancing of the system. And at my instigation, the College, together with the National Police Chiefs Council and with the support of the Inspectorate of Constabulary and the government, set up a review of the entire system of non-crime hate incidents. The review has found that the current approach and use of non-crime hate incidents is not fit for purpose, and there is a need for broad reform to ensure that policing can focus on genuine harm and risk within communities. The recording of hurt feelings and differing views should not continue. A report has just been sent to ministers, and I'm sure they will respond in due course. But while I believe change is vital to restore public confidence and to ensure that free speech is protected, I would counsel against laying at the door of non-crime hate incidents all the problems of policing. The police are not spending their whole time policing tweets. The Metropolitan Police Commissioner has pointed out that non-crime hate incidents account for 0.05% of the calls they respond to. And a number of the high-profile and controversial cases about the policing of social media comment actually relate to hate crimes, offences which Parliament created for good reason. If we want to revisit those criminal offences, then that is a debate which we should have here. But in the meantime, the police have a duty to uphold the law. What I think we can and should expect is that the police will act proportionately, without fear or favour, and use common sense and professional judgment in the investigation of crimes. That judgment was obviously lacking in some recent cases. So a second key initiative, which I and the College's Chief Executive, Sir Andy Marsh, have instigated, will be new guidance on the exercise of that discretion, so that we can ensure that common sense decisions are taken and that confidence in the police service is not undermined.
My Lords, I very much welcome this bill, especially measures to tackle antisocial behaviour and shoplifting. And I'd like to thank my friend Lord Hanson for visiting Brixton just before the summer, where he met with local shop workers and local businesses, and we were very grateful for his time. I strongly support Clause 191, which seeks to decriminalise women who have to have an abortion. It was introduced by our colleague, Tonia Antoniazzi, who is with us here today in the chamber. It is not in the public interest for any woman to be prosecuted and given a criminal record in relation to her own body and her own abortion. In this day and age, we should not be vilifying and hounding pregnant women who often find themselves in deeply traumatic circumstances. I do not believe that any woman takes an abortion lightly, particularly at a very late stage. They need support, medical care and compassion, not the threat of prison. I'll tell you what I find embarrassing. This conversation and the tone of this conversation, it feels like we are back in Victorian times. It is absurd and wrong that in 2025 we are arguing that a woman should have the right or the agency to choose what she knows is best for her body and for her health. I also welcome the government's commitment to ending time limits of child abuse. At the moment, it is very, very difficult to bring a case if you are over the age of 21. That makes no sense, and it is a denial of justice, as it often takes many years before people who were abused as a child can speak about their abuse. But the government is only proposing this apply to sexual abuse. I would ask ministers to consider widening this to include physical and emotional abuse and neglect, which often accompanies sexual abuse. This is the approach taken in Scotland, and I think this is right. I hope that the ministers will also consult with victims of child sex abuse about how to make it easier to seek justice. We know from the grooming rape gang scandal how hard it is for young people to speak out and to be believed, and the devastating consequences of abuse. And I very much agree with lots of the points raised by Baroness Royal. But I would also really welcome what we heard from the Minister, who announced a pardon and disregard scheme for those girls caught up in the grooming gang scandal. I know that's something that they have been pressing for, and they will very much hope that that will happen. Finally, we know that much of the troubling increase in sexual violence and misogyny against women and girls is rooted in people, particularly young people, having unfettered access to extreme pornography. 90% of online porn, in fact, involves acts of torture and barbarism against women. 44% of our children have watched rape scenes online. This is poisoning minds and leading to violence in real life. So I very much support the amendments tabled by Baroness Burton to better protect children from online pornography, and I also appreciate the government's efforts to ban the depiction of strangulation. It is not right and it is not normal to teach our children that sex means inflicting pain on a woman. But that is what is happening, and we are allowing it to happen on the online screens, on the screens that our kids have in their hands every single day. I hope ministers can make some progress on these three issues through the passage of this bill. Thank you.
My Lords, there is much in this bill that can be supported. Many of the measures were, as we've heard, part of the Conservative Criminal Justice Bill that fell at the time of the last election. So on many levels there should be consensus. But this is a very large bill with many specific headings, many of which would merit a standalone bill in their own right. Our scrutiny will require time, as we have seen when considered by the other place, requiring 15 committee days, and we have been promised further amendments from the government. I hope the Minister will encourage his front bench to allow sufficient time for the level of scrutiny for which we in this House are proud. These are all important subjects. The government have said the bill will deliver its Safer Streets mission, and the early parts of the bill address, inter alia, offensive weapons, stalking, retail crime, and antisocial behaviour. Antisocial behaviour is complex, and we often use the term as an umbrella term. That is not good enough. As far as this bill is concerned, the public, and particularly the police, need clarity in this area where antisocial behaviour is not dealt with at a low level. Then, of course, it can turn to much more serious criminal activity, and that becomes the norm. We have only to look at the more recent change in retail theft, not a new crime, but one which has developed in a way which now requires us in this bill for stronger protection for retail workers, and I hope, as in clause 37 to 39, we're able to deliver that. My Lords, serious crime, knife crime, sexual abuse of children are in need of stronger enforcement. And as we progress with this legislation, I hope we will hear more about how enforcement is to be delivered. It is a fact, as the criminality evolves, so too we as legislators often find ourselves playing catch-up and somewhat behind the curve to keep up with the criminals. I think I've been in this house well over 30 years, well not this house, but the whole building over 30 years, and there seem to be enormous Home Office bills required almost in every session, but I think it's understandable why. We can't afford to stay still, the criminals don't stay still, and very often the technology aids and abets them. My Lords, I too, like many others, am concerned about Clause 191. Baroness Hazarika in her submission just now mentioned that a woman in this position would need many things, including medical assistance. From what I've heard today, I am not actually clear in my mind that if this was enacted, medical assistance would be lawful. And I do hope that we are going to give sufficient time to this clause and that the Minister will make sure that we have the information we need when debating this to make sure that existing legislation that is already on the statute book is weighed against what is being proposed in this particular clause. So, my Lords, I do support this bill. I'm sure there'll be one or two bits and pieces of which I've got issues, but nonetheless, this former Home Office Minister wishes it good speed.
My Lords, I'd like to talk about one specific issue in the bill, which has been referred to by Baroness Hazarika and Baroness Royal, which is the limitation period for child sexual abuse claims. Child sexual abuse is abhorrent, and unfortunately it's been shown over the last 20 or 30 years to be much more widespread than was once believed to be the case. It's always been possible for the victim of child abuse to sue the perpetrator, or more commonly the institution where the perpetrator worked or was closely connected, the limitation period being 3 years. There are exceptions, however, the most important and relevant of which is that time doesn't start to run until the claimant reaches the age of 18. Even after 3 years, there are various ways of extending the limitation period. Firstly, where a claimant did not have the necessary knowledge or awareness of the abuse, quite often relied on. But the most important extension was provided by Section 33 of the Limitation Act 1980, which gave the courts a complete discretion to disapply the limitation period. The section sets out in detail all sorts of sensible factors which guide the exercise of the discretion, but the discretion is in fact unfettered, so that other factors not listed can be taken into account. Although it's for the claimant to persuade the courts generally disapply the limitation period as it happens, unless there are particular circumstances where it would be unfair for the case to go on. I mean, noble lords might think, well, it would never be unfair for the victim of child sexual abuse to be deprived of a victim. And I have some sympathy for that. But the reality is that the claims are not against the perpetrators. They're against institutions, educational or religious, and those run by local authorities or government, where the abuse has taken place. The law on vicarious liability was changed by the courts so that an institution could not argue that the abuse was outside the scope of employment. The result was that compensation often had to be paid, sometimes even by the taxpayer or insurers, without any fault on their part. I should make it entirely clear that I have a relevant interest to declare. Over the years as a barrister, I have acted for institutions that have been sued for what is known as historic child abuse. I've also acted for victims, and I've been involved in a number of the cases which have reached the higher courts on the questions of limitation. My query to the government is essentially this: what was wrong with the existing law in practice, and how do the relevant provisions change it? My current view is that if these provisions become law, there is a risk of satellite litigation just at a time when the law seemed relatively settled. There are some cases where it's simply impossible for there to be any meaningful trial. For example, the claimant's own recollection may be very hazy, the perpetrators or alleged perpetrators of the abuse may be dead, there may be no records of any sort, and the relevant institution may have closed, and any insurance may be untraceable. The intention, presumably, and it's something of a compromise, this particular way that's framed in the bill, is to make it very difficult for the defendant to defeat a claim on grounds of limitation. But what sort of cases would now be in time which would not be under the current law? There are some other features which need to be raised at committee stage, some already referred to. What's the proper definition of sexual abuse? What about other forms of abuse which may properly be described as sexual? What if there are mixed abuse claims? There will also be uncertainty as to what constitutes, quote, settled by agreement, unquote. Does this include pre-litigation settlements? And what about claims that have been discontinued or settled informally? My current view is that the law is fair to both parties. These changes will breed uncertainty and litigation. Good for lawyers, but not a beneficial advance in the law. The proposed changes are not the result of a Law Commission report, nor the result of a large piece of legislation like the Limitation Act. Rather, they seem to be the result of a general recommendation from the ICSA inquiry and a rather modest consultation. This is not a good way to make law and will result in uncertainty and much litigation. In a wholly natural desire to help the victims of abuse, we should be careful not to make bad law.
My Lords, I'm grateful to Noble Baroness the Minister for the introduction of her bill, which has much to commend it. My Lords, earlier this year I indicated that I would retire in the spring. Aww. However, I am a politician and I didn't say which spring. But I really do want to retire, but I have one last parliamentary task to deal with. When I arrived at your Lordship's house in 1992, one of my areas of expertise was in road haulage operations, including abnormal load movements. In the late 1990s, the late and much missed Lord Mason of Barnsley worked tirelessly on seeking to replace the police with private, or rather self-escorting, of abnormal loads. This was because it was not a good use of police time, and in some cases, the police were not very good at it, although forces such as the Met were, and still are, excellent. A large part of the problem was that police priorities causing abnormal loads to have to wait a long time for a police escort, which was expensive for industry. At this point, I should declare an interest, as I operate a tank transporter for the Remy Museum, and I have given the Minister full details of this interest. My Lords, we succeeded in about 2002 when the then Minister of State for Policing, John Denham, changed UK policy, and henceforth the police would not routinely escort abnormal loads unless they were particularly large or traffic rules would have to be contravened. By and large, this policy change worked really well, and I'm proud of it. But about 3 years ago, some police forces decided to take a very close interest in heavy haulage operations. It is not clear why, because my understanding, based on discussion at retired senior traffic commissioner level, is that operators who conduct heavy haulage work are generally regarded as responsible, compliant hauliers who want to do it right despite the many challenges they face. There will, of course, be a small proportion of heavy hauliers identified who don't comply, just as there are always hauliers in all sectors who won't comply. But these are the exception and not the rule. With regard to the few forces involved, the most appropriate term would be persecution and harassment, and even of the largest and most professional operators in the land. I have emailed my report to many of your Lordships about my investigations. I urge your Lordships just to read page 3. Noble Lords will often ask me what is driving this behaviour. The short answer is money. Often the police officers who decide if the load needs a police escort are the very same ones who will pick up the overtime payments. Furthermore, over the last 5 years, the income for West Midlands Police, for instance, has increased somewhat. So year 1, 15,000. Year 2, 39,000. Year 3, 36,000. Are your Lordships sitting down comfortably? Year 4, 855,000. Year 5, projected using the 23-24 figures, 1.1 million. So we've gone from 14,000 to 1.1 million. The income profile of many other police forces has remained steady. So other comparative police forces, you're looking at about 30,000 a year. Some police forces, like Thames Valley, don't make any charges at all. My Lords, we have regulations about how much the police can charge for issuing a firearms certificate, and basically we screw down the amount that the police can charge so they can't do a proper job, but none about charges for escorting an abnormal load. There is NPCC guidance, but is predicated on policing events such as football matches. The police forces involved are charging for a minimum 6-hour shift, but using the same team to escort several loads within that shift. This cannot be right. It should be noted that a lot of the money eventually comes from government-funded projects such as HS2. I will be tabling amendments about this and quite a few others about abnormal loads because the relevant SDGO legislation is no longer fit for purpose.
My Lords, I thank the noble lady, the Minister, for her kind words about the new offence with respect to child sexual abuse image generators. But I actually wanted to take the opportunity myself to recognise the work of Specialist Police Unit who have worked alongside me on these and other issues. Working at the front line of child sexual abuse detection and enforcement is to come up against some of the most sordid and horrendous scenarios that can make you lose faith in humanity. So I wanted to put on record our huge debt to them for their courage and their commitment. I was also pleased to hear the Minister's commitment to criminalise pornography that depicts acts of strangulation and suffocation. This is one of a number of concerns of the noble lady Baroness Burton, which she will speak to shortly, and I shall be supporting her on all her amendments. During the recess, I chaired a meeting of extremely senior health professionals, and the prevalence of young people presenting in clinical settings suffering from violence and abuse during sex was simply horrific, with outcomes ranging from fear, trauma, to death itself. There is an epidemic of sexual violence normalised and driven by pornography, and I very much hope that the noble Baroness will have the support of the whole House on this matter. I have 4 other further areas of concern, and I'm going to touch on each very briefly. First, this House successfully introduced amendments to the Data Bill, the Data Use and Access Act, to empower coroners to require technology companies to preserve data when a child has died. At the time we proposed, but were refused, that preservation notices should be automatic and that statutory guidance should be developed. We now have the law, but bereaved families are still unable to benefit from its provisions because preservation notices are not being used quickly enough, nor are the powers fully understood. It is simply heartbreaking to see a parent who has just lost a child become a victim of a system that does not understand or use its own powers. And I will be laying amendments to make the new law work as Parliament was promised and it intended. Second, we have all seen media reports of chatbots suggesting illegal content or activity to children. I remain unclear about the government's appetite to strengthen Ofcom's codes or to resolve the differences of opinion between Parliament and the regulator about the scope of the Online Safety Act. Nevertheless, I will be seeking to ensure that AI chatbots which suggest or facilitate illegal activity are addressed in the Crime and Policing Bill. Third, as I've indicated, I welcome the CSAM generator offence already in the bill, but a gap does remain, and I will be tabling amendments to place clear, legally binding duties on developers of generative AI systems to conduct risk assessments, identifying if and how their systems could be misused for this narrow but devastating purpose. And finally, I am curious about the youth diversion orders. I am by no means against them, but I would like to understand if they are to be backed up by other support, such as autism screening and therapeutic support. Many at the front line of this issue say there's a serious lack of resource, and I would be interested to hear from ministers if how young people are to be supported once diverted, and if the government has plans to further look at the responsibility of tech companies who deliberately design for constant engagement, even if extreme content is being used simply as bait. My Lords, it is no longer possible to consider the online world separate from any other environment, and if we do not impose the legal order we require elsewhere, we continue to create a place of lawlessness and abuse.
My Lords, it's never an easy act to follow. But I want to thank her so much for my noble friend, the Baroness Kedron, for her work. And as they say, back at you. I will be supporting your work in this bill as well. I also want to welcome the noble minister to this House, what an asset I think she'll be, and also to the government. And I want to very graciously thank her and this government for the announcement around the criminalisation of depictions of strangulation. The law has to be well drafted, though, because the industry will find every loophole they possibly can. They're like water dripping through the cracks. And I'm telling you, they'll already be thinking about it because it's a very popular, very profitable genre. So I would appreciate some back and forth on that to make sure that we absolutely get it right, because it's a big bill. We don't want to spend time arguing over things that we basically agree with. Pornography, my lords, has long existed, and it's not going anywhere anytime soon. But its scale and its nature and its impact have changed dramatically. And today, free and easily accessible content, as many lords have already said, is increasingly violent, degrading and misogynistic. This is not a niche issue. Over a quarter of the UK population regularly accesses online pornography. A third of men say they watch it weekly, and the average age of first exposure is just 13. Technologies such as nudification apps designed to sexually humiliate are still legal and very prolific. And it's not confined to pornography sites. Violent sexual content is now present on social media, X being the worst offender, I would say, and mainstream platforms. Homepages of major porn sites display material with titles including words like attack, kidnap, force, violate. Mainstream search engines very quickly get you to thousands of videos with harmful titles such as "He overdid it and now she's dead," "Lawyer strangled, bound and gagged in a van." And these are the ones I can read out, and I'm pleased the little ones have gone from the chamber. Content involving incest and child abuse themes are also disturbingly prevalent. And the free-to-view porn business model has driven this extremity. This is rewiring how young people think about sex, gender and relationships. Toxic masculinity, we know, is rising, and experts warn of links between violent, viewing extreme pornography and committing sexual violence. Indeed, online porn has been described by one expert as the largest unregulated social experiment in human history. We discovered this during the review. The impact is far-reaching. Choking has now become a sexual norm. That is why the law does need to change. It will take a while to reverse this, though. Over 38% of women under 40 say they've been strangled during sex. Nurses reported to us dealing with sexually inflicted injuries on a very regular basis. Teachers reported pupils' confusion over what constitutes sexual assault, as well as increasing reports of sexual dysfunction among men who find real-life intimacy less stimulating than online extremes and leading to many, many relationship breakdowns. When I met with Giselle Capellico's daughter last month, she was adamant that online pornography played a role in her father's crimes. And Dame Angelini, in her inquiry, highlighted that Sarah Everard's murderer had a history of viewing violent pornography. Yet, despite the harm and the pace at which extreme online content has proliferated, legislation has lagged far behind. There is no external moderation, nor proactive monitoring. There is no one government department with overall accountability or responsibility. Laws are patchy and rarely enforced. And again, I'm delighted that one recommendation of 32 has been taken forward, but there's a lot more to do. And in stark contrast, the world of offline pornography, such as DVDs, is regulated by the British Board of Film Classification, which my noble friend Baroness Benjamin spoke to. So these amendments will absolutely do just that and will seek to reduce this imbalance in the law. It cannot be right that offline law would refuse to classify material which promotes or depicts child sexual abuse, incest, trafficking, torture and harmful sexual acts. This has to change. These recommendations and amendments will ensure not only the act but the depiction of incest and material that encourage an interest in child sexual abuse would be banned. It would also bring parity between material prohibited online and offline. It would also compel sites and platforms to verify the age and consent of anyone appearing on them. My Lords, this is not about ending pornography. It is about putting proportionate and necessary guardrails back in place. I don't naively stand here and think that these amendments will solve everything overnight, but I believe these changes could bring good, workable, enforceable law, which at long last is in step with technological developments and growing national sentiment. To our daughters, it would say there is no industry, no subculture that condones or excuses violence against them. To the porn industry and the ecosystem that it supports, it would say to them that they can no longer avoid accountability or scrutiny. And to our sons, who are also damaged in all this, regulating online pornography says to them that what they've seen on their screens is not normal, it is not acceptable, and it is not inevitable. And when we come to later stages, I urge noble lords in the government to support these amendments. Apologies for overrunning.
My Lords, the Minister, the Noble Baroness, Lady Levitt, should be congratulated for her extraordinary achievement in summarising more than 400 densely packed pages of legislation in 15 minutes, which I, by my mathematics, works out around summarising 25 pages per minute. So I think she set the bar pretty high, and I know that her friends on the government front bench will be looking very closely to see if they can follow on from that. My Lords, I would also like to follow my noble friend Lord Garnier, noble Lord Burt, down the perhaps unpopular opinion in this House of Legislation that the answer doesn't always lie in the statute book. And much of the antisocial behaviour type issues that we've been talking about in the early part of this very substantial bill are already illegal activities, they're crimes. So the focus of my remarks, my Lords, really is going to be much more on execution, delivery, performance and coordination than it is on the generation of new criminal offences, quite often of offences that are and activities that are already illegal. So, my Lords, I hope the Minister will accept that nothing I say today should be taken as a party political point or a criticism of a government of one flavour or another. My remarks are intended to address the performance of government as a whole under various different administrations and including all of the agencies involved, including the police. My Lords, I'd like to start off by saying that I certainly pay tribute to the police officers who protect us all. I think we're extremely lucky to have such a high-quality police force, and when there are failings, such as we've heard about, including from the noble Baroness, they're even more extraordinary because the overall standard is so high. But, my lords, despite that, public confidence in local policing has continued to decline. And one of the principal factors is that the public sees overt offending not being properly prioritised or dealt with. The cumulative effect of the de facto tolerance of street crime means that the public feels powerless and disenfranchised whilst lawbreakers are allowed to carry on without fear or sanction. And we've heard about, for example, the extraordinary prevalence of bicycle crime. I understand that the clear-up rate is 1%. 1%, my lords. So criminals, for 99% of the time, are getting away with it. And that is normalisation and tolerance of crime, and we cannot allow that to be the case. The noble Lord Hogan Howe, we all listen to so carefully on so many issues, and I find myself very much aligned with his view that if we see people riding obviously illegally powerful e-bikes, how does that affect those who go the proper route of purchasing registered vehicles with number plates, insuring, taxing, MOT, and being prepared to take the sanctions should they break the law? So, my lords, and never have I seen a policeman, never, and I walk a couple of miles a day around the streets of central London, I've never once seen a policeman stop one of these vehicles. My lords, there has been a lack of coordination and accountability has fallen between the cracks between central, local government and I believe 45 or so police forces. Just as a final note, my lords, is that really a sensible number in our modern digital age in our small group of islands?
Yeah. My lords, can I add my thanks and welcome to the Minister for her introduction to the bill, and can I also thank my noble friend Baroness Ducey for setting out the Liberal Democrat stall so cogently on both policing more generally and on this bill, my lords. On these benches we recognise the imperative to make our streets safer and equip the police with the tools necessary to address modern crime. We support the elements of the bill that tackle knife crime, combat online child exploitation and pursue criminal proceeds. However, the foundation of our approach to public safety is our demand that new laws should not just be tough but fair and proportionate, and we reject measures that risk the erosion of civil liberties or the criminalisation of the vulnerable. A core priority for me and my party is ensuring that our legal framework is modernised and future-proofed against evolving digital and online threats, as my noble friend emphasised. We support the new measures concerning the online supply chain of offensive weapons. We welcome the introduction of civil penalties aimed at strengthening accountability for businesses and online platforms involved in the advertising or selling of unlawful weapons. To enhance police intervention capability, we will, however, propose an amendment mandating a proactive, real-time system for reporting under the new duty to report bulk or suspicious sales of bladed articles to the police. The current cybersecurity landscape is, however, badly hampered by outdated legislation. The Computer Misuse Act 1990 is now 34 years old, stemming from a time before widespread internet access. It inadvertently criminalises legitimate cybersecurity activities, such as vulnerability research, which are essential for national security. And we also call for the introduction of a statutory public interest defence within the CMA 1990 to decriminalise the vital work of cybersecurity professionals and provide clearer legal protections. Furthermore, to combat organised crime and address widespread online fraud, we want to see the creation of a specific criminal offence for digital identity theft. This new offence must target the unauthorised obtaining of personal or sensitive information, such as passwords or biometric data, with a clear intent to impersonate an individual for unauthorised activities. We support new online child protection offences targeting AI-generated child sexual abuse material and enhanced border force powers to compel device unlocking for CSAM searches. On extreme pornography, we will be strongly supporting amendments to be tabled by the Noble Baroness Burton following her review, extending the online definition to explicitly cover incest pornography and material depicting adults acting as or depicting children. And we want to see robust safeguards against the inappropriate use of intrusive technology. We oppose the police's use of live facial recognition, surveillance in public spaces without a statutory framework, given concerns regarding privacy and algorithmic bias. Deployment of LFR should be explicitly authorised by a judicial warrant and governed by a statutory code of practice, complete with an independent oversight body. On antisocial behaviour measures, accountability and fairness are of crucial importance. New respect orders must be subject to rigorous democratic scrutiny. Applications need to undergo full public consultation and should be approved by the relevant full council or its executive or cabinet before implementation. My Lords, we're opposed to the punitive increase in fixed penalty notices for breaches of public spaces protection orders and community protection notices from £100 to £500. This sharp increase risks intensifying abuses and arbitrary enforcement against the most vulnerable individuals, and we will continue to protect the fundamental right to peaceful process. My Lords, on these benches we will seek to amend this bill to ensure it's rooted online and offline in accountability, proportionality and the protection of civil liberties. We must ensure that this legislation is fair, effective and fit for the future.
My Lords, I also support much of this bill. The Home Secretary introduced this bill to drive her government's Safer Streets mission, to halve violence against women and girls in a decade. So I welcome tightening the law in clauses 84 and 85 around voyeurism and criminalising exposure intended for sexual gratification or humiliation. Despite the Supreme Court disallowing biological males from using women's changing rooms and spaces, this still happens in many contexts. Not all are motivated by voyeurism, already a crime, or to expose themselves for sexual gratification or humiliation. But we shouldn't turn a blind eye to these possible motivations. Consideration should be given to them. Can the Minister confirm this new law will protect women and girls whilst everyone catches up with the Supreme Court ruling? Clause 147, extending polygraph testing to more offenders, including those posing a risk of committing certain sexual offences, should shore up protection against predation on women and girls. If technology helps us manage sex offenders more smartly, let's use it. However, Clause 191, as we've heard much today, cuts across this bill's protections against predation. Despite risks to women, this clause, intended to transform our societal approach to abortion, was appended in a rushed, emotive way in the other House. My Lords, there is a pattern here. Safe access zones around all abortion clinics were also hurriedly appended to the Public Order Act in the Commons. This despite testimonies from women now with grown-up children, whom they were very glad they decided not to terminate after talking to caring and compassionate people outside clinics. Once such measures appear in legislation, they acquire an unassailability on the grounds of care and compassion for women seeking abortions. Clause 191 repeats the same pseudo-virtuous stitch-up. A short discussion in the other House during report stage of a bill that has absolutely nothing to do with abortion, and the assumption that all fair-minded people should agree to it. Those who don't can just be dismissed as reactionaries because abortion is treated as an unlimited good in our topsy-turvy moral universe. Whatever we each individually think about abortion, the laws of this land and a wide range of other considerations are being ignored or twisted out of shape to meet the insatiability of extreme bodily autonomy. Safe access zones sacrificed freedom of speech on that altar. Clause 191 shreds women's criminal responsibility, and with it a vital protection for her against a partner or family member coercing, predating upon her to have a late-term abortion. Bringing about her own late-stage termination of a baby that's been kicking, hiccuping, and otherwise moving in utero will leave a long tail of effect on her life. Decriminalisation is only caring and compassionate in a very narrow and short-term way. This House will discuss ramifications of allowing terminations up to birth, but the only fit place for Clause 191 is the cutting room floor. My Lords, I will end by apologising on Baroness Gaudier's behalf for not being here today. She will table amendments against trafficking for sexual exploitation to outlaw lucrative UK-based pimping websites which enable traffickers to advertise their victims easily and ply this vile trade.
Having nodded along to those who complained about the length and diverse nature of this bill, I'm going to propose 5 modest additions to it, which in entirety would take up less than a page extra to add to the 400 that the bill already contains. These are measures which are related to the review I carried out in my capacity as the government's former independent advisor on political violence and disruption. A review which had such a profound impact on the last government that the Prime Minister called a general election 24 hours after having published it. So this is the first legislative opportunity to enact some of these measures. And this is a timely moment. The Prime Minister rightly stood up after the Heaton Park Synagogue murders and said that he would do whatever it takes to keep the Jewish community safe. And there are a number of measures in this bill that will help protect vulnerable communities and individuals such as Jewish people, again, in this increasingly dangerous and intimidating environment. And better balance the right to protest, which is indeed fundamental, with the rights of the wider rights of communities and individuals to live their lives free from disruption. But it must go further in a number of key ways. First, on cumulative impact, where the focus of the Prime Minister and Home Secretary is welcome, looking at the harm which has been done to Jewish communities in particular from the weekly marches, repeated marches that have taken place, which have made many areas seem unsafe for Jewish people. But the commitment made so far, which is to add cumulative impact into sections 12 and 14 of the Public Order Act, it already exists, unless the Minister can explain to me how it will be extended. And the important thing is to add the cumulative impact into section 13 of the Act, which enables the police to recommend to the Home Secretary that a procession should not go ahead on particular days. Simply amending the precise route or the timing is not going to be sufficient. Now, I don't want to go over my time, so let me race through the other measures. 2, protecting police resources. The government should consider adding into section 12, 13 and 14 the difficulty of police being able to resource repeat marches and the effect that this is having on other key areas. 3rd, protecting our democracy where the very welcome strengthening of protection to places of worship should be added, places that are central to the functioning of our democracy, such as council offices and MPs' offices. 4, enhanced powers to tackle extreme protest activity, however anyone comes down on the issue, for example, recently of Palestine Action, it was a nonsense that it took 5 years of them being able to carry out crimes and advertise them until they reach the terrorism threshold. So I hope the government will consider my proposal of an extreme protest activity order, and then finally clearer statutory measures to prohibit public funding going to bodies that such as NECAP, who received a public grant which could not be taken back by the government, despite their promotion of criminal activity and undermining of democratic governance.
My Lords, I will use my time to focus on the protection of women and girls, and the first issue I wish to raise is honour-based abuse, a crime motivated by the perpetrator's perception that an individual has somehow shamed or may shame a family or community. These crimes, which include devastating honour-motivated killings, female genital mutilation and forced marriage, have happened in the shadows for too long. And it's been pointed out that there is a lot in this bill, but honour-based abuse is not currently mentioned. I'm not suggesting a new offence, but I want to ask the Noble Lord the Minister whether he will incorporate a statutory definition of honour-based abuse into the bill, with language strongly supported and agreed by survivors and the groups and charities that work with them, alongside issuing formal guidance to ensure understanding and consistency across agencies. Offences related to honour-based abuse continue to have the lowest conviction of all flagged crimes, and it remains hidden, misunderstood and under-prosecuted. Far too often, cases are misidentified or inaccurately recorded, which obscures the true scale of the problem and limits the protection available to victims. And collective and family involvement is not consistently recognised in investigations, and courts are left without a clear framework to identify and address honour as a motive. A survivor-led and sector-backed definition has already been developed, which recognises the role of collective perpetration, honour-based motivations and the powerful silencing effect of shame. And this definition would provide a consistent basis for identification, recording and intervention and effective protection for those at risk. I also intend to raise whether the government will consider adding honour as an aggravating factor in sentencing, which would ensure that honour-based motives are formally recognised by the courts and better reflect the gravity and broader societal impacts of these crimes. The announcement in August that the government does intend to introduce a definition and accompanying guidance was hugely welcome, and this change has been campaigned for many years by many people, including Yasmin Javid, whose daughter Fawzia was so tragically murdered in the name of honour. The bill provides the earliest legislative opportunity to act on that commitment, so I hope that the Minister will be positive in his response. On other issues relating to women and girls, I fully support my noble friend Baroness Burton's work on regulating online pornographic content and hope that the government will take the opportunity to deliver many of her recommendations in her powerful report on creating a safer world. And I also support my noble friend Baroness Owen in her ongoing work on image-based sexual abuse. Finally, my Lords, I turn to Clause 191 on the decriminalisation of women in relation to abortion. Noble Lords will have received much correspondence on the subject, and I want to use this time to clarify what Clause 191 does and what it does not do. Clause 191 removes women from the criminal justice system, meaning they will no longer be investigated or prosecuted for having an abortion. What the clause does not do is make abortion legal up to birth. There is no change to the 24-week limit. There is no change to the 10-week limit on telemedicine. Abortions would still require 2 doctors' signatures to be legally provided. Women would still have to meet one of the grounds laid out in the Abortion Act 1967. And importantly, non-consensual abortion would remain a crime at any gestation. Abortion outside these limits remain illegal, and anybody, including a medical professional, who assisted a woman in obtaining an abortion outside of this law would be liable for prosecution. The reason this clause has been introduced is because more than 100 women, many of them vulnerable and abused, have been investigated by police in recent years, and these investigations have taken many years, and those investigations themselves can prevent them from getting the health care, the mental health support, and the referral to appropriate support services that they need. My Lords, I appreciate the Noble Lords want to discuss this clause in more detail in committee, and I very much welcome that. It's supported by leading medical organisations, and I encourage interested Noble Lords to read what they have to say. I also wanted to highlight that decriminalising women in relation to abortion is not unusual. It would bring England and Wales in line with Northern Ireland and over 50 countries worldwide, including Canada, Australia, New Zealand, and over 31 European jurisdictions, and indeed the United States, where women can never be prosecuted for having an abortion. Those countries have laws that criminalise those who provide an abortion, and that will remain the case here.
It was a pleasure to follow the noble Lady Baroness. Congratulations first to my noble friend Lord Hanson of Flint on securing the considerable legal services of my noble friend Baroness Levitt. The government's very lucky to have them both steering this supertanker. There is much to commend its focus on several vulnerable groups, including exploited children, victims of stalking, cuckooing, and so on. And I hope to speak to these parts at committee. There is further scope, I think, to innovate in other areas genuinely to improve criminal justice. Still, I have some concerns about an arms race begun over 30 years ago and escalated by some parts of this measure. Lords, the Criminal Justice and Public Order Act of 1994, you're too young to remember, began raising public expectations that governments could legislate their way to a harmonious society. Politicians purported to do this even in times of austerity amidst real-time cuts to living standards in the justice system, as well as youth, mental health and addiction services. Continued rhetorical attacks upon the judiciary and fiscal attacks on legal aid have left swathes of ordinary people thinking that the law is not for them. It will arrest and prosecute them for a growing array of crimes and misdemeanours, but rarely protect them from abusive employers, landlords or unaccountable corporations. That's why I welcome the imminent Hillsborough law. The disillusionment can be disastrous. Knee-jerk politics fights the alligators but never drains the swamp. And I fear that we've been breeding alligators in a swamp in which only populist far-right politics thrives. We see this long shadow in compromises to due process rights, the unregulated deployment of technology at cost to personal privacy, and always more police powers. Every year, yet more powers, broad, vague, and never mirrored by measures improving police vetting, training, and discipline. In 1994, it was the end of the right to silence, suspicionless stop and search, and restrictions on gatherings featuring music with a repetitive beat. Now and for years, the target has been non-violent protest. I share the Council of Europe Human Rights Commissioner's concerns about our existing public order statute book, measures proposed in this bill, and those trailed as likely new government amendments to come at committee to restrict cumulative protest. Protests against asylum hotels, my lords, make me very anxious. But I would no more ban them than those against job losses, benefit cuts, environmental degradation, war crimes, or racism and anti-Semitism. What would blanket bans on face coverings at protests mean for dissidents outside the embassy of an authoritarian foreign power? With all its churches, restrictions on protesting in the vicinity of places of worship could render our capital an extremely un-British protest-free zone. Recently, ministers have rightly warned of the existential dangers of a far-right administration. My lords, we must never write, let alone legislate for, a blank cheque for potential future anti-democratic abuse. So while today is one for broad brushes and 4 minutes, I hope noble lords will come prepared for line-by-line forensic scrutiny of bill and amendment text in the vital weeks to come. Lords, the other place may invoke the will of the people, but here we read the small print.
Well done, well done. My Lords, I'm grateful to the clerks, the whips, and to the noble Lord, Lord Jackson of Peterborough for allowing me to change my place in the running order. Let me declare my interest as the chair of Common Sense Media in the UK, a US not-for-profit that campaigns for children's safety on the internet. I had to briefly step out of the debate because I wanted to take part in a debate on music education in the Moses Room. And that allows me to continue a tradition that I've set up for myself to always shoehorn the arts into any debate that we have here. And to a certain extent, I can echo the excellent sentiment behind the Noble Baroness Chakrabarty's speech. There's an interesting theme developing, I think, during this debate, where there is a sort of undercurrent, I think, coming from many noble lords, that do we need endless pieces of criminal legislation? Do we narrowly focus down on the specifics that happen to exercise the public mind today, or the political mind perhaps, and miss the big picture? And I have long campaigned for the importance of the arts in the criminal justice system, and of course the importance of the arts in our society in helping people to find interests and ways of expressing themselves that contribute to the harmonious society, which I completely agree with the Noble Baroness it is impossible to legislate for. And I know that the Noble Lord Timpson does so much incredible work as Prisons Minister and in a previous life in promoting the use of the arts in this way. I was very struck, I have to say, by Lord Garnier's speech earlier in this debate, which I think set this tone about this constant recourse to legislation. And I was reminded that when I first became the Arts Minister, I inherited the Digital Copyright Act and the new legislation to prosecute people who downloaded illegal music. And I thought that going after teenagers in their bedroom was a fool's errand. There would be a technology solution, but also the music industry found a solution by using existing legislation. They used the 1988, I think it was, Fraud Act to prosecute the big websites that were ripping off music makers, and in that way they started to get things more on an even keel. And it's long been a sort of slightly bizarre obsession of mine why we don't have, as it were, a criminal code in this country, one piece of paper, as it were, that lists the criminal offences that would allow the government of the day to do exactly what Lord Garnier was speaking about, to actually cross-reference whether the offences that they're now bringing into law do already exist, or whether there are existing offences that could cover the current passion. For example, I bow to no one in wanting to defend retail workers from attacks from increasingly aggressive shoplifters, but I want to prevent everyone from being attacked in this way. Do we need a specific offence for retail workers, or does this merely clog up the system? And indeed, to a certain extent, legislation like this misses the big picture. The Noble Lord Viscount Goshen referred to the merger of police forces. That is long overdue. And we've also referred in this debate to clogged cases. And having said all that, of course, let me now do a reverse ferret, channel my inner Lord Wolney, if you like, and say that I also wanted to speak in this debate to offer my unequivocal support to Baroness Burton. She and many other noble baronesses and noble peers have done incredible work in bringing the criminal statute book up to date in terms of the way technology has fundamentally changed how pornography is used and has fundamentally impacted the lives of young people. And anything that can make that more coherent and allow us to have greater powers to crack down on this great technological scourge, I will support.
My Lords, there are a great many aspects of this bill with which I agree, and my understanding of it has been greatly enhanced by today's debate. I am uncomfortable, however, with clause 191. Decriminalising abortion up to birth for women clearly marks a significant shift in the law on abortion in the UK. Over the coming months, we'll hear many arguments about clause 191, drawing on the diverse expertise of this House. But I wish to focus on 3 points: parliamentary procedure, unanswered questions, and the Salisbury Convention. On the first point, it should be noted that clause 191 has received precious little parliamentary scrutiny. By way of comparison, consider the level of scrutiny that both houses have given the Assisted Dying Bill. That bill had more than 100 hours of debate in the other place. Clause 191, in contrast, had just a few hours. That bill had an impact assessment of more than 150 pages. Clause 191, in contrast, is not covered in the Crime and Policing Bill's impact assessment. and up-to-date information is not published on how many abortions take place through the Pills by Post scheme. So if the assisted dying bill has not been sufficiently scrutinised, as many have suggested, then clearly the scrutiny of Clause 191 is insufficient. Secondly, decriminalising abortion raises a plethora of unanswered questions, and often when questions have been asked of the government, they've received weak replies. For example, the noble lady Baroness Foster of Agadrumsey, who's not in her place sadly, tabled the following pertinent written question on the 6th of October, which is worth quoting in full. To ask His Majesty's Government what assessment they've made of the potential risks to vulnerable women, including those who may be subject to coercion or abuse if abortion were to be decriminalised, and what safeguarding measures they plan to put in place to protect them. A very sensible question. Sadly, the government's response on the 10th of October did not inspire confidence. It began simply, and I quote, "No assessment has been made." I question how we're meant to vote or indeed debate Clause 191 when no assessment's been made of the consequences. It clearly needs much more scrutiny than it's received thus far. Finally, it's worth noting that the Salisbury Convention does not apply to Clause 191 because this proposal was not included in the government's manifesto last year. This omission is perhaps unsurprising, as it does not command the support of the public. Polling from Ipsos earlier this year indicated that 63% of people support the status quo of 24 weeks. And polling from Whitestone Insight in May showed that 62% of voters agree that having an illegal abortion should continue to be a criminal offence. In this House, we rightly pride ourselves on our commitment to scrutinising legislation clearly and effectively and providing the necessary time to challenge how legislation will be implemented. I know that noble lords will be tabling amendments to Clause 191 at committee stage. I'll be looking closely at these amendments to ensure the clause receives the level of scrutiny it merits for the profound impact it would have on society.
My Lords, economic crime, in particular fraud, is now the leading form of UK crime, and together with money laundering and bribery, costs the UK billions of pounds each year. This also undermines public trust, public confidence, and also economic growth. The good news, my Lords, is that enforcement against these economic crimes and associated confiscation of assets, while complex, generates substantial receipts, some £566 million per year currently. And yet, my Lords, while we entrust the police and other law agencies with more and more tasks, mostly both difficult and vital, the very agencies responsible for securing these funds from criminals face acute resource challenges, particularly in recruiting and retaining specialist staff, updating skills, and modernising ageing IT systems and capabilities, as a number of other speakers across the House have referred to today so powerfully. I suggest to the House, and not for the first time, that those enforcing the laws we so carefully create and pass here must be properly resourced to enforce them. An obvious means of doing this would be to use the confiscated criminal assets via a ring-fenced fund to resource the agencies concerned. There are two existing schemes in this area. The Economic Crime Levy is an annual charge on UK businesses regulated under the money laundering regulations. This private sector contribution could logically be matched by greater reinvestment of enforcement receipts. The current Asset Recovery Incentivisation Scheme, ARIS, is subject to the curiously named annularity rules, which means that money not used by the year end, which is sometimes just weeks away from when the money is obtained, is lost. A ring-fenced fund would enable stronger agencies, which would then deliver greater asset recovery and confiscation, which reinvested into the fight against economic crime would establish a virtuous circle of self-financing investment and effectiveness. Beyond the obvious capacity and effectiveness benefits from such targeted resources, a ring-fenced fund would demonstrate to working people that the government is exploring all avenues to crack down on economic crime. And, my Lords, There is a certain fiscal poetry here. Not a phrase one hears very often, I believe. In that this would all be achieved without adding to anyone's tax burdens, but instead by making the criminals pay, a form of polluter pays, if you will. My Lords, in the House of Commons, an amendment to this bill was put down to require the government simply to investigate the viability of such a ring-fenced economic crime fighting fund using a proportion of the assets that I've referred to. This cross-party proposal secured broad parliamentary support in the House of Commons. It was signed by 28 MPs from Labour, Conservative, Liberal Democrat and Green parties at report stage in the Commons. Unfortunately, there was insufficient time to debate the amendment, but there were productive conversations with the relevant ministers. Just to underline again, my Lords, the amendment did not suggest, and I do not suggest, that the bill is used to establish such a fund, simply that its viability is investigated. I have already shared with the Noble Lord the Minister these ideas, and indeed a draft of the amendment. I look forward to hearing the Noble Lord the Minister's thoughts on this subject when winding up this debate, and I would also welcome a meeting to discuss it with him.
My Lords, we live in an age where pretty much all of us carry in our pocket the means to access pornographic content so extreme that it would be illegal for any shop to sell it to any adult anywhere in the country. And until very recently, children have had ready access to this extreme content. As the Noble Lady Hazarika said, and it bears repeating, 44% of children see depictions of rape in pornography before they turn 18. I think everyone in this House would accept that since the early 2000s, there has been a huge change in who sees pornography and what pornography they are seeing. However, by and large, the regulatory framework has not changed. It is not designed for the digital age, it is not designed for the smartphone age, and it is certainly not designed for the age of AI, where anyone can generate a pornographic image in seconds. My Lords, our legislation must catch up. The provisions in the Online Safety Act and the Data Act are an important first step, but more is needed. While running the No. 10 policy unit for Rishi Sunak, I pushed for an independent review to look at the problems associated with online pornography and to advise the government on what could be done. That review was established in 2023, and my noble friend Baroness Burton was appointed lead reviewer. I'm extremely glad that the current government shared our concerns and continued to support the work of the independent review, which, as we've heard, published a comprehensive and shocking report earlier this year. It's thanks to my noble friend Baroness Burton and her team that we now have a much clearer understanding of what's happening online and the impact it's having in the real world. As she set out in her earlier speech, our failure to regulate online pornography has facilitated an industry that is increasingly violent, degrading, and misogynistic. It's an industry which directs users towards ever more extreme content, and in doing so, it's changing attitudes and fueling violence towards women and girls. Indeed, almost every month seems to bring fresh evidence on the damage being done to children, to women, and to those viewing this harmful content. Content which goes unchecked because we have failed to apply our existing settled laws and regulation to the online world. In the pre-internet age, we had a broadly effective mechanism for regulating pornography through classification. We balanced the rights of consenting adults with the need to protect society. For over 40 years, legislation has ensured that pornographic videos are regulated by the British Board of Film Classification. Depictions of illegal activity such as rape and harmful activity like violent sexual activity are banned. However, this regulation has never been extended to cover online pornography. My Lords, there is nothing rational about a system that says content is illegal and harmful when watched on a DVD, but legal and permissible when watched on the internet. If we still believe that it's wrong and harmful for adults to watch depictions of incest on video, Blu-ray or DVD, how can we believe that that content should be readily available online? In this bill, the government has a chance to act decisively, and I'm extremely grateful for the commitment to bring forward an amendment to ban depictions of strangulation and suffocation in pornography. That's an important start, but during the passage of this bill, I hope the House will agree to go further. My starting point is that we should apply the same standards to films that are distributed online as we already do to those that are distributed offline. It raises legitimate questions of enforcement and regulatory capacity, and those are valid concerns, and I hope that we'll debate them at committee stage. However, I do not believe it should raise concerns about freedom of expression.
After all, I'm simply proposing that we apply and enforce our existing standards consistently. Unless, of course, some would like to argue that our current laws for offline pornography have indeed been stifling our freedom for decades and should now be relaxed, in which case I look forward to debating that too. My Lords, I know that regulation in the digital age is not straightforward, and having spent many years in government, I have every sympathy for the current government, who may well think this is simply too hard to do. It is hard to do, but I would say to them it's too important not to do, which is why I will be supporting the amendments in this space, including those from my noble friends Baroness Owen and Baroness Burton.
Yeah. My Lords, I wish to address 3 issues. Firstly, the long-awaited duty of mandatory reporting of child sexual abuse, a key recommendation of the independent inquiry into child sexual abuse, but with a strengthened and more encompassing base, and a key issue supported by the NSPCC. This mandatory provision is born of tragedy. It reflects too many cases where children found the courage to speak, and yet nothing was done. But whilst the principle is right, the drafting as it stands is too narrow, too timid, and risks being ineffective in practice. First, the duty to report is triggered only when a disclosure is made or abuse is witnessed, yet most abuse is not disclosed, and rarely is it seen firsthand. And professionals in health and education and faith settings often encounter warning signs, not confessions. The duty must extend to situations where there are reasonable grounds to suspect abuse. Secondly, the bill currently imposes no real sanction for failure to report, and a law without consequence is not a law that can change culture, and there should be a clear offence for deliberate failure to act when a child's disclosure is known. Thirdly, there is a risk that the present wording could sweep in minor consensual activity between young people or undermine trust in health services, and that must be corrected because the duty should target exploitation and coercion, not teenage relationships or confidential medical advice. Fourthly, implementation matters, and we will need proper training, triage mechanisms to prevent over-reporting, and resources for local authorities and police to respond swiftly and sensitively. The second issue is that we need to introduce a penalty on the intention to conceal, because all too often the orthodoxy is for individuals to feel a pressure to protect the organisation which they serve, too big to fail, and individuals are too scared to report, and individuals who are protecting their institution must risk penalty. My third issue is that when I served in the Home Office, I had the privilege of introducing and funding the Ugly Mug scheme. The principle behind it was not controversial. When a sex worker experiences violence or a threat, it enables them to report it anonymously, and so others are warned. And that information is their only line of defence, and it has saved lives since it was introduced, prevented repeated attacks, and encouraged people who would never otherwise go near the police to start trusting them again. New Clause 1, as moved in the Commons, directly implicates online platforms and intermediaries that currently help sex workers publish adverts or manage listings, because that's one of the main ways that the Ugly Mug scheme engages, through alerts, listing of known bad actors, and facilitating reporting. And it has been truly successful in helping protect sex workers from dangerous clients. And whatever one's view of prostitution, no one should be assaulted, raped, or murdered for the work they do. Ugly Mugs was never about endorsing prostitution, it was about reducing harm and preventing homicide. And the evidence is clear. Where harm reduction schemes exist, sex workers are better able to report violence, share intelligence, and access justice. Where they are removed, people go underground, and it is a dangerous illusion to think that by abolishing tools that keep people safe, we abolish the reality of prostitution. We do not. We simply make it more dangerous. My Lords, the duty of any government, whatever their moral stance, is to protect life and prevent violence. Ugly Mugs does precisely that, quietly and effectively, and at very modest cost. Closing it would not advance women's safety, it would imperil it.
Yeah. My Lords, there are necessary provisions in the bill, but there is also window dressing. Thus, while we all deplore assaults on shop workers, we don't need this new measure. There are good laws of theft, robbery and assault. What we lack are the resources to arrest and prosecute. Last night, the Metropolitan Police announced that London will be left with just 2 police stations with front counters operating 24 hours a day. 10 more are set to close under cost-cutting measures. That is not good enough. Today's Times reports that family drug and alcohol courts face closure, yet each such court saves local authorities £58,000 in care costs and £15,000 in legal costs, each such case. Instead of chasing headlines, government should be funding the police, the CPS, those on legal aid and the courts properly. The Department of Justice has been starved of money by the previous government, I accept that, and is not being helped by the current one. Clause 39 is well-intentioned. It will show shoplifters who regularly steal low-value goods that this may be treated as a serious offence triable in the Crown Court. But it's important, really important, that only the prosecutor and not the defendant can go on to elect Crown Court trial. If not, our Crown Courts will be overwhelmed. Backlogs are already years long. I welcome the measures in Part 8, which are directed at electronic devices to steal cars. These are necessary and overdue. The measures to address so-called SIM farms are also to be welcomed. I agree entirely with what the noble Lord Folkes has had to say about the changes proposed under Clause 82 to the law of limitation. These are unnecessary and will be unhelpful. Finally, I turn to Clause 191 to the decriminalisation of abortion. I make it plain, I'm not in principle opposed to abortion, but there was no prior scrutiny, no public consultation. The benign intention, because I accept the benign intention, of not criminalising a woman who aborts her own child, risks new evils. Women may be harassed into abortion without the safeguards of the current law, and a woman will be permitted, without medical advice, to abort a baby right up to due birth date. Right up to due birth date. Just think about that. It is a human being at that stage, on any measure. And what if the baby survives but is damaged? Will they sue the mother? I agree with what my noble friend Lord Elliot of Micklefell has had to say about this provision. We must look at it very carefully. Such an important change to the law regarding human life should be based on proper inquiry and evidence, and then, if necessary and appropriate, measured change in measured circumstances to the Abortion Act 1967. To wind up, my lords, 240 seconds to debate 400 pages is not very much. At committee, we must be allocated proper time. It is likely that more baubles will be added to the Christmas tree. Thank you.
I welcome the noble lady, the Minister, to her role, who introduced this large bill with admirable clarity. The need to address mandatory reporting of abuse of children is urgent, but this bill should go wider than sexual abuse, because the criminal exploitation of children is associated with all types of abuse. As physical abuse occurs, the abuser tends to use the loophole initially to claim it's reasonable chastisement and to avoid action being taken. Yet this is linked to increasing violence, sexual abuse and emotional exploitation. Such abuse and driving children to crime can happen within the home. The perpetrator grooming and using and abusing a child is not always from outside the home. The child, deeply disturbed, is pushed into criminal activity, which escalates from relatively minor offences to very serious crime with frightening speed. There is an urgent need to ensure that children are protected from ongoing exploitation. These children are subject to significant threats, such as that they or their family will be killed, Some have acid or heat burns, are scalded or stabbed, all as ways of intimidating. 90% of these children do not disclose who's abusing them. The child is terrified. They cannot protect themselves. Many struggle with the idea that the child is both a victim and a perpetrator at the same time. When it comes to the use earlier on of this loophole of claiming reasonable chastisement, I think it's important to remember that bruises do not show on skin of colour. Children need equal protection from assault and battery, just as adults have. That loophole needs to be closed. The exploitation of children with the criminal exploitation of children protection orders is long overdue. It will provide protection of the child, allowing services to intervene earlier and disrupt the business model of criminal gangs that are controlling these children, which even often continue to operate from inside prison at times. But the defence for the perpetrator of reasonably assuming that the young person is over 18 leaves the door open to victimising teenagers without protection. We mustn't think that by only requiring mandatory reporting of child sexual abuse, we will be adequately protecting children. And on a completely different subject, if we are to protect all on our streets, we must lower the drink-drive limit to 20 milligrams per 100 mils of blood. To leave it as high as it is leaves lives endangered every day.
My Lords, I am deeply concerned about the process, or lack of it, around Clause 191, which was tacked to the end of an unrelated bill via a backbench amendment with just 46 minutes of backbench debate. Many MPs wanting to speak were unable to do so. This is not a responsible way to make law. As many other noble lords have said, I fear there would be an increase in the number of late-term abortions with no medical supervision whatsoever, particularly as women continue to be able to obtain these pills through the post without an in-person consultation. This came in during the special circumstances of the pandemic, but it has not been rescinded as it should be, even though we are no longer in such a health emergency. Recent figures show that 54,000 women were admitted to NHS hospitals in England for the treatment of complications arising from the use of these abortion pills, a 50% rise from the figures before the pandemic. Analysis of accredited official statistics published by NHS England and the Office for Health Improvement and Disparities shows that 1 in 17 of all women self-managing their abortion at home will subsequently be admitted for hospital treatment. This clause will scarcely improve that. I fear two things. One, that we are creating a modern-day equivalent of backstreet abortion. And second, that it will assist the coercion of women into late terminations by coercive and abusive partners. They could just argue that this is legal now. But this clause would also remove the vital protection for unborn babies mature enough to survive outside of the womb. There is no popular demand or pressure for this form of infanticide. And if the public were made fully aware of this, I'm sure that the great majority would regard this clause not as progressive but barbaric. I am profoundly worried about this clause and will be seeking to address it in committee.
My Lords, this bill presents a unique opportunity to close long-standing accountability gaps in the UK's universal jurisdiction laws and will ensure, if the amendments were received, ensure that perpetrators of the world's most serious crimes can be brought to justice on British soil. The House has heard me on a number of occasions advocate for a review of the universal jurisdictional laws as they operate in this country. Now, many of you may ask what universal jurisdiction is all about. UK courts can prosecute certain international crimes under the principle of universal jurisdiction. It's a legal framework that allows states to pursue justice for the most serious offences committed abroad, even when the case has no direct connection to the UK. These crimes include genocide, war crimes, crimes against humanity, and torture. Universal jurisdiction reflects the global consensus that such crimes are so grave that they demand accountability wherever they occur. However, there's a certain problem here in the United Kingdom in that our organisations who are involved in human rights have seen over and over again ways in which failure to prosecute takes place because we require residency and nationality as a requirement, so that a person who's present in the UK, sometimes coming to speak at a conference, sometimes coming to find a university for one of their children, but they can't be prosecuted because they are not a British national and do not perhaps have residency in this country. At a time when such crimes, grievous crimes, are rising globally, reform is necessary. And it would uphold the rule of law, enhance national security, and help build safer communities both at home and abroad. And we are renowned worldwide for our commitment to the rule of law. Britain probably leads the world, and yet there is this serious gap. At present, the UK's ability to prosecute grave international crimes under universal jurisdiction is severely limited, as I've just said. And it was under the International Criminal Courts Act that it was declared that prosecutions can only be brought for genocide, war crimes and crimes against humanity where the suspect is a UK national or resident. It means that individuals accused of serious international crimes enter this country and they don't face justice. And we can give you examples of that having happened. And it's illogical because we can prosecute torturers, because under the Torture Convention and the law that we used to introduce that as a domestic crime where we could prosecute those whom we knew were internationally renowned torturers, those we can prosecute, but we can't prosecute these others on the crimes that I've listed: war crimes, genocide, crimes against humanity, sexual crimes which have been weaponized as weapons of war. And so the Joint Committee of Human Rights, on which I sit and which is led by Lord Alton, published 2 reports this year, one relating to this bill, but another relating to Daesh, ISIL, people who've returned from criminal activities abroad. And part of the recommendations in both those reports, which have been produced by the Joint Committee, recommend that there be a review of the universal jurisdiction laws in this country. Sir Ken MacDonald, KC, former Director of Public Prosecutions, pointed out that it was illogical that we can prosecute for torture, but we can't prosecute for all these other grievous crimes. And the example I wanted to give, just briefly, was that of a Rwandan general, Kabarebe, who has been known to have committed many crimes and has come to this country and yet not been in any way detained or prosecuted. And so I strongly recommend that this is something that the House will consider in the fullness of time, along with the many valuable recommendations that have been made in the course of other speeches.
Yeah.
And also Chair of the Duke of Edinburgh Awards. While I broadly welcome this bill, I do have a number of reservations, but I do strongly support the work of the noble lady Baroness Burton, in her work on tackling pornography. And I'm sorry to say that my noble friend Lord Hogan Howe is not in his place at the moment, because I do support also the fervour in which he wishes to improve cycling safety. I'm going to concentrate my comments on the mandatory reporting of child sex abuse, and I have a private member's bill on this topic. And I'd like to thank the noble Lord Hanson, for responding to me at second reading. Tom Perry, who previously worked with Mandate Now, has said, and I quote, "Among the 82% of countries in the rest of the world that mandate prescribed personnel to report child sex abuse, None employs such a dilute approach. The impact assessment for this bill says there will only be an increase of around 8 extra reports per annum per police force. Hardly groundbreaking. In April 2025, the Home Office published a progress update on tackling child sex abuse and found that the scale of child sexual abuse is truly staggering. Children are 20% of the population, but are the victims in 40% of all sexual offences. The Local Government Association estimates that only 1 in 3 children who are sexually abused by an adult told someone. The Centre for Crime and Justice Studies estimates that 85% of child sexual abuse goes undetected and unreported. While the Home Office update states that the government is committed to tackling child sex abuse and will respond to the independent inquiry into child sexual abuse report, but a system that requires abuse to be disclosed by the child, witnessed by the reporter, or confessed by the perpetrator before a report is mandated is just far too weak. What His Majesty Government proposes falls short of the recommendations made in ICSA. The recommendation from ICSA is for anyone who's in a position of trust, whereas the scope of the proposed bill is much reduced. This bill excludes leadership and supervisory roles from the duty to report. Furthermore, only disclosed and witnessed abuse is covered. There's no criminal penalties proposed for a failure to report, meaning suspected child sexual abuse may continue to go unreported with no repercussions. Lastly, the confidentiality duties for religious and medical sectors remain open to interpretation or to possible future exemption. The ICSA report shows that international evidence supports the view that England and Wales ought to introduce mandatory reporting laws to enable the police and local authorities to better identify children in need of protection. And we must learn from other areas where mandatory reporting has been implemented, such as female genital mutilation. And we must endeavour to ensure that we have a clear, comprehensive and effective law. My Lords, our children deserve better.
My Lords, I welcome the Noble Baroness the Minister to her new role, and I very much look forward to working with her. I further welcome the clarification that this bill brings to the law around spiking and the new offence of taking non-consensual intimate images. I very much look forward to supporting my noble friend Lady Sugg on her amendments on honour-based abuse and my noble friend Lady Burton on her amendments on online pornography. I want to take this opportunity to congratulate and thank the noble Lady Burton for her brilliant review and her tireless efforts pushing for comprehensive law on online pornography. I turn now to the new taking offence. I greatly welcome the implementation of the Law Commission recommendation to update the pre-existing voyeurism and upskirting offences and implement a single taking offence. I am very pleased to see that it is vitally a consent-based offence, removing the unnecessary burden of having to prove the motivation of the perpetrator that has featured in previous iterations of image-based abuse offences. However, it is vital that we further strengthen this offence by increasing the time limits prosecutors have to bring forward charges so that victims are not inadvertently timed out by the 6-month time limit of a summary offence. In February of this year, the government gave me an undertaking to extend the time limits on the non-consensual creation offence in the data bill after it was highlighted by the campaign group Not Your Porn. The extension of the time limit here means that for the creation offence, victims have 3 years from when the offence is committed, or alternatively, from when the CPS has enough evidence to prosecute. Given that we have already achieved a legal precedent in extending time limits on image-based sexual abuse, I would be grateful if the Noble Baroness the Minister, in her summing up, could commit to extending the time limits available in both the new taking offence and the pre-existing sharing offence to ensure that all image-based abuse offences have parity within the law. I was pleased to see the updating of the sentencing code to reflect the new taking offence and clarify that the photograph or film to which the offence relates and anything containing it is to be regarded as used for the purpose of committing the offence. However, I am keen that we look into further ways to ensure that this content is not kept by perpetrators and remains offline in perpetuity. Further, I will continue my work with survivors of this abuse and charities to explore ways in which this content can be removed from the internet as rapidly as possible. Additionally, I was concerned that there does not seem to be a sufficient definition of what it is to take an image or video in the offence, and therefore I would be grateful if the noble Baroness the Minister could confirm that the definition of taking will include screenshotting. In the 2022 Law Commission report on intimate image abuse, the example was given where a person may consent to being in an intimate state in a video call, but not consent to the person screenshotting them. The Law Commission concluded that taking a screenshot of a video call should fall under the definition of taking because this conduct creates a still image that does not otherwise exist. I turn now to the issue of spiking, which my colleague in the other place, Joe Robertson, has highlighted alongside the campaigners Colin and Mandy Mackey, whose son Greg tragically died after a spiking incident at university. Whilst the clarification of spiking in this new offence is very welcome, I echoed the point made by my noble friend Lady Kofi that there is concern that the intention element may be too narrow and that it may not allow for cases where a person has been spiked that does not fall into the category of injure, aggrieve or annoy. My Lords, this bill includes positive steps and I look forward to working with the Government and noble Lords to strengthen it.
My Lords, it's a pleasure to follow Baroness Owen and I congratulate her on the campaigning work that she has done on some of the issues that we are addressing in this bill. I congratulate too Baroness Levitt on opening the second reading of this juggernaut of a bill, and she is a welcome addition to the front bench. As other noble lords have said, there is much to welcome in this bill, but we must also recognise that there are deep concerns too. Non-governmental organisations that I hold in high regard and across a wide spectrum have expressed deep reservations. Therefore, it's vital that the government gets the equation right and ensures that there is a balancing of rights and protections. The opportunity, as other noble lords have said, to widely address concerns and omissions will be in detailed committee work. And I eagerly await the amendments that will be introduced by the government to make all existing strands of hate crime an aggravated offence. I will also, my Lords, address omissions in relation to the needs of the traveller, Gypsy and Roma communities. My Lords, hate crime continues to rise and therefore government action is to be welcomed. Those who encourage and promote hate crime, whether online or in print or on the streets, empower the thugs who ultimately take violent action. The litmus test of any civilised country is that we all enjoy the equal protection of the law and the universal freedoms and obligations which are basic human rights. Yet online hate crime increases and is sadly often defended by those who should know better, Elon Musk amongst them. People are routinely, grossly misrepresented, defamed and victimised because of their religion, their belief, their disability, that they're transgender, lesbian, gay, bisexual, gender non-conforming, or because of their race or more. To attack and denigrate such people and to portray them as a threat to others is, in my opinion, to debase the very society in which we live. Freedom of expression is not the freedom to incite violence. Whoever incites hate or violence or carries it out should be held accountable and the law must be applied equally. So therefore, I have no hesitation in encouraging the government in their attempts through this bill to create a better and more equal society. Like other noble lords, I have concerns, not least in relation to the bill's public order provisions, and I share reservations expressed by the Joint Committee on Human Rights, as well as the Constitution Committee of your Lordship's House. The right to protest is an essential freedom. Protests often offend and often discomfort, and that is a price, I believe, worth paying in a democracy. And to counter-protest, my lords, is not un-British. It is how protests are undertaken and conducted that matters. And I am one of 16 members of your Lordship's House that voted against the prescription of Palestine action because the case was not made and has not been made. And therefore, all restrictive actions by the state must be open, transparent, and the evidence of such decisions clear for all to see. In conclusion, if this bill helps to make our country safer and stronger, then it is to be welcomed, but it must strike the right balance in protecting the essential freedoms that underpin democracy Otherwise, it will do more harm and create further divisions. I associate myself completely with the intervention by the noble Baroness Chakrabarti. We need to return, my lords, to being a country where we are more comfortable with one another, where we respect difference and celebrate somebody else's right to disagree with us. No one has anything to fear from equality, the equal protection of the law and the equal obligation to abide by the same laws. That is the litmus test of any decent, civilized society. It is not defined by draping oneself in a flag or the proclamation of patriotism or the defining of Britishness by the claim of some right or another or how and when we make our voices heard. The essence of a civilized society is defined in its treatment of the most defamed, the most disfavoured, those shunned and misrepresented. Britishness is when we return to being a better, fairer, more generous country. If this bill can help us move in that direction, it is a bill to be welcomed.
My Lords, I'd like to also add my congratulations to the Minister, and particularly the skill in introducing such a wide-ranging bill. My Lords, my interest is parochial in the sense there are many subjects here that require the appropriate attention and scrutiny. But as a previous General Secretary of the Retail Union, somebody who's been involved in the issue of retail crime for many years, I want to try and bring in the short time available, the impact on retail workers into this chamber. Some months ago, I introduced a debate in this chamber on retail crime. And there was many speakers, in fact there was universal support, why wouldn't there be, on the subject on the abuse of workers. There are nearly 3 million workers in retail. Now in 2003 I had the responsibility and the pleasure to introduce in retail, in my union, the Freedom from Fear campaign. Now it sounds very dramatic, but it was born out of necessity where there was such systematic verbal and physical abuse. One of the criticisms of many members of retail workers were politicians listening. Now, of course, politicians can't resolve the ills of society with one clause. But I say to the ministers, the message you've sent out by this standalone clause is significant. The attention it's received in my union says politicians don't only make speeches, but they also conclude actions. And for me, it's a conclusion of hard work. Now, I could give many examples of bringing to life the effect of verbal and physical abuse. Time doesn't allow, so I'll quote a couple. But before I do, I just want to say verbal abuse, which might seem not a victimless crime. It's just something that people do when they can and don't get their way in a store. Verbal abuse is demeaning. We've heard of it in so many other contexts in this chamber. But the right to go to work and be safe is a fundamental right in the workplace. Now, this has never been an adversarial campaign. Retailers have supported the campaign, British Retail Consortium, many of the big retail companies were with us on this. In fact, when this started, all the recording was about the theft in the stores, not the reality of the impact on the employees. That day is gone. This decision by this government sends the right message that abuse will never be tolerated. Now, of course, one clause, a standalone clause, doesn't in itself solve everything, and we'll monitor the impact of it in due course. And there will be calls for an extension of the clause to other frontline workers. But don't let that negate the importance of this clause. One of the best recruitment opportunities I had as a leader of a trade union was when we introduced this campaign. Those people who may never have wanted to join a union in the past liked the idea they had somebody speaking up for them. Somebody was prepared to discuss with the companies, with the stakeholders and with politicians. So please, whatever your reservations about specific clauses, you should be congratulations of the government for this one. This is extremely important. Now, I can just give you 3 statistics. No, I won't. I'll give you 2 examples. The store manager who had been assaulted 3 times gave his job up. He couldn't face returning to the workplace. A young woman who had 2 children, the only earner within the workplace, couldn't face coming back. Now, I know that's trying to draw a degree of emotion into this, but these are real people. 70% of receiving verbal abuse, behind the statistic, is individuals. So I applaud the government for the bill, and I look forward to watching its work through and contribute going forward. Thank you.
My Lords, I'd like to say just a few words to welcome the inclusion of the cuckooing offence into this bill. Unfortunately, across the country as a whole, vulnerable people are being exploited, threatened, and manipulated in their own homes by criminals who take control of the property for their own purposes. Communities are also suffering terribly this antisocial behaviour as a consequence. We call it cuckooing, which sounds a bit odd, but it's because of the similarity to the behaviour of the cuckoo bird, which imposes itself into another bird's nest, expelling the rightful offspring and manipulating the adult birds into caring for it. I think it was 2021 when I first proposed the criminalisation of cuckooing. This was actually prompted by expert research by Justice and Care and the Centre for Social Justice. I was concerned that the existing laws were inadequate to address the exploitative nature of this predatory behaviour. I'd like to congratulate the Noble Lord the Minister, Lord Hanson, and his colleagues for bringing forward this offence. I'd also like to thank him for his response to my correspondence regarding the victims who are too afraid to verbalise their lack of consent, and also, of course, young people who may be compelled to engage in cuckooing by others who are exploiting them. I hope these issues will be addressed on the record during the later stages of this bill. The cuckooing offence treats this activity with the seriousness it deserves and will give the police the tools they actually need. I look forward to seeing this brought into force. Thank you.
My Lords, Lord Stratsburger is taking part remotely, and I now invite Lord Stratsburger to speak.
My Lords, I declare my interest as Chair of Big Brother Watch. I'd just like to welcome the earlier comment of Lord Herbert that the non-crime hate incident regime is not fit for purpose. My Lords, this bill has much to recommend it, but 4 minutes is nowhere near enough to do it justice, so I will focus on just 2 concerning aspects. Until recently, our country was an exemplar of how government and other institutions could be held to account by citizens through peaceful protest. But in 2022, the last government gave us the Police, Crime, Sentencing and Courts Act, which handed senior police officers and ministers powers to impose extensive constraints on protests. Then in 2023, the Public Order Act further enhanced police powers to restrict and criminalise protest activity. As a result, in just 2 years, 712 protests in England and Wales were subject to police conditions, 95% of them in London. But now it seems the government wants even more powers to restrict protests. Clause 138 would enable police to ban protests in the vicinity of a place of worship. Whatever in the vicinity of means, it would certainly include Parliament Square and most urban centres. And Clause 118 would have the chilling effect on some people's willingness to engage in protest. Furthermore, the government is promising additional clauses to enable the police to ban repeating protests, which of course is most protests. My lords, protecting the right to protest is absolutely vital to maintaining a healthy, vibrant democracy where power is questioned and is balanced by the collective will of citizens. The cumulative effect of more and more restrictions on protest is one of the reasons why our country is sliding down the world's free speech league, and this trend needs to be reversed. My lords, I now turn to an astonishing omission from this bill. The collection of DNA, how it is retained and examined, and how it is used as evidence and its eventual destruction are quite rightly controlled by several acts of Parliament and detailed regulations, all overseen by a statutory regulator. But when it comes to the relatively new facial recognition technology, none of these protections and none of this oversight exists. Nothing at all. And facial recognition is far more intrusive than DNA. It's as if citizens are walking around the streets with a barcode on their foreheads that the police can read from a distance to identify them. It drives a coach and horses through our time-honoured right, with limited exceptions, to withhold our identity from the police. And when this technology is incorporated into this country's vast network of CCTV cameras, as it surely will be, it will be possible to track us wherever we are going about our lawful business. Since the technology was first used in South Wales in 2017, police forces have reluctantly had to cobble together their own rules and mark their own homework, falling foul of the courts in the process. So, my lords, you would assume that the new government would seize this opportunity of this major bill on policing to introduce the long overdue statutory regulation of facial recognition technology. But if you thought that, you'd be wrong. This bill does nothing to urgently fill the black hole where the essential regulation should be, the black hole that is crushing our privacy. Instead, the government is presenting a bill that says nothing about facial recognition, other than Clause 138, which seeks to make the technology even more intrusive by linking it to the DVLA database. My lords, this extraordinary regulatory vacuum must be filled by amendments during the passage of this bill. Thank you.
My lords, I know that many on the Labour benches don't want to hear this, but this government is actually more authoritarian than the last. Not only has the Labour government accepted all the draconian laws of the Conservative government, it actually continues to add to them. Now, how many times in the previous 14 years, I've only been here 12, but in the past 14 years, the Labour benches did speak against laws clamping down on protests, but now they're supporting them and even defending and adding to them. The values of liberty and democracy, a passionate defence of the right to protest, it all sounded great in opposition. So why did Labour drop them when they came into power? The desire to squash effective protest is the aim of this legislation. Of course, governments don't mind if protest changes nothing. The bulk of laws in recent years have been aimed at the kind of non-violent direct action protests that stop big corporations from, for example, setting up damaging fracking wells in our countryside, or supported people trying to stop an ancient woodland being cut down to build a new destructive road. A lot of those protests were successful and led to policy changes either locally or nationally, like the direct action protests a few years ago actually led to the passing of the Climate Emergency Act. The oil and gas industry don't like countries switching to renewables, to insulation and net zero, so they paid a think tank to come up with the laws clamping down on effective protest, which the last government passed and this government has kept. That's why we need to enshrine a legal right to protest, and I intend to bring an amendment to that effect. I spent 12 years in this House warning about this country being on the path towards a big brother state. A combination of laws against effective protest while using digital ID will enable a future government to carry out repression with a biometric link. The police are already using facial recognition without any proper regulation or legal restraints. With the proposed rules against face covering and the rollout of digital ID, just being seen on a protest against a future government could see you losing promotion or your job or state benefits. It's already happened to dissenters in Hong Kong and other repressive countries. The government can blacklist you, just like the UK building industry did to trade unionists in conjunction with the police. We have to allow people to disrupt, make a noise, get noticed. That's democracy. The police, of course, should be able to arrest for serious infringements, and people should still face legal consequences, but not the very severe punishments of recent years that labels protesters as terrorists. The prescription of Palestine action was another nail in the coffin of democracy and dissent. The new powers for the police to ban repeated protests is the state trying to shut down the people who are putting a spotlight on the government's complicity in the genocide in Gaza. After all, when you're supplying military intelligence to Israel and exporting arms to a country that wants to ethnically cleanse people from a land that you want to settle, those are actions which could land you in an international court. My noble friend, Baroness Bennett, who can't be here today, will engage on the issue of travellers' rights and abortion law at a later stage. So I just have a few questions for the Minister to answer. I'll cram in as many as I can. Do you suspect that the prescription of Palestine action has discredited the use of anti-terror laws? Will the government look instead at the case for prescribing members of the Israeli Defence Force living in or visiting this country? These are people who've taken part in potential war crimes, who've murdered and terrorised thousands of women and children in Gaza. And finally, does the Minister really feel it's a priority for the police and security services to waste their time enforcing this unpopular and largely pointless prescription when they have real terrorists to track down?
My Lords, as ever, I declare my interest as a teacher in a state secondary school in Hackney, a place that my noble friend Lord Burt I thought was rather unfair about earlier. My Lords, this is an extensive and wide-ranging bill. You know you're in trouble when they have to Treasury tag it rather than bind it. But there are many good things about the bill. Clause 191 is good. As Professor Rani Thakur, President of the Royal College of Obstetricians and Gynecologists, said, abortion is an essential form of health care and should be subject to regulatory and professional standards like other medical procedures, not criminal sanctions. Clause 78 is good, preserving the right of child confidentiality in some circumstances. Barnardo's and the NSPCC, among others, stress its importance for services like Childline. AI image generators used to produce child abuse images made illegal is something that many Lords have talked about. But, my Lords, there are issues. The Children's Society feel that the offence of child criminal exploitation does not go far enough. Any child can be at risk of exploitation. Indeed, perpetrators are now looking for so-called clean skins, children who aren't known to the police or involved with the local authorities, so the exploitation can go undetected. Many of these young people are from affluent backgrounds. The Children's Commissioner has concerns about parts of Clause 40. She says, it is clear when an adult exploits a child to engage in criminal activity, that should be a mandatory criminal offence, regardless of the child's perceived age. I welcome the government's mission to halve knife crime and get knives off our streets, as Lady Lawrence of Clarendon so movingly spoke about. The Ben Kinsella Trust reports an 81% increase in police recorded offences involving a knife or sharp instrument in the last 10 years to March 2025. Our school lost a child killed in a knife attack last year. Do we need zombie hunting knives and other overly aggressive styles of knives? Surely some are just too potentially dangerous. But according to the Youth Endowment Fund, in the year 2024, 50% of murders were carried out with a blade used that were carried out with a blade used a pointed kitchen knife. They call for a ban on pointed knives altogether. The catering fraternity might object, although studies have shown there is no culinary effect in whether a knife has a point or not. Would the minister support such a ban? We also get to equal protection. Does this go in this bill, or we're trying to get it in the Children's Wellbeing Bill? With over 65 countries, including Wales and Scotland, already having legislated to protect children from physical punishment, how much longer can England justify standing still? The NSPCC does not describe this as a smacking ban, but talks about equal protection. This is not the call for creation of a new offence, just the removal of a legal defence to make equal the law of assault for both children and adults. This is about giving children the best possible start in life, not criminalising parents. My lords, deliberately causing pain for a child for whatever reason has to belong to the last century. There are much better and safer ways to respond to a child's behaviour than the use of physical force. And I look forward to hearing the Minister's thoughts on that as well.
My Lords, first may I welcome Baroness Levitt, the noble Baroness, to front bench to supplement the efforts of the indefatigable Home Office team in the front bench in the Lords. I wish to speak about Clause 191, which decriminalises abortions for women ending their pregnancy at any stage to birth. This clause does not change the existing time limit of 24 weeks, after which an abortion will be a criminal offence, except under special circumstances for medical professionals, those who provide an abortion or assist a woman to procure one for themselves. What will change is that the woman herself, who takes steps to end her pregnancy at any stage up to birth, will not face criminal charges. I am against such a change on 3 grounds. 1, procedural, 2, substantive. First, a private member's conscience amendment has been used to amend a government bill bringing the weight of the executive to a matter of conscience. Moreover, by this procedure, a matter of great significance may be allowed to slip through, tagged on to the Crime and Justice Bill, avoiding the full national and parliamentary scrutiny that such major changes in a law requires. 2, it is selective in the application of the law in a way that goes against the very principle of law. It is bad in principle and practice to count some action as a crime for some people, but not for others. In Clause 191, it is accepted that aborting a baby over 24 weeks old is normally a crime and that those involved should be punished, except for one, the pregnant woman who is the instigator of the action. It is part of the very principle of what it is to be a law that is applied universally. There can be special factors, such as coercion, which relieves someone of criminal responsibility in particular circumstances, but not a blanket exception. Moreover, there could be no greater denigration of pregnant women, and indeed all women, than to deny them the most basic right of all, to be judged morally, and when they have committed a crime, judged criminally. Abortion over 28 weeks is accepted as a crime by all. To say that pregnant women can commit it, so long as they do so against their own children or own child, but nevertheless are not criminals, is to treat them as less than fully human adults.
My Lords, I want to start, as lots of people have done today, by echoing the comments about this excellent bill. I know very well the impact that its many measures will have in many communities around the country. I also want to echo congratulations for my friend, the Noble Baroness Levitt, for her hugely impressive debut in introducing a very complex bill. I want to talk today in favour of Clause 191, because I believe very strongly that women, often very vulnerable women, should not be criminalised for ending their own pregnancy outside the law, which often results in years of investigation and a custodial sentence. Baroness Suggs earlier talked very eloquently about what is and isn't contained in Clause 191, so I'm not going to go through that again, but a couple of points I want to make. The other place voted to repeal this antiquated law, bringing us in line with many other democracies around the world, but it also brings us in line with public opinion. 52% overall oppose criminalising women in these circumstances, while only 21% support it. That's men and women, fair-minded people, if you like. But unsurprisingly, women feel this most strongly. Just 16% of women support criminalising women in this way. And when we look at women under the age of 40, i.e. those women who are most likely to be directly affected by the law, that drops down to just 13%. So the data is very, very clear. But for me, the most powerful and persuasive argument comes directly from some of the women who've been treated barbarically by this law. Take Sammy, who went into premature labour at home, and as she attempted to resuscitate her own baby, 7 police officers were searching her bins for evidence, even before the paramedics had arrived. She was then interviewed under caution for suspected illegal abortion and had her phone and her computer seized. She was not allowed home for a week, as it was sealed off as a crime scene, and she was left just in the clothes that she had attended hospital in. She was also not allowed to contact her partner. Despite providing forensic samples that did not show the presence of abortion drugs, she remained under police investigation for a year and was only allowed limited supervised contact with her baby, who had survived the traumatic birth, probably because of her own intervention. Sammy is now a very active campaigner against this law, a law that was passed before women even had the vote. We have a chance now to end the suffering it causes, and we must do so. Thank you.
My Lords, there's a great deal of interest in this bill, so I shall confine myself to talking to someone about something that isn't in the bill, but should be. Of the 42 million vehicles on UK roads, the research we've done over the last 5 years shows that 10 million of them are non-compliant, uninsured, unregistered, untaxed, or without MOT. That's an astonishing figure, but it shouldn't surprise us. If you don't enforce a law, then you get an upsurge in people breaking the law. And as this bill deals with shoplifting, and I am delighted that it should, so it should be dealing with vehicle non-compliance. With non-compliant vehicles, there is something that we can do without cost to the Treasury, because we are dealing with people who are easier to locate, who owe money anyway, and who are in possession of a substantial asset. So that produces a set of circumstances where we can devise a system of enforcement which does not cost the Treasury anything. If any other noble lords are interested in this problem, please correspond with me. In the Commons, it has been most actively pursued by Sarah Coombs MP, who has now been brought within the government and therefore can't campaign for it actively. So this is very much a cross-party issue, a national issue, not a party one. So I intend to propose amendments to this bill to allow a pilot to help us reach a self-funding solution to the problem. My amendments will enable local authorities and other enforcement bodies to identify high-risk vehicles and intervene, starting with things like warning notices and text messages, targeting the worst persistent evaders, those using clothing number plates, foreign registered vehicles, and those without DVLA keeper details. There are a lot of them. The pilot can be delivered at zero cost to police or government. It will end up supporting overstretched police forces, denying criminals the use of our roads, and reducing vehicle-related antisocial behaviour. The pilot proposals have been developed in consultation with those representing the interests of roads, policing, local government and trade associations. It is very well thought through, and I take no credit for it. I am just a spokesman. But none of this can happen without government support and legislative change, and this bill seems to me to be the place for that. Rather than embarking on something wholesale, which would raise all sorts of questions about people needing to be consulted, a pilot is something that is much more limited. If it falls over, we will all have learnt something without the government having to pay for the lesson. If it succeeds, and I am most optimistic, it will drive lasting reform and make UK roads safer for us all. I very much hope that the Minister will be agreeable to a meeting with himself and relevant officials to present this initiative in more detail alongside industry experts who have helped shape its development.
My Lords, can I begin by congratulating the noble Baroness the Minister on an exceptionally comprehensive introduction to what is, by any measure, a wide-ranging and ambitious bill. In the time available, I will confine my remarks to three aspects of the bill: the government's manifesto commitment to extend aggravated offences to all strands of hate crime, the continuing discussions around the recording of non-crime hate incidents, and, in common with Lord Hogan Howe, as a London cyclist, I'm very interested in the new provisions around cycling. First, I welcome the commitment made by the Minister at report stage in the other place to introduce a government amendment at committee stage in this House, I got all that formation correct, to make all existing strands of hate crime aggravated offences. The framework for race and religion has made a real difference. It's given prosecutors the tools to reflect the gravity of hate-motivated crime, ensured higher sentences where hostility is proven, and given victims confidence that the law recognises when they have experienced such an offence. These offences send a clear message about who we are as a society and what we're prepared to confront. For disabled people, the same clarity has never existed. Hostility is too often treated as an afterthought, incidents instead recorded as ordinary assault or public order without recognition of the prejudice behind it. Extending aggravated offences to disability would bring long overdue parity and show that hate in any form will be met with equal seriousness. For LGBT people too, the gap in protection remains. While cases can be charged as hate-motivated, they still fall outside the aggravated framework. I hope the government's amendment will close that gap once and for all, and I look forward to working with ministers on it. I note the comments by the noble Lord Herbert on the recommendations to stop non-crime hate incidents. I do believe that seeing a spike in incidents can help police forces and, crucially, communities take action. For example, an increase in anti-Semitic incidents in an area can signal growing tensions. I absolutely accept the recommendations of the National College of Policing, but I am interested in how police forces and communities can still consider signals and measures of community cohesion and take proportionate and measurable action to prevent escalation. Finally, and perhaps most controversial thing I'll talk about in this chamber ever, I welcome the provisions on cycling now included in the bill. I cycle in London and I do something that sometimes feels rare. I stop at red lights and I indicate when turning and wear a helmet. Anything that deters dangerous or careless cycling is to be welcomed, and it is time our laws reflected how we travel in our cities today. But, my lords, I must also confess that I enjoy an e-bike. And although I have no financial interest in Lime, they certainly have a financial interest in me. Reducing the maximum speed of hired e-bikes would be a simple way to make them safer. They simply go too fast, my lords, and they evoke an adolescent abandonment of safety and conscience in a way that I am totally ashamed. Riders must behave responsibly, but providers also have a part to play, and an easy part to play, in protecting everyone. This bill covers a great deal of ground, and the issues I've touched on all point to the same principle. The law must be fair, proportionate and responsive to the world as it really is, not how we wish it was. I look forward to working with the Minister and noble lords across the House as the bill progresses.
My lords, a lot of today's speeches have been on abortion, which is weird in a bill boasting its aim is to make our streets safer. Just to note that I support Clause 191's aim of disapplying the criminal law for women acting in relation to their own pregnancies. But I don't think this bill was the right vehicle for such an important law change, and I've got some sympathy with the public backlash about a lack of debate on the issue. But you can see how it happened. The bill is so disparate and unfocused that even the government keeps adding to it. Ministers introduced 90 amendments, 66 new clauses and 4 new schedules at committee and report stage at the other place, and apparently there's more to come here. But where does that leave us, all this chopping and changing, leave us here? Recent tensions over our scrutinising role has led to the accusations of filibustering and time wasting. But how can we keep on top of what the government intends when it's so scattergun and expansive? As the noble Lord Garnier explained so well, the bill, to me, exemplifies the trend of excessive lawmaking as a substitute for enforcing laws that we already have. We've heard a lot today about the bill creating a specific offence of assaulting retail workers. Well, call me old-fashioned, but I've always been opposed to assaulting retail workers. As far as I knew, it was against the law. Now we are creating a new law that avoids crucial questions. Why has there been a shocking increase in attacks on shop workers, often accompanied by mass shoplifting, and why have this not been dealt with by the police? Inevitably, other workers say, what about us? For example, in an unlikely outbreak of consensus, the RMT, National Rail and the Rail Delivery Group are united in demanding that there should be a specific offence of assaulting or abusing transport workers. And to counter lots more special pleading, perhaps the government should use its energy in ensuring that assault laws lead to prosecutions. Another worry, the public's civil liberties and free speech are being carelessly jeopardised by this trend of criminalising ever more aspects of everyday life. For example, in relation to Clause 118, the Joint Committee on Human Rights warns that criminalising all forms of identity concealment could unjustifiably interfere in the right to protest. Yet again, the police already have powers to require individuals to remove such face coverings. Maybe the government should investigate why the police don't use that power when, for example, dealing with pro-Palestinian marchers chanting Jew hatred behind their keffiyehs and balaclavas. No, far easier to ban all face coverings instead. But as Big Brother Watch notes, there are many law-abiding individuals who might want to conceal their identities on demos. Topically, why do we think Hong Kong dissidents cover their faces on protests? Hint, their own authoritarian government agents are watching. And these proposals are made against the backdrop of other attacks on privacy, from facial recognition technology to digital ID. Then there's Clause 4, which many civil libertarians are concerned about. Firstly, those much vaunted respect orders. It seems the epitome of technocratic governance, by the way, to imagine you can tackle the breakdown of social respect so well described by the noble lady Baroness Stow by creating a new civil order called a respect order. Respect orders are almost a duplicate of the overused and discredited and ineffective antisocial behaviour injunctions, which will continue, but respect orders will have criminal sanctions up to 2 years in prison, which only use the lower civil standard of proof, and recipients won't even be told when they are put on an order. Meanwhile, the proposed increases in penalties for breaching the misnamed public space protection orders and CPNs from £100 to £500 is petty punitive, but outrageously, they're predominantly issued by private enforcement agencies who are paid by the state per fine. I'm afraid too much of this bill will continue this trend of eroding our everyday liberties, and I will be working with groups like Manifesto Club and Justice to ensure that actually we should focus on keeping our streets safe, but what's not safe with this bill is our civil liberties and our free speech.
My Lords, it's a pleasure to follow the Noble Baroness, and I welcome the Noble Baroness, the Minister, to her second reading. I welcome elements of this new portmanteau bill and the Noble Lady, the Minister's assurances at the beginning of this debate on the focus being on fighting basic crime. The bill addresses legislation seen as obsolete, incomplete, needing amendments or improvement, and I see a further golden opportunity in this bill to remove hate crime law, which was first put on the books in 1965, addressing race hatred. But since then, hate crime law has proliferated, indeed metastasized. It has proliferated in which protected characteristics it covers, now up to 5 in the UK, 7 in Scotland. It's proliferated in the triviality that can now incur the police's attention. It's proliferated in political agendas being pursued, with some hateful beliefs allowed to flourish, but less politically modish views cracked down on. It's proliferated by uncoupling hate crime from actual crime, with police intimidating and harassing individuals for the absurd and near oxymoronic concept of non-crime hate incidents. It's proliferated in the many new organisations claiming to unearth hate crime and hate speech, funding false narratives of hate crime, dividing the nation further, but with no reduction in hate crime. Hate crime has crystallised as the useful tool of left identitarians, dividing and conquering by inciting grievance within the identity groups whose votes they seek to capture. Set against this, my lords, is free speech, where in this country we traditionally do not believe in thought crime. Our first Queen Elizabeth famously said she had no desire to look into men's souls. But now we have policemen saying, I need to check your thinking. Free speech advocates see the need to tolerate it when people say disgusting things we don't like. Only ordinary criminal law, not hate crime law, should be deployed in such circumstances, and only then if there is intent to incite imminent violence. Criminalising hate speech didn't prevent the hateful marches that occurred immediately after October 7th, before Israel could even react. Nor did it stop the continuation of those marches after the ceasefire had been achieved. Those marches quickly over the months rose to the standard of criminal incitement, in my view, after October 7th, yet nothing was done about that, month after month. Is there any evidence, my lords, that the invention of hate crime has reduced the number of attacks on minorities? Try asking Jews in Manchester that question, or Muslims in Bethnal Green. Meanwhile, hate crime law has led to the police being confused, overstretched, badly led, distracted from fighting actual crime. Not one burglary was solved in 48% of English and Welsh neighbourhoods in the past 3 years. The police's soft target now is to pursue the unthreatening middle-class tweeter rather than shoplifters, phone muggers, burglars, drug dealers. My lords, to redirect the police, we need to get hate crime off the statute book, while ensuring that within the criminal code we have adequate provision for the punishment of any crime that's driven by the intent to intimidate, persecute, or marginalise any group of citizens of whatever identity. Police could then focus on the numerous actual crimes that are committed daily, so that our police forces can return, as they say, to policing our streets and not our tweets.
My Lords, while I broadly welcome this bill, the bit I don't welcome, I think, is how large it is. Its scale and complexity were referred to by the noble Lord Garnier and the noble Viscount Lord Goshen, and even Baroness Fox, with whom I find myself agreeing. It is, in a sense, a testament to how many of our public bodies live in silos, how many public bodies have inconsistent leadership and change of leadership, and how much different bodies have selective interpretation and enactment of regulation or guidance. My Lords, this bill is, in some senses, it is well intended, but it is also a manifestation of a systemic malaise, and is a testament to our continuous failure under governments of whatever colour to enact and or enforce existing law or regulation and guidance. My Lords, I was at a dinner last Monday for the all-party parliamentary group on the armed forces, and a very impressive gentleman who's in charge of all of our cybersecurity talked about the appointment of Mr. Rupert Pearce as the National Armaments Director to try once and for all to try and sort out our rather lamentable track record in major defence procurement. If I ruled the world, which unfortunately is not a hereditary role, I would be tempted to appoint the noble Lord Timpson as the National Joined-Up Government Director, because as his wonderful father, Sir John Timpson, created the concept of upside-down management, I do think that so many areas of our governance would benefit from focusing on the people at the bottom who are the subject of all sorts of things happening to them, and working your way upwards to find out how can you remove the blockages which are continuously failing to remedy what repeated laws and new regulations are failing to do. I said to the noble Baroness Smith of Malvern at the beginning of the Children's Wellbeing and Schools Bill that I would be all over the first part of the bill like a rash, and I make the same promise to the noble Lord and Lady for this bill, because there are many areas of interest. I will be working closely with the Office of the Victims Commissioner. Baroness Newlove regrets she's unable to be here today, on a variety of amendments to try and make more sense of the attempts to deal with antisocial behaviour. I shall be continuing work with the noble Lady Baroness Royal and others on stalking. I will be working with Baroness Armstrong of Hilltop and others on trying to deal with the difficult issue of exploitation of children, because there is a difficulty that we have in differentiating between the individual as a victim and the individual as a perpetrator. And if you're a child, you can be one and the same thing, and it is very complicated to try and deal with that. I shall be dealing with mandatory reporting of child sexual abuse, again, to try and make that more forensic and more efficient, AI-generated child sexual material, and I shall, of course, be supporting the noble Lady Baroness Burton on all of her amendments around pornography. I think it is a tribute to the women in this chamber how often it is women who speak up about these issues. I'm afraid not enough men do. And I thought it was very interesting that a large number of men have commented on the rights of women and what they do with their own bodies during the course of this debate, and rather fewer women. And with that, I will sit down.
My Lords, much that is valuable and important has been said by many in this chamber this afternoon, particularly about the risks of the criminal law creeping too far into the conduct of everyday life. The law shouldn't be a code of conduct, and of the problems of unenforceability when law becomes over-complex. An important suggestion was made by Lord Cromwell, for example, which I hope is debated at committee. But I want to speak to Clause 191, which has profound implications for the lives of some children. Those in favour in the Commons spoke of a recent increase in investigations and prosecution. They spoke of women abused and pressured into abortions, and of unreasonable behaviour by the police and CPS. And they used harrowing cases to argue. A number argued that abortion should be considered only as a healthcare matter. But it's not hard to unpick these arguments and to see on what shaky foundations this decision was taken. It's blindingly clear that abortion is a profoundly difficult issue because the rights attaching to two different lives conflict. This is why it figures in criminal law. I don't stand with those who argue for absolute priorities in either direction, but I have worked for years in areas where adults and children's rights unavoidably conflict. And I know how easy it is for campaigners to be blinded by such conflicts of rights, by their perceptions of their own rightness. This is how some can see giving women an unqualified right to kill their own children, even the day before birth, as merely a progressive modernisation of the law. For abortion, there is an uncomfortable asymmetry. Unlike their mothers, unborn children are helpless and voiceless. We should therefore reject the argument that abortion should be considered purely as a healthcare matter. Yes, of course women's healthcare matters, but to make healthcare the only consideration is to deny a vast and important ethical debate. Both lives in question matter very much. Clinicians and support services naturally want to be kind to the woman in front of them, to whom they owe responsibilities. And of course, it's easier for professionals if the law removes any possibility of repercussions for them from a self-induced late abortion. But furthermore, decriminalisation, even in the interests of kindness, isn't always a social good. To give just one example, Oregon has had to reverse its disastrous policy of decriminalising low-level drug possession and usage. Now next, if there are cases of police or CPS overreach or malpractice, primary legislation is not the right way to correct that. It's shocking when someone proves to have been wrongly convicted. But do a few cases of wrongful conviction justify, say, decriminalising rape, lest any man ever be unfairly accused and investigated? And finally, Parliament should not succumb to emotional blackmail. The old saying is that hard cases make bad law. Domestic violence charities do see dreadful cases. Abused women do deserve kindness and consideration. But not all women are angels without agency. There are women who are not abused, but who do neglect and maltreat their own children. Ask any social worker. And there is clear moral hazard here. For example, a woman who forms a new relationship in mid-pregnancy may be tempted to eliminate the baby that she thinks could be an impediment to that relationship. Yet as far as I know, despite the red flag of increased investigations in recent years, no systematic review has looked at whether telemedicine for abortion is having an undesirable consequence of enabling greater numbers of women to conceal their stage of pregnancy so as to attempt late abortions. For all these reasons, I believe that your lordships should be concerned about this clause and by the fact that it was inserted without any national consultation, showing a clear balance of public opinion in support, and that it was not informed by a full review of the impact of permitting abortions by telemedicine. I will therefore be proposing amendments to delay its implementation until such a review and consultation have taken place.
Lords, this comprehensive bill, so well introduced by my noble friend, brings our treatment of crime up to date to fit new kinds of offence and some hitherto unrecognised. In the time available, as my experience in dealing with crime is limited to my time in the past as a magistrate, my current membership of the Sussex Police Diversity Advisory Board, I will focus on two areas I am particularly concerned with now: the new provisions on county lines and the surprising omission of dealing with a High Court decision that Part 4 of the Police Crime Sentencing and Courts Act 2022 breached human rights. I declare interest as President of the Advisory Committee for the Education of Romany and Other Travellers and of Friends, Families and Travellers, to whom I am grateful as ever for expert briefing, together with that of the Traveller Movement. The new offence of coerced internal concealment and associated provisions will enable those forgotten children or vulnerable adults who have been excluded from education or slipped through the net in other ways to be found, rescued and protected. The abhorrent practice by organised criminal gangs of recruiting these young people by force or deception into carrying drugs, illicit money and SIM cards away from the centres where they were stolen or dealt with has mushroomed in recent years. It exploits many who've been virtually abandoned by society and its institutions, instilling fear which estranges them from their family and community networks. The reinforcement of the civil prevention order is helpful, and further support from the £42 million County Lines programme is a sensible broadening of the approach to include positive elements of safeguarding and rehabilitation. So I warmly welcome this set of measures. My other concern is that our government has missed an obvious opportunity to end the discrimination against gypsies and travellers created by the Conservative government's Police Crime Sentencing Courts Act, whereby that small minority of gypsies and travellers who live in their traditional way in caravans on sites and have to make do with unauthorised ones can be imprisoned and their vehicles, which are their homes, impounded, even if there are no authorised sites for them to go to, under circumstances found by the judge to be discrimination. The case followed formal recommendations by our Joint Committee on Human Rights, the Council for Europe Commissioner for Human Rights and UN treaty bodies to repeal these measures. They were not welcomed by our police either. The majority of police forces and police and crime commissioners responding to the initial Home Office consultation on criminalising staying on unauthorised encampments rather than the previous definition of trespass opposed it. 93% of police bodies called for better site provision as the solution to unauthorised encampments, and of course it is the paucity of these that is the real problem, as the judge commented, not the desperate search to find somewhere to put the caravan home. Meanwhile, the government is under a solemn obligation to remedy the incompatibility with our human rights law. That is, it must restore to these fellow citizens who don't live in bricks and mortar that small measure of security they had to be able to live, send their children to school without fear of being driven out unreasonably, having their mobile home impounded or sent to prison. I trust my noble friend the Minister will not default on this obligation. Surely this bill is a suitable vehicle.
My Lords, I declare my interest as Director of the Free Speech Union. I intend to table an amendment to this bill scrapping non-crime hate incidents. A non-crime hate incident, or NCHI, is an incident or alleged incident which involves or is alleged to involve an act which is perceived by the intended victim to be motivated wholly or partly by hostility or prejudice towards one or more of their protected characteristics. This definition is hopelessly subjective, relying as it does on the perception of the complainant. NCHIs have been recorded against a woman who said she thought her cat was a Methodist, a man who whistled the theme tune to Bob the Builder, and former MP Amber Rudd, who had an NCHI logged against her after a speech at the 2016 Conservative Party conference in which she called for British jobs for British workers. She was Home Secretary at the time. The reason the police are logging these incidents is because in 2014, the College of Policing instructed them to record all hate crime reports, which on investigation turned out not to be crimes, as NCHIs. That explains why, according to the most conservative estimate, 130,000 NCHIs have been recorded in the last 11 years. The police should not be put in the invidious position of having to record what are often vexatious, politically motivated complaints. As the High Court judge said in 2020 when he found for Harry Miller, an ex-policeman who challenged an NCHI that had been recorded against him, quote, "In this country, we have never had a checker, a Gestapo, or a Stasi. You may think, what does it matter if an NCHI is recorded against someone's name? Because, my lords, they can show up in an enhanced DBS check and stop you getting a job as a teacher or a carer. Why should the fact that you've committed a non-crime prevent you from getting a job? My lords, NCHIs are a breach of a sacrosanct principle of English common law, whereby unless something is explicitly prohibited, it is permitted. The behaviour recorded in NCHIs is by definition not prohibited by law. It's non-criminal. So why are people being punished for it? Recording NCHIs is also a colossal waste of police time. In a report published last year, Policy Exchange estimated that recording NCHIs takes up 60,000 hours of police time every year. My lords, it's not just free speech lobbyists like me who think NCHIs have to go. Her Majesty's Inspector of Constabulary, Sir Andy Cook, has called for their abolition. Earlier this year, he said, quote, "We need at times to allow people to speak openly without the fear that their opinions will put them on the wrong side of the law. I'm a firm believer," he said, "that non-crime hate incidents are no longer required." And Sir Andy is not alone amongst senior police officers and ex-senior police officers in his opinion of NCHIs. The noble Lord Hogan Howe, a former Metropolitan Police Commissioner, will be co-sponsoring my amendment. The noble lady, the Minister, said she hoped this bill will restore public confidence in the criminal justice system. Scrapping NCHIs, which risk turning the police into objects of ridicule, is a vital first step.
Yeah. Your Lordship's House has, over the years, taken a very serious role in defending our free speech, our freedom of assembly, and the right to peaceful protest. And just this afternoon, we've heard powerful speeches from Baroness Chakrabarty, from Baroness Jones, from Baroness Fox, probably the first time I've ever agreed with her, and from Lord Cashman and Lord Clement Jones. Baroness Jones pointed out something I've noted too, though, that out of power, political parties defend those rights very vociferously. But once they're in power as the government, they get very tempted, and as we see in this bill, to introduce legislation to restrict protest more and more. And in the 25 years I've been following this, I've noticed that successive governments have increased not only the legislation about protest, but also the severity of the penalties for those protesting or organising protests. And what especially concerns me is the cumulative effect of all those acts. Now, I can accept that sometimes legislation is a proportionate response to emerging social issues, and I'm sure that's something we'll explore in committee. But too often, it's been the easy way for successive governments to limit dissent against their policies. And as we look at this bill with more curbs on protest, it's shocking to think. This is something I especially want us to bear in mind as we go through the bill, because it's shocking to think that international bodies have found that the UK has moved from being a champion of free speech and assembly to a nation where protest is a risk. For example, the UN Rapporteur for Human Rights and the Environment, David Boyd, warned of the chilling impact of recent legislation on democratic rights. And then Volker Turk, the UN High Commissioner for Human Rights, said the Public Order Act 2023 was deeply troubling and incompatible with international law. And Michael Forst, the UN Rapporteur for Environmental Defenders, he condemned the harsh sentencing of climate protesters as not acceptable in a democracy. I think we have to take those as very serious criticisms. And on that last point, some of the sentences handed down to protesters are truly shocking. And even a short sentence can disrupt your life a lot. It can affect the jobs you can apply for. It can disbar you, for example, from going to the United States. In my case, that would be a very severe penalty, as so many of my family live there. And that's a massive disincentive to stand and protest. So there is a real chilling effect. But I'm fortunately quite old, so I think I've had my fill of protests. Not to say I wouldn't feel like protesting some more, but I at least have a voice here now. But the reason I'm speaking today is that I've heard the anger and frustration of the young. They need to make their voices heard on the issues that will critically affect their future. And in this case, I'm particularly thinking of environmental issues and climate change. And our job in this House is to enable those voices, not to crush them, not to frighten them into submission, and not to chill them till they're frozen out.
Yeah.
My Lords, I believe, well I hope, that there is one thing all members of this noble House agree upon, and that is that none of us wishes to see the rise of the far right or of any political movement that feeds upon public fear and the failures of our institutions. Yet that is precisely what is happening in the UK today. And I have come here today to address what is not in this bill, which I believe is a missed opportunity to address some of those most significant and pressing issues of our time. The public has lost faith in the even-handedness of policing and the moral courage of those in authority. And when people see double standards or two-tier standards, resentment grows and trust dies. This bill is a chance to restore that trust, to ensure that the criminal justice system in Britain is not captive to ideology and not anymore paralysed by fear. So far, and I commend much that is in it, but so far it fails to address the underlying causes of what is known by the public now and by our media as two-tier policing. We are failing to confront too many uncomfortable truths. And we have seen where that fear leads. In Rotherham and Telford, thousands of children, and we're still counting, by the way, were abused while officials looked away. The Jay and Casey reviews both record that professionals, and I quote, were nervous about identifying the ethnic origins of perpetrators for fear of being thought racist. One police officer put it more bluntly: it was safer to do nothing. Let me repeat that. It was safer to do nothing. That single sentence should haunt us, and I hope that that sentence will hang over this House while we scrutinise and look to close the gaps in this bill. And what a time to have a debate about introducing a definition of Islamophobia. May I remind the noble members that Baroness Casey, for her efforts, was voted Islamophobe of the Year. It is not right that those who have the courage to address these issues are attacked and accused of being racist for them. And I know that the noble Baroness, Lady Levitt, will take seriously these issues, and I hope that we can work together to address them. The same paralysis has cost lives in honour-based abuse. The murders of Banaz Mahmoud and Shafila Ahmed are just two examples. Both young women sought help, both were dismissed as family disputes, both killed. The government has promised to define honour-based law, and that is welcome. But definition without duty is not protection. We will need clear, spelled out statutory obligations to act, to report, to share intelligence, to intervene, likewise with grooming. I'm running out of time, but even as the police have shrunk from appalling crimes, they have continued to prosecute non-crime hate incidents, and I support everything that has been said on that. It is part of the same issue, and we need to show the courage that this country needs so that we don't end up driving voters into the arms of something less savoury. Why, in the current climate, would anyone do what the Casey or Jay reports urge? The very definition of two-tier policing is that fear has dictated who is protected and who is silenced.
My Lords, I very much welcome the opportunity to discuss the matters in this bill and welcome the Noble Baroness Lady Levitt to the front bench. She's obviously used to dealing with gargantuan matters such as my profession, the RICS, and her previous capacity. So I wish her well in her endeavours in chewing through this particular 400-page bill. Now, my first point relates to antisocial behaviour. Now, in my experience, which is from inter-neighbour matters, the distinction between perpetrator and victim is seldom absolute, a point made by my noble friend Lord Russell of Liverpool. And so when I encounter instances of an ASB order that is made in such terms as normal life is actually impeded, and then the so-called victim proceeds to indulge in exactly the same sort of behaviour that has been prevented by his neighbour, then I know something isn't right. There needs to be a better balance. There needs to be the order-making powers and enforcement ought to be subject to better rules, competence and oversight, in my view. Now, my second point relates to clauses 72, 79 and 80, principally regarding the duty to report suspected sex abuse of children. Now, I fully support that duty, and particularly as far as it's applied to the persons listed as who are under the duty to report, and it should have consequences for those who culpably fail to report or who obstruct that duty. This follows the prima facie principle that victims should be heard and believed, and that a report of a matter involving commission of a crime, as defined by law, should be so recorded unless there is credible evidence to the contrary, and particularly in the context of young people. Once on a record in the system, the matter then demands attention and conscious process, including, one hopes, some support to the victim. That is until such time as additional verifiable information dictates otherwise. Outside that recording system, there's nothing, and no practical form of subsidiary watch list or anything like that. So spotting a trend pattern or commonality in the data outside a formal record seems to me to depend on chance recognition by an official. Well, so far so good, but then clause 80 proceeds to start unravelling things by effectively deferring to the balance of probabilities evidence-based approach inherent in police procedures and Home Office counting rules. Now, my lords, I believe this is incompatible with the intent and aim of clauses 72 and 79. Suspicions, which is what we are talking about reporting, almost inevitably lack hard evidence. So if I say that if say the recording officer of police does not happen to be satisfied as to the evidence and therefore does not believe it can be reliably stated to be a crime that's being committed, that's on his or her balance of probabilities test as suggested in guidance or as directed by the senior officer, it may not get recorded. Not only does this court perversity, because recorded crime is related to police performance, but it risks repetition of precisely the outcomes of the Bradford child sexual exploitation case, when vulnerable young people were not believed and criminal enterprise went unchecked. So in my view, clause 80 requires a rethink or simply deleting. But I do note that this may have wider implications for the way in which crime is recorded and acted upon. My final point relates to Part 9. Now, other noble lords have made impassionate comments, but I am not alone, therefore, in sensing there's a degree of tendency to administrative overreach, a politically thin-skinned reaction even at times in the cumulative measures eroding the right to demonstrate. And I would just say that I do very much relate to the comments of Noble Baroness Lady Miller of Chiltern Donor and to the noble comments of Noble Baroness Lady Cash. And I hope that between us we can get a better balance of what we actually mean by allowing people the necessary freedom and opportunity to vent their emotions and campaign and demonstrate safely.
My Lords, may I congratulate Baroness Levitt on her excellent presentation. When you get to number 65, it's probably best to adapt your speech a little bit. So if I could save a bit of time and say I agreed with every word that Baronesses Burton, Owen and Sugg said. End of. I should first of all say that I have been a supporter of liberty and its predecessor, the NCCL, for 50 years. But I also had the privilege of leading Sir Chris Bryant's private members bill on increased protection for emergency service workers in this House. It was the Assaults on Emergency Workers Offences Act 2018. So you could argue I've had a foot in both camps, therefore. I want to make a brief point about police employment issues, not strictly speaking part of the bill, but then move on to the issue of aggravated offences. Now, I appreciate that the employment issue is not a direct part of the bill. However, as a former chair of ACAS and a fellow of the Chartered Institute of Personnel Directors, I want to make a point about the importance of retaining skills and experience in the police force. When you cut back a police force by 20,000, it has a devastating effect. When you lose literally hundreds of years of experience, it might mean you lose some bad habits, but you also lose the institutional memory and a reduction in on-the-job training capacity. If you reduce a service to the bone, as the last government did, you have a demoralised workforce and a stampede for the door when the opportunity for a retirement package arrives. And those with a grievance are the ones forced to stay. Practicality says that the police will then prioritise their work and leave other things undone. And dealing with attacks on lesbian, gay and trans people are a long way down the list, and it might explain why retail theft and attacks on retail workers are so serious as we speak. It's this kind of short-termism which makes the issues of powers and responsibilities of the police rather secondary. My plea to the Noble Lord the Minister is for adequate resources and for active management planning, which allows the police to do their job. Nevertheless, I support fully the attempt by Rachel Taylor MP to extend aggravated offences to include attacks on gay, lesbian, trans and disabled people, and I congratulate the government for its commitment to include this in the bill. Could the Minister say a little bit more about the likely content of that amendment? The Law Commission report on hate crime laws in 2021 recommended, and I quote, that aggravated offences be extended to cover all existing characteristics in hate crime law: race, religion, sexual orientation, disability and transgender identity. And as has already been said, it was also in the Labour Party manifesto of 2024. Why this hasn't been on the statute book for years in this day and age, one can only wonder, but I look forward, my Lords, to our consideration of the committee stage.
My Lords, whilst I agree with so much that has been said so eloquently today, I wanted to focus on three areas close to my heart: the inadequacies of enforcement of the criminal law, how to deal with the Wild West of e-scooters and cycling, and the best way to reduce shoplifting. Although not declarable as an interest, my son is in fact a detective in the Met. And I think he would agree with what the Noble Baroness Lady Jonah has just said about the need to retain skills and experience in the police. Now, in a long career in and outside government, at the top and on the front line, I have discovered that enforcement of the law is as important as the rules and regulations themselves. As Calvin Coolidge, President of the United States, said, "The laws of the country must be enforced. There is no substitute for law enforcement." And that is why, in March 2024, we, the Conservatives, ensured that police numbers were at their highest ever. For this bill to be effective, they need to rise further. And the resource needs to be focused on the right things, away from the obsession with online harm, prosecutions for tweets, non-hate crime, and into neighbourhood policing. The truth is that we've moved away from the founding Peelite principle that police need to be part of the community that they serve. They are increasingly a wholly separate organism, usually absent from our streets and town centres, and sometimes appearing to want to control our thoughts. Part of the problem has been the huge increase in bureaucracy, with energetic policemen and women weighed down by the paperwork requirements and the inefficiency of the police, CPS and court interaction and its supporting and less than compatible IT systems. My noble friend Lady Coffey has drawn attention to the burden of yet more reporting requirements in this bill. Now, to my mind, there is an enforcement crisis, and I'd ask the Minister what he's planning to do about it. I'm very pleased to see Clause 106 introduced in the other place, which creates new offences of causing death or serious injury by dangerous cycling or by careless or inconsiderate cycling. I also like Clause 8, which makes it easier to seize an e-scooter being driven antisocially. And I note that the noble Lord Hogan Howe actually wants to go further. Now, as noble lords know, I've been horrified by this wild west of scooters and cyclists, especially speedy electronic versions, dashing through lights, driving routinely on pavements, and spreading terrors amongst mothers with pushchairs, the disabled, the infirm, and sometimes me. I've been knocked over myself. And the truth is, this lawlessness in London has got worse, and the results can be seen in the A&E emissions. However, there is no need to wait for the new Act, as cycling on pavements is illegal. Current laws must be enforced, and I'd ask the Minister to consider a hotspot policy, perhaps by the Transport Police, to crack down on bad behaviour by cyclists and e-scooterists. We know that this sort of enforcement works. When I worked at Downing Street in the 90s, the Met got burglary down with Operation Bumblebee. And more recently, we've seen the success for crackdown on mobile phone thieves at Oxford Circus. My final plea for better enforcement relates to shoplifting, which has also exploded recently. And I know from my time at Tesco how this ruins honest endeavour and allows free riders free rein. It's so difficult for the staff, and there is a wider impact. I remember women putting large jars of Nescafe and beef fillet down their trousers to sell and fund their drug habit. And I remember the drudgery and cost of adding security tags to every valuable item. So the bill rightly responds to Usdor's long-standing campaign and creates a new offence of assaulting a retail worker. Clause 39 seeks to tackle the ridiculous situation whereby so-called low-value theft under £200 tends to go unprosecuted. However, I note that the opposition has concerned about how this is achieved, and we'd also like to see tougher sentences on shoplifting, where there are more than 3 occasions. My Lords, in conclusion, I return to Sir Robert Peel. He not only founded the Met, but gave officers clear guidelines on expected behaviour, so establishing a highly visible and positive relationship with the British people. In this respect, it's time for us to revisit our roots.
My Lords, in seeking to intervene in the gap, my intention is to bring about the minimum of delay as we reach the most important stage of the second reading, namely the winding up speeches. I unhesitatingly begin by entirely endorsing the words of Baroness Levitt, my new noble friend, to whom much welcome, when opening up this debate. Yes, neighbour policing has been neglected. Yes, we need to pay much more attention, for example, to the awful offence of child sexual abuse. But in the steps of Lord Garner, although in rather stronger language, I have to say this bill is a monster. And indeed, I'm holding it in my hand, and I have to put it down because I think it's going to crash any moment. And it's causing all my notes to go in a mess. But in its 422 pages, it seeks, if my arithmetic is correct, no less than 44 previous statutes. And to amend these statutes, going back to the Offences Against the Person Act of 1861 and the Limitation Act of 1980. In some cases, the amendments are extensive. For example, the Proceeds of Crime Act 2002 look at Schedule 16 of the bill and pages 316 to 323, no less than 7 pages of amendments. While we cannot change this, my lord, in this bill, we should be aware of what we're doing. Not only are we imposing upon ourselves in committee doing our job properly, the task of putting in front of ourselves all 44 of these statutes while seeking to amend them. My lords, what about this bill becoming law? How are the police and everybody else involved in enforcement going to cope? When in committee, we must do our duty, however long it takes. Fortunately, my lords, we have my noble friend, Lord Hanson, the nicest of ministers, who's got ever-enduring patience, but he's going to be tried out.
My lords, although this bill is extremely wide-ranging, as has been pointed out, and plainly lacks focus, we've had an interesting and diffuse debate, but we can discern something now of the government's central aims. First, to help halve violence against women and girls. Secondly, to protect children from criminal exploitation and abuse, on which my noble friends Baroness Benjamin, Baroness Hamway and Baroness Featherstone, the noble Lady Baroness Finlay, Baroness Cash and others spoke so compellingly. Then to cut street violence, particularly knife crime, to reduce antisocial behaviour and to increase neighbourhood policing and public confidence in the police. My lords, on these benches we support all these aims. However, as it stands, the bill risks many unforeseen and undesirable consequences. Broadly, we will seek to ensure that the bill does not unjustifiably reduce citizens' rights and liberties, that the bill should not unnecessarily create new or duplicatory offences, that the bill will keep the law up to date with new technology, as my noble friend Lord Clement Jones explained, that the bill will enhance police effectiveness and community confidence and will not increase pressure on the police or local authorities, and generally that the bill will not make managing the criminal justice system more difficult, either by increasing court backlogs or making it harder for courts to handle their workload effectively and justly, or by increasing the prison population when our aim is to reduce reoffending, reverse sentence inflation, and rehabilitate more offenders in the community. My lords, I can only make a few points. The detail will leave to 11 days in the committee, and we may need even more for proper consideration of the many expected amendments, just as Lord Sandhurst predicted. First, though, the protection of citizens' rights, particularly the right to peaceful protest. Whatever our differing views on the horrors in the Middle East, many have been frankly shocked that the Terrorism Act has been deployed as it has, because of the prescription of the Palestine Action Group, whether or not that was sanctioned by the legislation. Many hundreds of protesters face prosecution for offences labelled as terrorist for taking part in protests in an entirely non-violent way. Such prosecutions may prevent them from finding employment or travelling to the States, as my noble friend Baroness Miller pointed out, or indeed the EU when the European Travel Authorisation Scheme is launched next year. These are not groundless scare stories. They are points made by government and senior officers to deter attendance at these protests. So we will be seeking stronger statutory protection for the right of peaceful protest and a review of the threshold for so-called terrorist offences. I am concerned that the Noble Lady Baroness Leavitt's generally very clear and helpful opening, for which I thank her, revealed on these issues a lack of balance in government. The speeches of Baroness Chakrabarti, Lord Cashman, and my noble friends Lord Strasburger and Baroness Miller, and numbers of others, provided a welcome counterweight. We also worry about the indiscriminate use of live facial recognition, as Lord Strasburger explained. While it may have some uses, for example in connection with retail theft, car break-ins, bag snatches and other street crime, I suggest to Lord Mackenzie and others that its use needs careful review and control. Unsafeguarded access to DVLA information or electronic information on which the Noble Lord Anderson of Ipswich spoke present similar risks. So while agreeing with much of what he said, we don't always go along with Lord Hogan Howe's approach to police access to personal information. However, I suggest that the concept of stewarded public interest data trusts, introduced, for example, in Canada, Australia, and Belgium, offer balance on these privacy issues and deserves serious consideration. We must not slide inadvertently, carelessly, or by stealth towards being a surveillance state. Next, the respect order proposals are not risk-free. Although making these orders will be for the courts, applications for them will largely be for our under-resourced police and local authorities. How confident can the government be of their usefulness? Will not the financial and administrative burden of securing these orders, organising their supervision, and then policing and punishing their breach outweigh their effectiveness in reducing crime and antisocial behaviour? Are the procedures robust in respecting citizens' liberties? Before respect orders are made, there must be wide consultation on the guidance and an independent review of existing powers. Then the bill would create many new offences. I started in preparation to count them, but ran out of steam. A number of them duplicate existing offences and will make the criminal law more complicated. As Lord Davison-Gower pointed out, and as the noble and learned Lord Garnier so graphically described, supported by Lord Vesey and Lord Russell of Liverpool and others. Other provisions increase existing penalties. Now, this mixture is generally not helpful. More prosecutions for complex new offences will tend to clog up the courts and exacerbate the appalling backlogs we so desperately need to clear. More and longer prison sentences will do nothing to reduce reoffending or its massive cost to society. We already imprison more people and for longer than other countries in Western Europe. Our prisons are still overcrowded and understaffed, and in many cases dilapidated, often serving more as academies of crime than as centres of reform. We should be reversing sentence inflation, relying on more and better community sentencing and focusing on rehabilitation and training. The sentencing bill will cover these issues, but this bill betrays a lack of coordination across criminal justice issues. While opposing unnecessary new offences, I will relay the amendment I proposed to the Domestic Abuse Bill to criminalise psychotherapists who exercise controlling or coercive behaviour over their patients, often vulnerable young adults. When I moved this amendment in 2021 with all-party support, the noble Lord Kennedy of Southwark, who is now in a stronger position to influence these matters, argued that we had made a powerful case for change, and that he hoped the government would, as he put it, set out a pathway to remedy this undeniably serious problem. I hope to hold this government to his word. Finally, on police effectiveness and public confidence, and on pressure on the police and local authorities, my noble friend Baroness Ducey rightly said that pressure on the police largely comes down to resources, for example, on drug testing and law enforcement. This government, like the last, persistently understates both the shortage of resources for policing and the pressures on the police, which diminish both police effectiveness and public confidence. My Lords, public confidence means community confidence, which requires a genuine commitment to neighbourhood policing, addressed by Baroness Ducey, and to ending racism and hate crime, on which Baroness Lawrence, Lord Cashman and others spoke. We will seek progress on these issues. I add one final point on policing and police resources. The prevalent minimum or zero response to so-called minor crime undermines public confidence. It's said that minimal response is acceptable for crimes that are low level and low value. But just as Lord Burt and Viscount Gushen described, crimes such as bike theft, car break-ins, shop theft, mobile phone watch and bag snatches are committed on an industrial scale. Such offences may often be low value in isolation, but these are not isolated incidents. They are largely the work of multiple repeat offenders and professional gangs. Concerted efforts to ensure they are policed more effectively would do much to restore public confidence in our policing.
My Lords, may I first of all extend my thanks to all noble lords to their contributions to this second reading, but in particular to the noble Lady Baroness Levitt for the clarity of her opening, for which I'm sure we're all grateful. My noble and learned friend Lord Garnier opined quite correctly that passing laws is not a solution. And that reflected an observation from the noble Lord Burt about the plague of everyday crime that already exists. And indeed, it was a point reflected by the noble Lady Baroness Neville Rolfe about the need for neighbourhood policing. It might be observed that in the period from 2010 to 2023, neighbourhood crime in England and Wales fell very substantially. That progress was hard won through local policing, prevention, and firm sentencing, rather than the creation of new laws. But of course, many of the measures in this bill will not be effective if police funding, police numbers, and police priorities are not able to keep pace. The National Police Chiefs Council recently observed that the Lord Chancellor's plan for police funding will result in a shortfall in police funding in England and Wales of £1.2 billion. Perforce, these police forces have had to rely on borrowing in order to achieve the necessary delivery of services. And rather worryingly, it's been estimated that the cost of debt servicing in respect of these liabilities is projected to rise by 50% in the next 3 years. So we're creating a snowball of underfunding. But of course, no additional funding is available to manage the potential increase in the number of offenders coming into our streets as a result of early release or as a result of the reduction in spending in-prison education, all of which is liable to impact and increase recidivism. All that said, of course, we welcome many of the provisions in this bill, and we support many of the provisions. The bill follows the Criminal Justice Bill, which was introduced by the previous government and which fell after the last election. Indeed, about 1/3 of the clauses in the bill are essentially the same as those in the previous bill. Unfortunately, this government has left out much and introduced a watering down of much of the previous bill's intent, and it is that I intend to address. I would begin with those provisions that should have been added back to the bill and which were the subject of proposed amendments in the other place. My Lords, the government claims to be tough on crime, but have consistently resisted amendments in the other place that sought to bolster the bill's provisions. They're reluctant to put into statute more robust sentence guidance, and indeed have rather ducked responsibility by referring repeatedly to their proposals for a review. In particular, the government is unwilling to introduce tougher sentencing in respect of persistent retail crime offenders, a matter that's been addressed by a number of your noble lordships in the context of that being such a social blight in many areas today. In the other place, amendments were proposed to introduce mandatory sentencing for courts dealing with repeat retail crime offenders, and also to introduce the requirement for electronic tagging of repeat offenders. The response from the government in the other place was, and I quote, "sentencing in individual cases is a matter for our independent judiciary," unquote. With the greatest of respect, my Lord, that response is as empty as it is true. My Lords, further, the government will not commit to introducing appropriate penalties to protect farmers and tradespeople, again a point that was touched upon by some of your noble lordships. We moved in the other place an amendment in respect of the Equipment Theft Act to ensure that fines made under that act reflected the cost of replacing equipment stolen from farmers and tradespeople. We also proposed an amendment to the Sentencing Act 2020 to make the theft of tools from tradesmen an aggravating factor. Why aggravating? Well, because of the double loss. The tradesman not only loses his tools, he loses the means to carry on his trade. So I ask the noble Lord the Minister to explain why such provisions will not be the subject of this bill. It does indicate an unwillingness of the government to address these issues head on and to instead talk of a review. Furthermore, the government in the other place would not commit on the maximum penalty for possession of an offensive weapon with intent to commit unlawful violence, despite its manifesto promise to reduce knife crime substantially. The independent reviewer of terrorism legislation, particularly in the wake of the Southport attack, argued that the proposed sentence of 4 years was far too low. And yet, in the other place, the government has resisted a proposal to raise the maximum penalty on such heinous crimes from 4 years to 14 years. The minister said in the other place that it will, and I quote, conduct a review. Lords, further, the government has resisted an amendment to make child murder a standalone aggravating factor in sentencing guidelines. They've once again ceded responsibility to a separate body rather than taking any action. In this instance, they suggest that there should be a review by the Law Commission. My Lords, perhaps the government will then review the reviews. Normally, we expect to find a review being a message that something is going to be placed in the long grass. It does appear to me that so far the long grass is becoming unduly crowded. My Lord, can I move on to some of the more pragmatic options that were recommended in the other place in order to address the issue of crime? It had been proposed that there should be an expansion of police powers of stop and search, but again that was resisted by the government in the other place. Although again, I find this difficult to reconcile with their manifesto promise to crack down on the knife crime epidemic. The amendment proposed to the Criminal Justice and Public Order Act 1984 was to lower the threshold required for stop and search, albeit it would still require perception with regard to violence. And again, I ask the noble Lord the Minister to explain the logic of not embracing that simple step in order to attempt to address the knife crime epidemic. Furthermore, in the other place, the government was presented with 2 pragmatic amendments to crack down on the issue of tipping offences. And that would have involved, first of all, making a third party responsible where there was vicarious liability, imposing a statutory guidance that the cost of removing the fly tipping should be reflected in the penalty, and that in some instances it should be possible to impose driving points on those who engaged in fly tipping. The government's response was to say that they would consult with DEFRA. I thought DEFRA was a part of the government, but it doesn't seem to me that in this instance the government is really willing to face up to the hard need for appropriate penalties in respect to these crimes. And again, I invite the Noble Lord the Minister to explain why the matter should be deferred in that way. Can I turn to the matter of police action and the need for police action? In the other place, an amendment would have required that there should be regular reporting on police presence, on stop and search, and on live facial recognition in areas with the highest levels of serious crime. And I regret that the government should have resisted that, because if the public are meant to have faith in these proposals, it is surely going to be interested in knowing whether or not they're actually working. So again, I would invite consideration of that matter by the government as we go on to committee stage. Turning on to some of the issues around sexual crimes and sexual abuse. This was touched upon by the Noble Lady Baroness Coffey. It was proposed that with regard to the offence of spiking, which is so obviously related to sexual offences, there should be a test of recklessness rather than intent. And when you consider the nature of the crime, it seems perfectly sensible that recklessness should be the appropriate test. The government have argued that adding recklessness to the relevant statutory test would create confusion. And I would welcome the Noble Lord the Minister's explanation as to what confusion he anticipates that simple amendment to the test would actually create. So, my Lords, those are the matters that we must immediately consider for amendment going forward if we're to introduce proper teeth to these proposals. But I wish to address finally one further matter which should be removed by virtue of this bill, and it's been touched upon already by the Noble Lord Young: non-crime hate incidents. They have a chilling effect on free speech. They divert precious police time away from tackling very real crimes. Indeed, it's reported that over 13,000 of these non-crime hate incidents are now being logged each year, consuming an estimated 60,000 hours of police time. And it's time, in my respectful submission, for that to be properly addressed, not by a review, but by a proper consideration of the policy that lies behind this. So we find ourselves in line with the suggestion of the Noble Lord Young that this should be addressed in the bill. My Lords, this bill is intended to be a step forward in addressing crime and policing. Unfortunately, it also risks being 2 steps back. The government should not persistently avoid hard and necessary decisions by deferring to wide, non-specific powers of sentencing or the wish for review after review. We can act now to significantly improve our means to tackle crime and to determine specific policies on punishment, as the original Conservative bill intended. I hope that we can raise the present bill to that necessary standard. The bill has much to commend it, but it has much more to improve.
I'm grateful to the almost 70 speakers in today's debate. And I start by just declaring an interest on my own behalf. I'm a member of the Union of Shop, Distributive and Allied Workers and have been for 46 years, and will obviously have an impact on my view of the measures on shop theft and on the assaults on shop workers. I'm pleased tonight to have the broad support of HMG opposition and indeed the broad support of Liberal Democrat benches with some caveats from both. And I look forward to the noble and learned gentleman's amendments in committee, and I can't give him a response tonight on those details, but we're going to have plenty of time to discuss that. And in saying I've got plenty of time to discuss that, I know that the Lord Russell of Liverpool, Baroness Browning, Baroness Foxton of Buckley and others mentioned the length of time and the size of the bill. Indeed, my noble friend Lord Hacking did as well. We will have time to do that, and it will be discussed through the usual channels. And I look forward to full and frank debate on this matter in due course. The bill deals with a number of key issues, and members have said about a theme in the bill. There are several themes in this bill: making our communities safe, strengthening child sexual abuse prevention, tackling antisocial behaviour and knife crime, and, dare I say it, supporting free speech, whilst at the same time ensuring that we have some measures on protest. Now, the noble Lord Garnier, Lord Frost, Lord Vasey, and indeed my noble friend Lord Hacking, in their comments have said that there's a mixture of this bill. It doesn't have a theme, it's very large. It is a government programme, much of it based on a manifesto commitment. And as my noble friend Baroness Levitt mentioned in her excellent maiden speech from this front bench on a second reading debate, it is a manifesto commitment from the government to do most of the things in this bill, and therefore we are going to do most of the things in this bill with the support of this House and the House of Commons. A lot of issues in the debate have gone around legislative proposals, certainly, but we've touched on neighbourhood policing, on courts, on speeding, on police presence, on speeding of justice and police numbers, etc. My noble friend Lord Mackenzie of Framwell Gate mentioned that, and indeed the noble Viscount Goshen and Lord Sandhurst talked about delivery, extremely important. Those things aren't in the bill, but they're extremely important matters that are before us today. So I just want to concentrate, if I may, on what is actually in the bill and the points that have been debated by noble lords today. Let me start with respect orders and youth diversion orders, which was raised by the Earl of Lytton, Lord Davis of Gower, Lord Anderson of Ipswich and Baroness Kidron. Respect orders are a substantial new power which give us police and authorities effective levers to deal with antisocial behaviour. And I know Baroness Fox of Buckley had some criticism of them, and I know indeed Lord Marks has got some challenge for them as well. But we believe them to be an effective tool, and we'll have a chance to debate that in due course in this committee. The youth diversion orders, I think, are an important matter. Again, the noble Lord Anderson of Ipswich will come back to that, but it's designed to help prevent terrorism and prevent people drifting into terrorism, so I think it's an important measure. Members have talked about shop theft, and I've had now Baroness Ducey, Baroness Stoll, Lord Herbert, Baroness Hazarika, the noble Lord Sandhurst and the noble Lord Davis of Gower and Baroness Neville Rolfe have all raised that issue. Shop theft is extremely important. It's something we shouldn't tolerate. That's why we're removing the £200 threshold. That's why we're putting a focus on it with policing. That's why we've encouraged police forces to tackle it. And the measures that we're removing, I think, will send a signal. It's still for judicial discretion, but it will send a very strong signal, as will the issues of mobile phone theft, with giving tracking powers for officers to be able to visit a premise straight away. So I think they're I look forward to debating them, but I think they're important measures to take action on that. The issue closest to my heart, I have to say, in this bill is the issue of retail workers and attacks on retail workers. And again, Baroness Stoll, Baroness Ducey, my noble friend Lord Hannett of Everton, Baroness Thornton, and Baroness Browning, and indeed Baroness Fox have contributed to the debate around that. This is a long-standing campaign, which is why I declare my membership of USDOR. I've moved amendments when in the House of Commons on this issue over many years, and I appreciate very much the support of my noble friend Lord Hannett of Everton and the members of USDOR, along with the businesses, the Co-op, Tesco's, Sainsbury's and others who have raised this issue. The new offence will ensure that we put on an obligation to ensure that those who uphold the law, which is what colleagues do in shops on solvent abuse, cigarette sales and alcohol, are also protected by the law. And I hope that will have good support as a whole. There's been a lot of debate around civil liberties. Baroness Jones of Mulscombe, Baroness Chakrabarti, the Right Reverend Prelate, the Bishop of...
Grateful to the Noble for giving way, but before he moves on, I wondered if you could just respond to my question, which was why has the government decided only to legislate for those group of workers?
The argument I will put to the Noble Baroness now is that shop workers are upholding the law on solvent abuse, alcohol, cigarette sales and other things. There will be representations, I know, on other areas, and we will have to examine those representations. But I want to, after a long campaign, get this over the line. Really do want to get this over the line. And I hope that she will support those measures, whatever amendments she pretends she may well bring forward accordingly. There's been considerable debate around civil liberties from Baroness Jones of Mulscombe, Baroness Chakrabarti, Right Reverend Prelate, the Bishop of Derby, Baroness Ducey, Lord Strasburger and others. We are making some changes and we will bring some further changes forward, but the principle of all this, including comments from my noble friend Baroness Cashman and Baroness Miller of Chilthorne Domer, the principle of this is that we are trying to ensure that we do have freedom of speech, we do have the right to protest, but we also have the right to ensure that protest is managed in an effective way, and that there are responsibilities in protest as well as the right to protest. We have also looked at the question of the Vacancy Act, and the Noble Lord Davis of Gower mentioned that particularly, and the government has been clear that no one should be criminalised, which is why we're repealing the outdated 1824 Act. And we will be examining and committed to repeal of the Vacancy Act once a replacement can be determined. So I hope that clarifies that for him. The Noble Lord Hogan Howe, amongst many other issues I'll come back to in a moment, raised suicide of policing, and again we're working closely with the National Policing Wellbeing Service to examine on that. There has been a major debate from noble lords and noble ladies around the question of child exploitation and child sexual abuse and the ICSA implementation. Baroness Gray-Thompson, Baroness Hanway, Right Reverend Prelate of Derby, Baroness Royal, Baroness Benjamin and Baroness Kidron, the Lord Hampton, Lord Folkes, the Earl of Lytton, Baroness Cash, and others, Baroness Finlay of Llandaff, have all raised and discussed that issue. We're going to have a big debate on this. We just think we're trying to meet the recommendations of the ICSA recommendations. The Noble Baroness Gray-Thompson's Private Members Bill stretches us a bit further. We're going to have a discussion around that. But I hope this bill, at the end of its process in this House, will have achieved an improvement in child protection services as a whole. We've also had a discussion around the big issue of abortion, and many noble members have raised that. Baroness Spielman, Baroness O'Lone, Baroness Coffey, Lord Elliot of Micklefell, Baroness Matteson, Baroness Hazarika, Baroness Thornton, Baroness Lawler, Lord Jackson, Lord Frost, Viscount Hailsham, Lord Farmer, Baroness Monkton, and also Lord Hampton. They've all raised that issue, and I just have to say to them now, there are different pressures on that. Some want that provision taking out, some want it maintaining. The government will remain neutral on this matter and will facilitate whatever the Parliament agrees in the end, and we will look at those issues whatever Parliament settles on in the end, and the government will have a free vote on that matter as a whole. The issue of police misconduct and police vetting has been raised very strongly. Baroness Lawrence, my noble friend, Lord Mackenzie, and others have raised that issue, and particularly in the light of the Panorama investigation we touched on in question time today. There are a number of measures in the bill to support strengthening police vetting, and I very much welcome those and hope they will be looked at positively in the future. The issue of knife crime was mentioned by the Noble Lord Hampton, by Noble Lord Clement Jones, by my noble friend Baroness Lawrence, and by the Noble Lord Burt. And again, the measures in the bill are designed to to regulate the supply of knives by people who wish to use those knives in a way which is not conducive to good behaviour and which causes death, misery and injury. And we have to take those actions, and I think it's important that we do so. And there's been a lot of discussion, again, around the issue of hate crime. And I want to touch, first of all, on the issue that was raised by my noble friend Baroness Donaghy, by Baroness Thornton, by Baroness Hunt of Bethnal Green, and by my noble friend Lord Cashman, which is the question of the aggravated offence. It is a Labour manifesto commitment at the general election. We are carefully considering now how best to amend the law to ensure the protected characteristics have that fairness, and we will set out our conclusions later during the passage of the bill. But that commitment has been given, and we will examine that in due course. But that leads me on to the question, which is again a live issue for noble lords, which is about the issue of non-crime hate incidents. The noble Lord Herbert has indicated very strongly what has happened in relation to the National Police Chiefs Council, and I'm grateful to him for the support he's done in giving the review on this matter. We've had certainly discussions from Lord Frost and from other lords, including the noble Lord Young recently, and others in the committee in the House, at the second reading, about this matter. And we're going to have a debate about it, but I'm hoping that the review that the noble Lord Herbert has instigated will help colour whatever amendments are brought forward. And the noble Lord Moynihan has mentioned that as well, and I think it's important that we have that debate and discussion, but I want to have it influenced by the review from the Police Chiefs Council if noble lords think that is appropriate to do so. A number of noble lords have mentioned the pornography review, and I'm grateful to Baroness Burton particularly for the work that she has done on that. Yeah. Baroness Owen of Alderley Edge, Baroness Shawcross Wolfson, Baroness Kidron, Baroness Sugg, Lord Vasey, and my noble friend Baroness Donaghy have all discussed and made contributions today on the pornography review. We are committed to taking any necessary action following consideration of the noble Baroness's recommendations. We've committed to criminalising pornography that depicts acts of strangulation and suffocation in this bill, and we'll be bringing forward an amendment to that effect. And where we can, in relation to the recommendations of the noble Baroness's report, we will be taking early action to undertake that as a whole. The noble Baroness Sugg mentioned honour-based abuse, and I'm grateful again to her for I'm looking at you. The noble Baroness was there when we started. She's now moved over there. The noble Baroness Lady Sugg called for a statutory definition of so-called honour-based abuse, supported by Baroness Cash. And I can say to her that we're going to work closely with the honour-based abuse sector to develop that statutory definition. We've given that commitment, and I agree it's vital that all professionals with safeguarding responsibilities have the right framework to identify victims and perpetrators, and I will be again looking at that during the course of this bill. Baroness Owen of Alderley Edge mentioned spiking. It's an important measure, and again I will reflect on the points that she's made in this discussion, and I was pleased for the welcome by the noble Lord McCall of Dulwich for the measures on cuckolding and the cuckooing that we have, not cuckolding, cuckooing. Sorry. It's been a long day in committee. It's been a long day in the chamber today. I've spent, apart from a very quick 20-second call of nature, I've been in for the whole day, so it's been a long day. For the offence of cuckooing, I'm grateful for his support on that measure as a whole. Now, we've also had a range of new ideas for the bill, and I look forward, honestly, to developing and arguing and having a discussion around the amendments during the passage of the bill. I just say at the start, I'm happy to meet any members, if I can, who are going to raise those issues. I've got firearms and cycling from the noble Lord Hogan Howe. I've got historical weapons, which has been raised by Lord Hogan Howe. I know Lord Lucas takes an interest in that. I've had measures on child abuse from Baroness Hazarika and Lord Folkes. I've got the transport issues from the noble Earl Attlee. I've got deceased children from Baroness Kidron and the chat box issues. I've got new proposals on cyber digital from Lord Clement Jones. I've got Lord Walney raising a number of issues to do with the terrorism review. I've got universal jurisdiction from my noble friend Baroness Kennedy of the Shores. I've got the cumulative impact issues from Lord Walney. I've got facial recognition from Lord Strasburger. I've got vehicle non-compliance from the noble Lord Lucas. I've got fraud from Lord Cromwell, from Lord Burt, from Baroness Ducey and from Baroness Coffey. On all of those things, I'm happy to meet and discuss. Let us look at what is tabled, let us look at what is put down, and the government will reflect on it. We may disagree at the end, but let's have that discussion as a whole. On the fraud issue, though, however, from the noble Lord Cromwell in particular, I am the government's first fraud minister, and I am producing at the moment, anti-fraud minister really, but it's called fraud minister for the purposes of the discussion here today. I have a challenge from the government to produce a new fraud strategy. We're in the process of working on that, and by January, February of next year, there will be a 3-year fraud strategy produced, which will cover some of the points that the noble Lord Cromwell, Burt and others are mentioning to date. I know also that the issues of facial recognition for Baroness Jones of Milscombe and Lord Strasburg and for the noble Baroness Ducey are important, and I want to ensure that we examine those. I've also had representations made by colleagues today, including the Lord Russell of Liverpool, Lady Royal of Blaisdon and others, around the stalking measures in the bill, and I hope that they will welcome those, but we'll have a debate around that in due course. My noble friend Lady Whittaker has argued for the repeal of the provisions on encampments in Part 4 of the police bill. We're aware of the High Court ruling, and we're aware of the points that have been made there, and we're going to consider how best to respond to that in due course, and we will do so. Lord Farmer has mentioned again issues to do with the recording of offences, of intimate images. I'm not sure we're going to agree on some of these issues, but at least I look forward to the amendments in due course if they're brought forward. Sorry, Lord Farmer. I look forward to the amendments in due course if they're brought forward. I also just want to note that Baroness Featherstone's points as well I will reflect upon, and we will look at those in due course. This is indeed a very large bill. The noble Lord Keane and learned Lord Keane mentioned also the Equipment Theft Prevention Act and the implementation of that for farmers. We're looking now at when we can implement that, and we're trying to bring the necessary regulations later this year, so I can give him the answer and support on that. I think I've covered, although it's very rushed, every point by every member who has spoken in the debate today. I may not have satisfied every member, but I hope I've recognised.
Terrific to-do list, and I congratulate you on a spectacular summation. The one thing that hasn't really been touched on, which I think we all almost spoke about, is resources. How are we going to pay for it?
Again, the bill itself covers a range of legislative options on a range of matters. There is, in parallel to that, 2 other aspects of work. We are to produce a policing white paper very shortly, which looks at how we can improve efficiencies, look at some of the issues in policing, and with the Police Chiefs Council and colleagues and Police and Crime Commissioners, look at how we can improve and get better value and better focus on policing, on the key issues that members have talked about today. Because the very points that Viscount Goshen mentioned, the very points that others have mentioned about delivery and about use of resources, about focus, and about saying that what do the police do on particular issues is extremely important. And it's absolutely vital that we do focus the police on government priorities. Now, aside to the police white paper, we've also got issues to do with police funding and police budgets. We have actually given £1.2 billion extra this year to policing. There is a challenging settlement that's going to mean that it's going to be challenging, but our job is to get better value out of that and to make sure that, I think there's commonality between all of us in the chamber today, that the issues that matter to people are antisocial behaviour, shop theft, violence against women and girls, child sexual abuse, and although there are many, many policing priorities, those are things that this legislation is dealing with. And therefore, we're hoping that the resources will follow the legislation and the focus will follow the legislation. And the work we've done on already on putting an extra 3,000 neighbourhood police on the ground now and focusing on neighbourhood policing means that over the next 2 to 3 years we're trying to increase the number of forward-facing neighbourhood police officers on the ground. Nobody expects that there's not going to be a challenge in all of this, but the purpose of this bill is to give legislative framework to government manifesto commitments. I think it meets a number of really important objectives. There will be debate between members, there will be differences, there will be votes, there will be not a meeting of minds on certain issues, but I'm hopeful that when this process is over, this bill will pass, it will be put into effect, and members of this House and the House of Commons will hold the Home Office to account for making sure that we reduce crime, increase confidence in policing, and make sure that there are fewer victims in the future. And I commend the bill and beg to move it to the House tonight.
My Lords, the question is that this bill be now read a second time. As many of that opinion will say content. The contrary not content. The contents have it.
I beg to move the commitment motion standing in my name on the order paper.
The question is that the motion be agreed. As many of that opinion will say content. The contrary not content. The contents have it.
My Lords, I beg to move the House do now adjourn.
That the House do now adjourn.